I'm waiting for a very important member of the committee to arrive before we start.
That's not me.
Welcome back, Judge Gorsuch. Glad to have you back, and I'm sure you're glad to be here. Good morning, everybody. I'd like to welcome everyone, and especially our nominee, as I just did. This is day 2 of the Supreme Court nominees hearing. We have a long day in front of us, so we'll immediately turn to members' questions. It's my intention to get through all members' first round of questions today, so it's important that we all stick to our time limits so that we can stay on that schedule. I realize that 10 hours is a long time for you to sit there and answer questions for 20 of us, so I'm going to defer to you when you might need a break. In the meantime, I would anticipate a break about 30 minutes for lunchtime, and I hope for the members of the committee. I have not made up my mind on this yet, but we do have a vote scheduled at noon, and it might, I'm sorry. Okay, we have 2 votes at noon, so it might be appropriate to use that period of time for our lunch break. I'll make a decision on that later on. So with that understanding with you and to accommodate you, because you're the person that has to sit there and answer questions, and so whatever your needs are, you let us know. I started yesterday morning, Judge and audience, with Justice Scalia's comments that our government of laws and not men is the pride of our constitutional democracy. Our democracy requires judges to let the people's elected representatives do the lawmaking. You, Judge, said that Justice Scalia's great accomplishment was to, quote you, remind us of the differences between judges and legislators, end of quote. Legislators, in other words, consult their own moral convictions to shape law as we best think it to be. But you said that judges can't do those things, rightly so from my point of view. Our Constitution is also a charter of liberty. Justice Scalia said that our Constitution guarantees our liberties primarily through its structure. That happens to be the separation of powers. You've said, Judge, that said much the same thing, and I quote you, what would happen to disfavored groups and individuals, end of quote, if we allowed judges to act like legislators? Quote, the judge would need only want his own vote to revise the law willy-nilly in accordance with preferences, end of quote. The separation of powers in our system requires an independent judiciary made of judges respectful of the other two branches, but not beholden to them. Judges must be equally independent of the president who nominates them and us senators who confirm the same judiciary members. Let's start with independence from the executive. No one, not even the president, is above the law. One of the most remarkable things about your nomination is the broad bipartisan support that you've received. You've earned great praise from individuals who aren't exactly supporters of the president, but who strongly supported your nomination. Yesterday, we heard from one of them, Neil Gorsuch. President Obama's former Solicitor General said that you, quote, will not compromise principle to favor the president. In 2006, former Colorado Senator Salazar, a Democrat, said that you have, quote, the sense of fairness and impartiality that is a keystone of being a judge, end of quote. And legal commentator Jeffrey Rosen, similar, praised you for your independence. So let's start with my first question. I'd like to have you describe in any way you want to what judicial independence means, and specifically tell us whether you'd have any trouble ruling against a president who appointed you.
That's a softball, Mr. Chairman.
Turn your microphone on.
I'm sorry. So that's a softball, Mr. Chairman.
Okay.
I have no difficulty ruling against or for any party other than based on what the law and the facts in the particular case require. And I'm heartened by the support I have received from people who recognize that there's no such thing as a Republican judge or a Democratic judge. We just have judges in this country. When I think of what judicial independence means, I think of Byron White. That's who I think of. I think of his fierce, rugged independence. He said, I have a job. People asked him what his judicial philosophy was. I give the same answer. I decide cases. It's a pretty good philosophy for a judge. I listen to the arguments made. I read the briefs that are put to me. I listen to my colleagues carefully. And I listen to the lawyers in the well. And this experience has reminded me what it's like to be a lawyer in the well. It's a lot easier to ask the questions, I find, as a judge than it is to have all the answers as the lawyer in the well. So I take the process, the judicial process, very seriously. And I go through it step by step, and keeping an open mind through the entire process as best I humanly can. And I leave all the other stuff at home. And I make a decision based on the facts and the law. Those are some of the things judicial independence means to me. It means to me the judicial oath that I took to administer justice without respect to persons, to do equal right to the poor and the rich, and to discharge impartially the duties of my office. It's a beautiful oath. It's a statutory oath written by this body. That's what judicial independence means to me. Happy to talk about the separation of powers, too, if you'd like, Mr. Chairman, which you referenced in there, or I'm happy to answer another question, entirely up to you.
Well, your record made clear that you aren't afraid to fulfill your role independently, and you just emphasized that. You vacated orders of administrative agencies acting outside their authority, and you ruled on cases where Congress has overstepped its bounds. So I think you can maybe speak about the separation of powers, but at the same time, maybe you could give me a couple of your cases that demonstrate your commitment to that independence of the executive branch of government.
Sure. On the first point, I have decided, as I noted yesterday, over 2,700 cases. And my law clerks tell me that 97% of them have been unanimous. 99% I've been in the majority. They tell me as well that according to the Congressional Research Service, my opinions have attracted the fewest number of dissents from my colleagues of anyone I've served with that they studied over the last 10 years. Now, the Congressional Research Service speculates whether that's because I'm persuasive or I believe in collegiality. I don't see why it has to be a choice. My law clerks also tell me that in the few cases where I have dissented, that I'm as likely almost to dissent from a Democrat-appointed colleague as a Republican-appointed colleague. And that's, again, because we don't have Democrat or Republican judges. According to the Wall Street Journal, I'm told that of the 8 cases that they have identified that I've sat on that have been reviewed by the United States Supreme Court, our court was affirmed in 7 of them. Now, I think Louise might argue for the 8th.
Okay.
Because in that case, the Supreme Court didn't like a procedural precedent of our court that, as a panel, we were bound to follow. So they remanded it back. We decided on the merits, as the court instructed. Cert denied. 8 out of 8. On the separation of powers, it is, Mr. Chairman, the genius of the Constitution. Madison thought that the separation of powers was perhaps the most important liberty-guaranteeing device in the whole Constitution. And this is a point of civics that I do think maybe is lost today, how valuable the separation of powers is. That you have, in Article 1, the people's representatives make the law. That's your job. And I don't think it's an accident that the framers put Article 1 first. Your job comes first. You make the law. Article 2, the president's job is to faithfully execute your laws. And our job, Article 3, down at the bottom, is to make sure that the cases and controversies of the people are fairly decided. And if those roles were confused and power amalgamated, founders worried that that would be the very definition of tyranny. And you can see why. Judges would make pretty rotten legislators. We're life tenured, right? You can't get rid of us. It only takes a couple of us to make a decision, or 9, or 12, depending on the court. That'd be a pretty poor way to run a democracy. And at the same time, with respect, legislators might not make great judges because they're answerable to the people. And when you come to court with a case or a controversy about a past facts, you want a neutral, rigidly neutral, fair, scrupulously fair decision maker. You want somebody who's going to put politics aside. So the separation of powers, I don't think has lost any of its genius over 200 years. In fact, it's proven it.
Thank you. I've heard my colleagues and people not in the Senate say that now more than ever, we need a justice who will be independent of the president who nominated him or her. So I'd like to ask about your nomination and your independence. A lot has been made about the list of judges then candidate Trump proposed as possible nominees. To me, it was the most transparent that we've had in history, and we didn't have Secretary Clinton give out such a list. Of course, you weren't on the first group that came out, and otherwise added later. So I'm curious, when did you first learn that you were on candidate Trump's extended list?
Well, Mr. Chairman, you're right. There were 2 lists, as I recall, over the summer. And I wasn't on the first list. And I remember having breakfast one day with a friend who may be here, Brian, There you are. You remember this. We were having breakfast one day, and he said, "Neil, you're not on the list." And I said, I'm fine. You're right, I'm not on the list. He said, "You should be on the list." And I said, "I love my life in Colorado. I wouldn't change a thing. I'm a happy man. I have a loving wife, a beautiful home and children, a great job with wonderful colleagues. I'm a happy person." We're walking away from breakfast, and I get an email from Brian saying there's a new list, and you're on it. That was the first I heard of it.
And I assumed you thanked him.
I don't know about that. I don't think he. You didn't know. I don't think we were all surprised.
I'm kidding.
And at any rate, we are where we are.
Okay. Tell me about the process that led to your nomination. Did anyone ask you to make any promises or assurances at all about your view on certain legal issues or the way that you'd rule in certain cases?
Senator, I think you'd be reassured by the process that unfolded. I tried to live under a shell during the campaign season, watch baseball and football, go about my business. But I did hear lots of talk of litmus tests from all around. It was in the air. And I don't believe in litmus tests for judges. I've written about that years ago. I wasn't about to become party to such a thing. And I am here to report that you should be reassured, because no one in the process, from the time I was contacted, was an expression of interest for a potential interview, to the time I was nominated. No one in that process, Mr. Chairman, asked me for any commitments, any kind of promises about how I'd rule in any kind of case.
And that's the way it should be. So we've just discussed your independence from the president, but there's also independence from the legislative branch. It's odd that some of the same folks who will claim that you're not independent from the president will turn around and try to extract from you promises and commitments before they pass judgment on your nomination. The irony, of course, is that extracting commitments during the confirmation process is exactly what would undermine your independence as a judge. One way that they'll do this is asking you about precedent. So let's talk about that. For starters, I've got a book here that you co-wrote, an 800-page book on precedent. Your 12 co-authors included judges from across the ideological spectrum, such as Bill Pryor, who was also on President Trump's Supreme Court list, and Diane Wood, who was reportedly on President Obama's list. You've also touched on the value of precedent in speeches that you've given or in your opinions. For instance, in the speech you gave honoring Justice Scalia last year, you said this, quote, "Even when a hard case does arrive, once it's decided, it takes on the force of precedent, becomes an easy case in the future, and contributes further to the determinacy of our law," end of quote, especially if more recent opinions have called into question the rationale of the original case. But you've also suggested that there may be circumstances where it's appropriate to revisit precedent. Specifically, you wrote that it may be appropriate to reconsider a decision where it has become a, quote, precedential island surrounded by a sea of contrary law, end of quote. So there may be times where it is appropriate to reconsider certain decisions, especially if more recent opinions have called into question the rationale of the original decision. I think all of us would agree, for instance, that Brown versus Board of Education, which finally overruled a repugnant, separate but equal standard in Plessy, is the textbook example of this. So with these things in mind, I'd like to explore the approach that you take to Supreme Court precedents. Could you tell us what you believe is the value of precedent in our legal system?
Absolutely, Senator. And if I might, Mr. Chairman, go back just a moment to promises. I have offered no promises on how I'd rule in any case to anyone, and I don't think it's appropriate for a judge to do so, no matter who's doing the asking. And I don't because everybody wants a fair judge to come to their case with an open mind and to decide on the facts and the law. One of the facts and one of the features of law that you have to decide it on is on the basis of precedent, as you point out. And for a judge, precedent is a very important thing. We don't go reinvent the wheel every day. And that's the equivalent point of the law of precedent. And we have an entire law about precedent, the law of judicial precedent. Precedent about precedent, if you will. And that's what that 800-page book's about. It expresses a mainstream consensus view of 12 judges from around the country appointed by, as you point out, presidents of both parties, great minds. Justice Breyer was kind enough to write a foreword to it. It makes an excellent doorstop. And in it, we talk about the factors that go into analyzing precedent, any consideration of precedent. There are a bunch of them. You've alluded to some of them. The age of the precedent, very important factor. The reliance interests that have built up around the precedent. Has it been reaffirmed over the years? What about the doctrine around it? Has it built up, shored up, or has it become an island, as you point out? Those are all relevant considerations. Its workability is a consideration, too. Can people figure out how to abide it? Or is it just too confusing for the lower courts and their administration? Those are all factors that a good judge will take into consideration when examining any precedent. You start with a heavy, heavy presumption in favor of precedent in our system. Alexander Hamilton said that's one important feature, I think it was Hamilton, said one important feature of judges. If we're going to give them life tenure and allow them that extraordinary privilege, they should be bound down by strict rules and precedents. Francis Bacon called precedent the anchor of the law. So you start with that heavy presumption in favor of precedent. You consider those factors in that light. And yes, in a very few cases, you may overrule precedent. It's not an inexorable command, the Supreme Court has said. That's the law of precedent, as I understand it, and I believe is expressed in that book with my very highly respected colleagues.
As a lower court judge, you're bound by not only Supreme Court precedent, but as you've demonstrated, the precedent of your own court. But as a Supreme Court justice, part of your job will be to decide when existing Supreme Court precedent need not be reconsidered. How will you decide when you revisit existing precedent?
Mr. Chairman, I don't think the considerations change. It's the same analysis that I would have as a Supreme Court justice, if I'm fortunate enough to be confirmed, that I have when I'm considering circuit precedent as a circuit judge. It's the exact same process. The exact same rules apply.
Okay. This is the 14th Supreme Court hearing that I participated in, so I have a pretty good idea of some of the questions that you're going to get today. You're going to be asked to make promises and commitments about how you'll rule on particular issues. Now, they won't necessarily ask you that directly. For instance, how will you rule on this issue or that issue? Instead, they'll probably ask you about old cases, whether they were correctly decided. Of course, that's another way of asking the very same question. They know that you can't answer, but they're going to ask you anyway. I've heard justices nominated by presidents of both parties decline to answer questions like these. That's because, as the nominee put it, quote, a judge sworn to decide impartially can offer no forecasts, no hints for that would show not only disregard for the specifics of this particular case, it would display disdain for the entire judicial process, end of quote. Now, you probably know that's what Justice Ginsburg said at her hearing, and it's what we call the Ginsburg standard. The underlying reason for this is, of course, is that making promises or even giving hints undermines the very independence that we just talked about. I'd like to ask you if you agree with what I just said.
I do, Mr. Chairman.
So let me ask you about a couple of Supreme Court cases. In Heller, the Supreme Court held that the Second Amendment protects an individual right to bear arms. If I ask you to tell me whether Heller was rightly decided, could you answer that question for me?
Senator, I'd respectfully respond that it is a precedent of the United States Supreme Court. And as a good judge, you don't approach that question anew as if it had never been decided. That would be a wrong way to approach it. My personal views, I'd also tell you, Mr. Chairman, belong over here. I leave those at home. Mr. Kochel yesterday said that what he wants is a fair judge. And that's what I wanted as a lawyer. I just wanted a judge to come in and decide on the facts and the law of my client's case and leave what he had for breakfast at the breakfast table. And part of being a good judge is coming in and taking precedent as it stands. And your personal views about the precedent have absolutely nothing to do with the good job of a judge.
Let me ask you about Citizens United. In this case, the Supreme Court held that the government can't restrict independent political expenditure by a nonprofit corporation. Do you agree with that decision?
And Senator, I'd give you the same response. I know people have their views personally about lots of Supreme Court decisions and about a lot of other things. We're all human beings. I get that. I'm not an algorithm. They haven't yet replaced judges with algorithms, though I think eBay's trying, and maybe successfully. We're all human beings, but the judge's job is to put that stuff aside and approach the law as you find it. And that's part of the precedent of the United States Supreme Court that I'm sworn as a sitting judge to give the full weight and respect to due precedent.
Those two cases were 5-4 decisions. So let me ask you about something that was unanimous, Hosanna, Tabor. The Supreme Court ruled 9-0 that the Obama administration couldn't tell a church who its ministers can be. The only thing controversial about that case was that the Obama administration actually tried to convince the Supreme Court that a bunch of government bureaucrats could tell a church who its ministers could be. Like I said, that case was 9-0. Can you tell me if that case was decided correctly?
Respectfully, Senator, I give you the same answer.
Okay. Those are relatively recent cases. Let's talk about cases that's been around for a while. Let's look at Gideon Wainwright. It was decided unanimously a long time ago, 50 years or more. It says a criminal defendant has the right to an appointed attorney if he can't afford one. Everyone who watches cop TV shows know that this law. Does that make a difference? Can you tell me if you agree with the principle of Gideon? Is it the same answer, the same reason?
Mr. Chairman, it's certainly a seminal decision of the United States Supreme Court. There's no doubt about it. It's a very old decision of the Supreme Court now. It's been reaffirmed many times. There's a lot of reliance interest built around it. So I could talk to you about the factors that a good judge considers in analyzing precedent and the weight due a precedent. But I'm not in a position to tell you whether I personally like or dislike any precedent. That's not relevant to my job. Gideon is a seminal precedent of the United States Supreme Court, and it deserves respect on that basis. Precedent is kind of like our shared family history as judges. It deserves our respect because it represents our collective wisdom And to come in and think that just because I'm new or the latest thing and know better than everybody who comes before me would be an act of hubris, inappropriate to the judicial role.
What if I ask you about Bush versus Gore?
I know some people in this room have some opinions on that, I'm sure, Senator, but as a judge, it's a precedent of the United States Supreme Court. And it deserves the same respect as other precedents of the United States Supreme Court when you're coming to it as a judge. And it has to be analyzed under the law of precedent.
Well, let's go to a kind of a more controversial issue, but along the same lines I've been asking you. I think the case that most people are thinking about right now, and the case that every nominee gets asked about, Roe v. Wade, can you tell me whether Roe was decided correctly?
Senator, again, I would tell you that Roe versus Wade, decided in 1973, is a precedent of the United States Supreme Court. It has been reaffirmed. The reliance interest considerations are important there. And all of the other factors that go into analyzing precedent have to be considered. It is a precedent of the United States Supreme Court. It was reaffirmed in Casey in 1992 and in several other cases. So a good judge will consider it as precedent of the United States Supreme Court, worthy as treatment of precedent like any other.
What about Griswold, which was decided a few years before Roe, the case where the court found constitutional right to privacy? Can you tell me your views on Griswold?
Senator, it's a precedent that's now 50 years old. Griswold involved the right of married couples to use contraceptive devices in the privacy of their own home. It's 50 years old. The reliance interests are obvious. It's been repeatedly reaffirmed. All very important factors, again, in analyzing precedent.
Well, I think I'm going to stop questioning, but I'd kind of sum up what you and I just talked about in regard to precedent, so everybody understands the principles that are at stake here. There are two reasons why you can't give your opinion on these cases. One, I believe, is independence, and the other one is fairness to future litigants. Is that the way you see it?
It is, Senator. If I were to start telling you which are my favorite precedents or which are my least favorite precedents, or if I viewed precedent in that fashion, I would be tipping my hand and suggesting to litigants that I've already made up my mind about their cases. That's not a fair judge. I didn't want that kind of judge when I was a lawyer, and I don't want to be that kind of judge now. And I made a vow to myself I wouldn't be. That's the fairness problem. And then the independence problem. If it looks like I'm giving hints or previews or intimations about how I might rule, I think that's the beginning of the end of the independent judiciary. If judges have to make effectively campaign promises for confirmation. And respectfully, Senator, I haven't done that in this process, and I'm not about to start.
Thank you. I'll yield back 8 seconds. Senator Feinstein.
Thank you very much, Mr. Chair. Welcome, Judge, and good morning.
Good morning,
Good to
Senator.
see you again. Since we're on Roe, I wasn't going to begin with this, but I well recall the time we spent in my office, and we talked about precedent, and in my opening remarks, I indicated that if anything had super precedent, Roe did in terms of the numbers, and I've put that in the record. Here's why it becomes of concern. The president said that he would appoint someone who would overturn Roe. You pointed out to me that you viewed precedent in a serious way in that it added stability to the law. Could you elaborate on the point that you made in my office on that?
I'd be delighted to, Senator. Part of the value of precedent, it has lots of value. It has value in and of itself because it's our history. And our history has value intrinsically. but it also has an instrumental value in this sense. It adds to the determinacy of law. We have lots of tools that allow us to narrow the realm of admissible dispute between parties so that people can anticipate and organize their affairs. It's part of the reason why the rule of law in this country works so well. We have statutes, we have rules, we have a fact-finding process and a judicial system that's the envy of the world. And precedent is a key part of that because, as the chairman pointed out when he quoted a piece of mine, once a case is settled, that adds to the determinacy of the law. What was once a hotly contested issue is no longer a hotly contested issue. We move forward. And Senator, the value of that is the United States Supreme Court takes something like 70 or 80 cases a year. That is a tiny fraction of all the disputes in our federal legal system, right?
Right.
My law clerks tell me it's something like 0.001%. And they're unanimous in those cases which have divided circuit judges. That's why the Supreme Court largely takes the case, because it's divided us. It's one of the rare cases where we disagree. They're unanimous 40% of the time.
One other question.
Sure.
Do you view Roe as having super precedent?
Well, Senator, a super precedent is
In numbers, 44.
It has been reaffirmed many times. I can say
Yes.
that. Yes.
Yes, dozens.
Yeah.
All right. I would like now to take you back to 2005, when you were in the Justice Department, and I want to explain to you why I'm going here. This has to do with torture. The Intelligence Committee was informed in 2006, and Attorney General Gonzalez played a role in this, of the nature of the enhanced interrogation techniques, and we were given a very soft view. Senator Rockefeller became chairman of the committee in 2007 and began a study of 3 detainees and the enhanced interrogation techniques. When I became chairman in 2009, I added that, and we took all of the major detainees and looked at them in a 6-year study. The staff spent long hours analyzing every cable, every email, looking at more than 100 interviews, and essentially putting in a 7,000-page report, 32,000 footnotes, documenting where the information, there are no conclusions, they're just facts. That 7,000-page report has remained classified. I have read it. We have put out a 450-page summary, which is public. And in that summary, we indicate that those cases that the administration spelled out where torture produced operable intelligence was simply not so. We elaborate on that in the big report, and my hope is that one day, not too distant, that report will be declassified so the American people can actually see. But I wanted to ask you some questions along these lines. It's my understanding that the set of talking points were prepared for a press conference for the Attorney General on November 22nd, 2005. The talking points ask whether, and I quote, aggressive interrogation techniques employed by the administration yielded any valuable information, end quote. And in the margin next to this question, you handwrote one word, yes. What information did you have that the Bush administration's aggressive interrogation techniques were effective?
Senator, I'd have to see the document. I don't recall.
All right.
I've been sitting here. It's been a long,
Why don't we do this?
time.
I'd be happy to share the documents with you. I took these pages out of my binder. I think they
Fair
were
enough.
there, so I wouldn't have to pause. But let me just hold up that answer.
Sure.
And we'll get you the documents on that.
Thank you.
Because let me do the next question. In December 2005, after the passage of the Detainee Treatment Act, you advocated that President Bush should issue a signing statement to accompany the law. In an email you sent to Stephen Bradbury and others, you said the signing statement would, and I quote, this is your quote, help inoculate against the potential of having the administration criticized sometime in the future for not making sufficient changes in interrogation policy in light of the McCain portion of the amendment. This statement clearly and in a formal way would be hard to dispute later, puts down a marker to the effect that McCain is best read as essentially codifying existing interrogation policies, end quote. To be clear, the context was that earlier in 2005, the Justice Department's Office of Legal Counsel had concluded that CIA interrogation tactics like waterboarding and sleep deprivation did not amount to cruel, inhuman, or degrading treatment. I read your email as advocating a continuation of these interrogation techniques, and worse, saying that Senator McCain's amendment actually codified them, which it did not. Is that true? And doesn't it mean that when you wrote this email, you were condoning waterboarding as lawful?
Senator, I'd want to see the email again. I don't feel comfortable commenting on documents that aren't in front of me, but I can say this, that I do remember.
My staff has the documents
Great.
here. They can bring them down
That'd
to
be
you
great.
right now.
Thank you. That'd be
Okay.
wonderful.
And then I'll put aside this part.
Okay.
You'll have the documents, because there
All
are
right.
more, and I'll go on to the next subject.
No, that's fine. I'm happy.
Is that all right?
I'm-
I know,
of
I
course,
want you to look at the documents.
I'd like to just know what I'm talking about. My recollection generally, I can, from 12 years ago.
Eric, bring him the
thank you.
documents, please.
Yeah. Thank you, Eric. My recollection generally, working on the Detainee Treatment Act, Senator, was that at that time, after Razul was issued by the Supreme Court, there were a lot of habeas petitions coming in from detainees at Guantanamo Bay, some brought by my friend Neil Gorsuch. And there was an effort by some in the administration, along with many on Capitol Hill, to try and provide a regime for the processing of those claims in a way that would conform with the Youngstown ideal of Congress and the President acting together in unison. And that Senator McCain and Senator Graham put together legislation that emphasized that not only was torture unacceptable, which it always had been under U.S. law, but the cruel, inhuman, and degrading treatment was also unacceptable
Let
under
me help
U.S.
you
law.
here. I know from the documents that you worked on the Graham effort.
Yes.
For example, a self-assessment that you wrote said that you, quote, helped coordinate the legislative effort on the Graham Amendment within DOJ and in consultation with DOD and others.
That's absolutely right, Senator. I sure did, and I'm proud of it because we managed to come up with a bipartisan bill that I think passed this body with over 80 or maybe 90 votes, I don't remember, which did two things. One, affirmed this country's commitment to prevent cruel, inhuman, and degrading treatment. And second, which provided a regime that was agreed by the Congress and the President on how Guantanamo detainees should have their claims processed.
Except, after you read the documents, just so you know, the conclusion that we come away with is that when the bill on the McCain Amendment was about to be voted on, you forwarded press articles explaining what having these two provisions together meant. That was the McCain Amendment prohibiting torture and confining it to the Army Field Manual.
Yes.
And the Graham Amendment, which would bar habeas. In other words, a detainee could not use the habeas corpus right to file in a court of law and challenge their conditions of detention. So that was looked at as offsetting McCain, but basically preventing habeas corpus from being used, and of course it was overturned by the court.
Senator, you're absolutely right that it was eventually litigated, as all these things are. There was a bipartisan effort, and it was between the Department of Defense. Department of Defense wanted congressional approval for something so that they knew what the rules would be. They were desperate to have some congressional involvement and investment in this process. And as a lawyer, that's all I was. I was a lawyer for a client, right? I was advising them on how to go about doing that legally in conjunction with Senator Graham's office and others. And it was a bipartisan effort, and we put together our best effort. The D.C. Circuit upheld it. The Supreme Court of the United States, eventually many, many years later, found that the process was insufficient. And that's the Boumediene case, as you know, Senator. But to say that there was no process would be inaccurate, too, because the Detainee Treatment Act had a long list of prescribed processes, and the question just simply was whether they were adequate enough under the suspension clause. And that was a close case that divided the court very closely. And I respect that decision as a precedent of the United States Supreme Court no less than any other, Senator.
One last question on this. When President Bush signed the Detainee Treatment Act, he issued a statement that basically said he would only construe the law consistent with his powers as commander-in-chief. According to press reports, administration officials confirmed, and I quote, "The president intended to reserve the right to use harsher methods in special situations involving national security," end quote. In other words, the signing statement reflected the president's belief that he had the power to not comply with the law he had just signed. According to emails, and this you'll verify, you were involved in preparing that signing statement, and you advocated for the issuance of the signing statement. They even showed you saying to the top State Department lawyer that Harriet Miers, the White House counsel, quote, "needs to hear from us. Otherwise, this may wind up going the wrong way."
Well, Senator, I can tell you what I recall. I haven't read,
Okay.
I need to read the email,
That's
but
fair enough.
my loose recollection of something that happened, I think, 11, 12 years ago, is that there were individuals in maybe the vice president's office who wanted a more aggressive signing statement along the lines that you've described, and that there were others, including at the State Department, who wanted a gentler signing statement. And my recollection sitting here, as best I can give it to you without studying the email, is that I was in the latter camp. John Bellinger, among others, I would have associated myself with there. And I don't know what was in the president's head when he wrote the signing statement. I can't tell you that. I don't know. I can only tell you what I remember. And I certainly would never have counseled anyone that they could disobey the law.
Okay, I have no reason not to believe you, but if you will read those.
Sure.
And then in my second round, we'll go back to it.
Sure.
And I'd be very happy to, because I think you'll see that we didn't make this up.
Senator, I'm not
okay.
suggesting you are, but there was a tug of war among parties in the
I'm
White
sure
House.
that.
Right. And
I wanted to know which side you were on.
well, count me in with John Bellinger most of the time on these things, okay?
Okay.
All right? And
Okay.
that's my recollection. And Matt Waxman would be another one. And so that's my recollection, Senator, sitting here, and I'll study these.
Okay. Let me ask you a question on wiretapping. In December of 2005, news broke that President Bush had ordered the NSA to intercept the content of certain communications of Americans without a court order, outside of the requirements of the Foreign Intelligence Surveillance Act known as FISA. You helped prepare the public defense of the program. For example, in draft testimony that you prepared for Attorney General Gonzalez defending the program, you wrote this, quote, "These authorities are vested in the President, and they are inherent in the office. They cannot be diminished or legislated away by other co-equal branches of government." Paul Clement, President Bush's Solicitor General, quote, "found this proposition unconvincing, and it was removed from the testimony." Do you still believe that the President has inherent authority, this is important, to intercept the communications of Americans in the United States that cannot be legislated away by Congress?
Goodness knows, Senator.
Good.
And I didn't believe it at the time. What I was serving at the time, as I recall, again, my recollection, and I'd be happy to review whatever you have before you, is that I was acting in the capacity as a speechwriter and taking material produced by the components that were responsible for litigating these issues, including Mr. Clement, Paul Clement, dear friend of mine, and the Office of Legal Counsel and others, and assembling it to put words in together that sounded like English. You know, and I think people like my writing. And that was my job. I think I was the scribe.
Okay, let's move on. I'd like to go to the Heller case. When we met in my office, we discussed the Heller decision, which you said you were open to discussing since the case had been decided. At that time, you said you thought both the majority opinion written by Justice Scalia and the dissent written by Justice Stevens were brilliant examples of originalism, where both justices sought to explain the reasoning by looking at the original public meaning of the Second Amendment. Which decision did you agree with and why?
Well, Senator, I think we've alluded to my difficulty here. I do think everything you've just said is accurate. Both Justice Scalia and Justice Stevens wrote excellent opinions in that case. I am not here, though, to grade my boss's work. That would be kind of impertinent of me, I suspect. And certainly, I'm sure they would think so. I also worry that saying I agree with one or the other will indicate to clients or to litigants in future cases, because it's now a precedent in the United States Supreme Court. It's binding. It's the law. Whether we like it or not, it's the law. And if I start saying I like one opinion or I like the other opinion,
all right,
I'm signaling—
I'll let you off the hook.
Oh.
Let me go to another one.
Thank you, Senator.
In D.C. v. Heller, the majority opinion written by Justice Scalia recognized that, and I'm quoting, "Of course the Second Amendment was not unlimited," end quote. Justice Scalia wrote, for example, laws restricting access to guns by the mentally ill or laws forbidding gun possession in schools were consistent with the limited nature of the Second Amendment. Justice Scalia also wrote that, quote, "weapons that are most useful in military service, M16 rifles and the like, may be banned," end quote, without infringing on the Second Amendment. Do you agree with that statement, that under the Second Amendment, weapons that are most useful in military service, M16 rifles and the like, may be banned?
Senator, Heller makes clear the standard that we judges are supposed to apply. The question is whether it's a gun in common use for self-defense, and that may be subject to reasonable regulation. That's the test, as I understand it. There's lots of ongoing litigation about which weapons qualify under those standards, and I can't prejudge that litigation.
No, I'm just asking you, do you agree with his statement? Yes or no?
Are the statements out of the Heller decision from the United States?
Justice Scalia's statement.
Well, whatever's in Heller is the law, and I follow the law. Well, it's not a matter of agreeing or disagreeing, Senator, respectfully. It's a matter of it being the law. And my job is to apply and enforce the law.
All right, fair enough. Let me give you another one. The Fourth Circuit. Judge Harvey Wilkinson authored a separate concurrence in the Fourth Circuit case, Colby v. Hogan. Here's what he said. No one really knows what the right answer is with respect to regulation of firearms. I am unable to draw from the profound ambiguities of the Second Amendment an invitation to courts to preempt this most volatile of political subjects and arrogate to themselves decisions that have been historically assigned to other, more democratic actors. Disenfranchising the American people on this life and death subject would be the gravest and most serious of steps. It is their community, not ours. It is their safety, not ours. It is their lives, not ours. Do you agree with Judge Wilkinson that the Second Amendment is ambiguous? If so, should the ambiguity be decided by the courts or by legislatures?
I'd begin by saying I hold Judge Wilkinson in high regard. He's a very fine man and a very fine judge.
Can you do yes or no?
No, I wish I could.
I wish you could, too.
But, you know, the Supreme Court of the United States isn't final because it's infallible, as Justice Jackson reminds us. It's infallible because it's final. And Judge Wilkinson had his view, and the Supreme Court has spoken. And Heller is the law of the land. And Judge Wilkinson may disagree with it, and I understand that. And he will follow the law no less than any other judge in America. I am confident of that. He's a very fine judge who takes his oath seriously.
Okay. I asked you that question on super precedent, and let me end with one on workers' rights, if I might. As you know, there have been a number of Supreme Court cases where the court has made it harder for workers to hold their employers accountable when they have experienced discrimination or be injured on the job. And we've discussed that one case, Trans Am, I think 3 or 4 of us. Let me give you a short list. Ledbetter versus Goodyear Tire, which limited the ability of women to seek equal pay. Gross v. FBL Financial Services, 2009, which made it more difficult to prove age discrimination. And the University of Southwest Texas Medical Center v. Nassar in 2013, which made it more difficult for employees to prove they've been retaliated against for reporting discrimination, including based on race, gender, national origin, religion, and other factors. Vance B. Ball, which made it more difficult for workers to prove just plain discrimination claims. As Senator Whitehouse pointed out, each of these cases was 5-4, and Justice Scalia voted with the majority against the employee in every case. President Trump and others have said, you are the next Scalia. So I think it's only fair to ask you, do you disagree with any of the majority opinions that Judge Scalia joined in these cases? If so, which ones do you especially disagree with and why? These have already been decided.
I understand, Senator. But again, if I indicate my agreement or disagreement with a past precedent of the United States Supreme Court, I'm doing 2 things that worry me sitting here. The first thing I'm doing is I'm signaling to future litigants that I can't be a fair judge in their case because those issues keep coming up. All of these issues, as you point out, keep coming up. Issues around all of these precedents will continue to be litigated and are hotly litigated. I've had post-Ledbetter Act cases in my court, for example.
Then how do we have confidence in you that you won't just be for the big corporations, that you will be for the little men? This is the question that Senator Hirono, I think, so well asked yesterday. You know, those of us, I think on both sides, care very much about workers' rights. But the record is such that one questions whether the court is capable in its present composition to give a worker a fair shot. So I'm just looking for something that would indicate that you would give a worker a fair shot. Maybe it's in your background somewhere that I don't know about, but I'd like to have you respond to it any way you can.
Senator, I really appreciate that. And I think there is a way you can take a look at this question without me potentially prejudging a case. And I appreciate your respect for that. And just to finish that thought, I'm concerned that I have to look the litigant in the eye in the next case. And if I've prejudged that case, they can look at me and say, you're not a fair judge. And I've got no answer for that. I've got no answer for that. So what I think can give you comfort in this area is, Senator, I know a case or two has been mentioned yesterday. Respectfully, I'd suggest that does not represent the body of my work. I've participated in 2,700 opinions over 10 and a half years. And if you want cases where I've ruled for the little guy as well as the big guy, there are plenty of them, Senator. The Ute Indian tribe.
Would you be willing to submit some of them?
Oh,
It's
goodness.
hard to read 2,700 cases.
I'll name a bunch of them right now.
I mean, Trans Am.
I'm sorry, Senator. Of course, Ute 5 and 6, Fletcher, the Rocky Flats case, which vindicated the rights of people who had been subject to pollution by large companies in Colorado, uranium pollution. I point you to the magnesium case, similar pollution case in the Salt Lake City area. Colorado's effort with renewable energy upheld that. Or versus City of Albuquerque, involving pregnancy discrimination in the police department in Albuquerque. WD Sports, a discrimination claim. Casey, Energy West, Crane. Simpson versus CU, involving young women who had been harassed by the football team. AM versus AM, Browder, Sutton. I can give you a long, long list.
Helpful. And we'll find them and we'll read them.
And Senator, the bottom line, I think, is that I'd like to convey to you, from the bottom of my heart, is that I'm a fair judge. And I think if you ask people in the 10th Circuit, is he a fair judge, you're going to get the answer that you got yesterday from both Senator Bennett and Senator Gardner and from General Cotchiel, and the same answer you got from Senator Allard and Senator Salazar 10 years ago. And Senator, I can't guarantee you more than that, but I can promise you absolutely nothing less.
Okay, I have 1 minute and 21 seconds. Let's talk Chevron. That's been used, thousands of times, and it really perplexes me. Olympia Snow and I did something that took me 12, 13 years to get to, and that is changing the corporate fuel economy standards. And thanks to Senator Inouye and Senator Stevens, they put it finally in a commerce bill, and it passed. So now we are on our way to 54 miles a gallon. Here's the point. We could do the rules for the first 10 years, but who knew we needed the experts to do them from that point on? So what we said in the legislation was that science would prevail. And that's still the law. It's working. The goal is, I've read articles, they say there'll be 54 miles by 2025 if this continues. What is wrong with that? How else could we have done it?
I'm not aware of anything wrong with that, Senator. I've never suggested otherwise.
But what you said is the Congress could not legislate by leaving some of the rules up to the scientists or other professionals in departments, as I understood it, in Chevron.
I appreciate the opportunity to correct this misunderstanding,
Sure,
Senator.
appreciate it.
The case I think you're referring to is Gutierrez.
That's correct.
It involved an undocumented immigrant to this country. Okay. And the question was, there were two conflicting statutes. One said he could apply for immediate discretionary relief in this country from the Attorney General. Second said he had to wait outside the country for 10 years. We had a judicial precedent that said the first statute controls. That was the ruling of our court. After that, 3 or 4 years, I can't remember exactly, the Board of Immigration Appeals, in its infinite wisdom, says our interpretation is wrong. Chevron. You have to undo your precedent, the judicial precedent, that this man had relied upon, and that he now had to wait outside the country not just 10 years, but 13 or 14, because it took them so long to make up their mind. Well, Senator, that reminded me of, when Charlie Brown's going in to kick the ball, and Lucy picks it up at the last second. And that struck me as raising serious due process concerns, fair notice, and separation of powers concerns, when an executive bureaucracy can overturn a judicial precedent without an act of Congress. That's what the case was about. And it suggested, respectfully, Senator, that under the APA, the Administrative Procedures Act, this body tasked judges to decide legal questions and left to administrative agencies great deference when it comes to fact-finding. Okay? That's how I read Section 706, is fact-finding by scientists, biologists, chemists. The experts get great deference from the courts. The only question is who decides what the law is? And can a man like Mr. Gutierrez, the least amongst us, be able to rely on judicial precedent on the books, or can he have the ball picked up as he's going in for the kick?
I think I've exceeded my time.
Oh, I'm sorry.
Apologize. Thank you very much.
I apologize.
Thank you.
I want to make clear to everybody, you didn't exceed your time because I said if you asked your question before the last second's up, and you did, that we'd give whatever time it took for that to be done. And if everybody follows that rule, I think we'll be treating everybody fairly. Before I call on Senator Hatch, I'd like to enter into the record an article in the Wall Street Journal editorial titled this, Neil Gorsuch, how would you vote, ? Democrats demand the nominee declare himself on cases, end of the title. I'll just quote the first paragraph. Democrats have come up empty trying to find something scandalous that Neil Gorsuch has said, so now they're blaming him for what he won't say, to wit, they want him to declare how he would rule in specific areas of law, questions that every Supreme Court nominee declines to answer, end of quote. Without objection, I enter that in the record. Senator Hatch.
Well, thank you, Mr. Chairman. Judge, as I said yesterday, my goal in this confirmation process is to get an understanding or a handle on your understanding of the proper role of judges in our system of government. Now, you gave an interesting lecture last year at Case Western Reserve School of Law about Justice Scalia's legacy. Justice Scalia, you explained, emphasized the difference between judges and legislators. He reminded us, as you put it, that legislators may appeal to their own moral convictions and to claims about social utility to shape the laws they think it should be in the future. But the judges should do none of these things in a democratic society, unquote. I think that accurately describes Justice Scalia's view. Is that also your own view?
Senator, it is, though I got to confess that lecture was attended by about 20 people, and it's got a lot more attention since.
Well, we're making sure it gets some more. In your opinions on the appeals court, you take great care to identify what issues the court may or may not address. In one opinion last year, for example, you used phrases such as, quote, it's not our job, unquote, and, quote, it simply isn't our business, unquote. What is an appellate court's job in your view?
It is a limited but vital role in our separated powers. A judge is there to make sure that every person, poor or rich, mighty or meek, gets equal protection of the law. It is chiseled above the Supreme Court entrance in Vermont marble, though I believe the Lincoln Memorial is made out of Colorado marble. And that is a profound and radical promise, that every person is protected by our laws equally. And in all of human history, that may be the most radical promise in all of law. And what it means to me is that when I sit on the bench and someone comes to argue before me, I treat each one of them equally. They don't come as rich or poor, big guy or little guy. They come as a person. And I put my ego aside when I put on that robe, and I open my mind, and I open my heart, and I listen. And I tell my clerks that their very first and most important job is to tell me I am wrong and to persuade me I am wrong as I read the briefs and listen to the arguments. And then if they manage to do that, I tell them their next job is to try and persuade me I'm wrong again. Because I want to make sure I leave no stone unturned. I want to get to the bottom of it. I have one client. It's the law. And it's a great joy, and it's a great privilege, and it's a daunting responsibility to come in every day and to try and get it right. And then I go listen to the arguments of the lawyers. I don't treat them as cat's paws. They're not there to be toyed with. I treat them, I hope, always as respected colleagues who've lived with the arguments, studied the cases, know the facts far better than I do. I might actually learn something from them. I go in with the questions I actually have that I want answered. And then I sit and I listen to my colleagues after that. And Senator Hatch, I can't tell you how many times in the 10th Circuit I've gone through that whole process. I go to conference. I think I know my mind. And then one of my colleagues, Harris Hartz, was here yesterday. He's often the one. There are plenty of others who say something absolutely brilliant. Changes my mind. And that's the judicial process. And that's the role I see for the appellate judge.
Well, thank you. That's a very good explanation. We held a confirmation hearing for Justice Sonia Sotomayor in 2009. Senator Charles Schumer, now the minority leader, was a member of this committee and praised the nominee in this way. Quote, Judge Sotomayor puts the rule of law above everything else. Judge Sotomayor has hewed carefully to the text of statutes, even when doing so results in rulings that go against so-called sympathetic litigants, unquote. Do you agree with Senator Schumer that your duty as a judge is to follow the law, even when it requires ruling against sympathetic litigants?
Yes, Senator. I can't tell you that when I go home and take off the robe, I'm not a human being, that I don't think about some of those cases. But my job is to apply the law as fairly as I can in each and every case without respect to persons. That's my oath. There's not every law in the book I love, you love. I'm sure of that. But my job isn't to write the laws, it's to apply the laws. And I try to do that, and that enough is enough for a day's work, and it's enough for a life's work.
In my opening remarks yesterday, I mentioned a letter we received from dozens of your peers at Harvard Law School. And Mr. Chairman, I ask consent that this letter be included in the record at this point.
Without objection, it'll be included.
The signers were of all parties and ideologies and represented many different faiths, lifestyles, and views. They all strongly support your nomination. The letter said that you personify a disinterested philosophy that respects judicial modesty combined with compassionate appreciation of the lives impacted by your decisions. Now, how can you do both?
Senator, I'm just a person. And I remember how hard it is to be a lawyer. I remember what it was like to represent clients who had problems. I told my kids when they asked me what my job was when I was young, was to help people with their problems. And as a judge, I have to resolve their problems. One of the hard things about being a judge is that somebody has to win and somebody has to lose. You make half the people unhappy 100% of the time. That's the job description. But you have to believe in something larger than yourself and that you're part of something larger than yourself. And I believe in the rule of law in this country. And I believe in an independent judiciary as one of the keys to it. And I feel it has been a calling to be a part of it. and an honor.
Well, the Fourth Amendment protects the right to be free from, quote, unreasonable searches and seizures, unquote. It was written in the late 18th century when the tools used by law enforcement to investigate crime and monitor suspects were radically different than they are today. In your view, how should a judge approach interpreting and applying constitutional provisions like the Fourth Amendment in cases where the technologies or methods at issue were obviously not even imagined by the founders?
May I offer an example, Senator, I think
Sure.
might be helpful?
Sure.
I take United States versus Jones, recent case from the United States Supreme Court involving whether police officers might attach a GPS tracking device to a car. Modern technology. How do you apply the original Constitution written 200 years ago to that? And the court went back and looked at the law 200 years ago. And one of the things it found was that attaching something to someone else's property is a trespass to chattels at common law and would be considered a search. And the court held that if that's a trespass to chattels and a search 200 years ago, it has to be today, though the technology is obviously different. So the technology changes, but the principles don't. And it can't be the case that the United States Constitution is any less protective of the people's liberties today than it was the day it was drafted.
Well, you authored the opinion in Meshworks versus Toyota Motor Sales. Now, this 2008 case applied principles from earlier cases involving photography, a relatively old technology to determine the intellectual property protections for digital modeling, a new medium. How should judges approach questions of intellectual property in cases that involve new technologies or new applications of old technologies? Should they confine themselves to analogous technologies, or may judges create new doctrines or case law that they believe better addresses the changing technological landscape?
Well, Senator, I think it's actually a very similar sort of question, right? Yeah. We look back, we find what the law was at the time, the original understanding, if you will, right? And we make analogies to our current circumstance. We judges love analogies. We work with analogies. And that's how lawmaking through the judicial process happens. That's proper judicial decision-making. It is a very different thing if you want to create a revolution in the area and change the law dramatically. That's for this body to do. It's for judges to interpret the law as best they can from the original understanding to current circumstances and apply it to current circumstances. So in Meshworks, that's exactly what we did. And looked at old case law having to do with copyright and applied it to digital media. Same principles from the beginning of the Copyright Act, just applied to a new medium.
Well, several of your writings have called into question the so-called Chevron doctrine. It's been raised here already. Most Americans probably wonder why a Supreme Court nominee would talk about a gas station, but the concept of Chevron is very straightforward. It commands federal judges to defer to an agency's interpretation of the law. In effect, this deference allows unelected, unaccountable, or bureaucrats to rewrite the law. Any middle schooler, however, should be able to see how Chevron is inconsistent with the basic duty of judges under the Constitution. As you probably know, I'm a Chevron skeptic and have led the fight to overturn this decision legislatively with my Separation of Powers Act. I introduced this bill last Congress with the support of several colleagues on this committee and will soon reintroduce it. Now, I chose its title for a reason. Reexamining Chevron is not about being anti or pro-regulation. Rather, it's about restoring the constitutional allocation of powers between the three branches. It's about maintaining fidelity to the laws passed by Congress and the exact bounds of authority granted to regulatory agencies. And it's about ensuring that the bureaucracy abides by the law no matter what its policy goals, liberal or conservative. Judge, do you agree that there's nothing extreme or inherently ideological when the Supreme Court said in Marbury versus Madison that, quote, it is emphatically the province and duty of the Judicial Department to say what the law is, unquote?
Senator, Marbury versus Madison is the cornerstone of the law in this country. I don't know anybody who wants to go back and reconsider that. I hope not.
I feel the same way. Last week, the New York Times reported that the primary line of attack against you is that you are, quote, no friend of the little guy, unquote. We've had that come up time and again in these proceedings in the last couple of days. Harvard Law School professor Noah Feldman, who does call himself a liberal, wrote an opinion piece on the subject that appeared last week on Bloomberg.com. He opens this way, quote, I don't know who decided that the Democratic critique of a U.S. Supreme Court nominee, Judge Neil Gorsuch, would be that he doesn't side with the little guy. It's a truly terrible idea. Now, Mr. Chairman, I ask that this column by Professor Feldman be placed in the record at this point.
Without objection, so ordered.
Now, Judge, some of your critics question whether you have a solid track record of judicial independence and objectivity. In particular, they question whether you would stand up to the current president if he were to exceed his authority under the Constitution and laws Congress has enacted. So, Mr. Chairman, I ask consent to place in the record an essay I wrote on the subject that appeared at SCOTUSblog.com.
Without objection, so ordered.
Now, Judge, how would you respond to that type of criticism?
Senator, a good judge doesn't give a whit about politics or the political implications of his or her decision. Decides where the law takes him or her fearlessly. I walk past every day a bust of Byron White in my courthouse. My courthouse is named for Byron White. And when I do that, I think about his absolute determination just to get it right, no matter where it took him. He said, it's a job. You do your very best and you go home. And that's how I approach things. And if you look at my record, Senator, respectfully, I think it demonstrates that. According to my law clerks, again, when I do dissent, which is very rarely, I do so in about equal numbers between judges who happen to be appointed by Democrat presidents and who happen to be appointed by Republican presidents. And I hate to even use those words because they're all just, to me, judges. I don't think of them that way. But my decisions have always been independent, regardless of who I'm agreeing or disagreeing with. And have I ruled against the government? My goodness. Ask the U.S. Attorney's Office in Colorado. I give them a pretty hard time. I make them square their corners, Senator Hatch, all right? And if you want some examples, I'd point you to Carlos, Kruger, Ackerman, 3 recent Fourth Amendment cases, ruling for the accused, the least amongst us, against the government.
Well, in 2005, before being appointed to the appeals court, you wrote an op-ed piece for National Review in which you criticized the reliance on the courts by litigants seeking to achieve policy results that they could not achieve through the regular political process. Not that long ago, there was a consensus that courts are not the appropriate place to make policy. Now you are criticized for that same common sense idea. And I want to give you a chance to respond. How does relying on courts to make policy undermine both democracy and the legitimacy of the federal judiciary?
Well, again, it goes to our separation of powers. Judges would make very poor legislators. We're not equipped for it. We're not responsive to the people. Can't elect us, can't get rid of us. You're stuck with us. And we don't have the opportunities to talk to people, to have hearings like this one in places like this. I'm permitted 4 law clerks for 1 year at a time, right out of law school. It's kind of an evanescent crowd, replenishes itself every year. Now, if you were to make laws, I don't think you design a system where you let 3 older people with 4 young law clerks straight out of law school legislate for a country of 320 million. That's just not how anyone would design the railroad. And so those are some of the problems I see, Senator.
Well, thank you. And that,
With all respect to my law clerks, I love them very much. They're like family. But they're not the same as your staffs and the investigative powers you have.
well, they're lucky to be with you, is all I can say. In that National Review piece, you pointed out some liberal policies that lawyers have sought to achieve through litigation. Some of your critics have tried to turn this into one of those gotcha moments, claiming that your real qualm was with those policies that were liberal, not that they were achieved through litigation. Again, I want to give you a chance to respond.
Well, I would say that in that article, I'd say a couple things about it. First, as I pointed out, and I believe, the courts are a very important place for the vindication of civil rights.
Yep.
And for minorities. It's a place where unpopular voices get heard the same as popular voices. In a democracy, in the legislature, majorities win. That's not the case in courts. The best argument should prevail. So they play an important role. Second, I pointed out that one thing that we lack as judges to make good policy decisions as legislators is the ability to compromise. These bodies, legislative bodies, you can put together a compromise. Judges, somebody has to win, somebody has to lose, Senator. It's not a great place to compromise, and again, we're not well equipped to do your work. At the same time, I did criticize, I pointed out a column by a liberal columnist, a self-identified liberal columnist, very fine man, and I agreed with him that his side had spent perhaps too much time in court instead of in front of the legislature. I can report to you, having lived longer, as I did report to you in 2006, that the problem lies on both sides of the aisle, that I see lots of people who resort to court perhaps more quickly than perhaps they should.
Well, some liberal organizations are claiming that in private practice you represented only big corporations. Your former law partner, David Frederick, who happens to be on the board of directors of the Liberal American Constitution Society, has a very different take. In an opinion piece published in the Washington Post, he describes your work at the firm this way, quote, "Over the course of this career, he has represented both plaintiffs and defendants. He has defended large corporations, but also sued them. He has advocated for the Chamber of Commerce, but also filed and prevailed with, class actions on behalf of consumers. We should applaud such independence of mind and spirit in Supreme Court nominees," unquote. Now, Mr. Chairman, I ask consent that this column appropriately titled, quote, "There is no principled reason to vote against Gorsuch," unquote, be included in the record at this point. Mr. Chairman.
Without objection, so ordered.
Judge, is that an accurate description of your work in private practice?
It is, and I'm grateful that David is here today with me.
Well, I'm grateful he's here, too.
Senator, I wanted to go to a place where I could represent plaintiffs as well as defendants, not pick one side of the V. I thought that would make me a better lawyer, and I'd see more of life that way. And I did. And we represented small plaintiffs. My very first trial, I represented a man who bought a gravel pit. And the prior owner wouldn't leave. And he stole the gravel. And we had to kick him out. And then he brought a bunch of lawsuits where we thought malicious use of process, trying to kick my guy out. Well, we found an old statute that said when you furtively mine another person's property, you get statutory damages. It was quite an unexpected find. It was like a 100-year-old law, no furtive mining, the no furtive mining statute. And we brought suit, and we won a claim for conversion and malicious use of process, among other things, in county court. It may have been one of the highlights of my career when one of the jurors came up afterwards and said to me, "Son, you're a young Perry Mason." That was my first trial, Senator. I represented large defendants. I represented large plaintiffs as well, along with a very significant team, my partners. We won what was at that time, I don't know if it still is, they've probably done better now, the largest plaintiff side antitrust verdict that had been affirmed in American history. We represented class actions of consumers, some dry holes, some successful, all sorts of clients, individuals, companies, nonprofits, represented pension funds, public employee pension funds, a variety of clients. It was a great and wonderful practice, and I loved every minute of it.
You're a person of great experience for your young age, I have to say. Liberal groups also claim that you favor employers over employees. In fact, they suggest that you are actually biased in that direction. An analysis published in the Stanford Law Review, however, came to a very different conclusion. Now, here's the conclusion. Quote, "After surveying his labor and employment decisions, it is clear that Judge Gorsuch does not favor or oppose employees, employers, unions, or the NLRB. His opinions do not show pro-labor or anti-labor tendencies," unquote. The author says that parties who come before you, quote, "can rely on a record of fair analysis and resistance to simply rubber stamping business interests or executive agency actions," unquote. Now, Mr. Chairman, I ask that this essay be included in the record at this point.
Without objection, so ordered.
Judge, is that your goal, to focus only on the facts and the law in every case?
Sir, I'm heartened by that article. I hadn't read that one, and I hadn't seen.
Good article.
But to answer your question, when I became a judge, they gave me a gavel, not a rubber stamp. And nobody comes to my court expecting a rubber stamp.
That's good. The Supreme Court recently decided 2 cases coming from your court that involved the Religious Freedom Restoration Act, a bill that I was instrumental in. I was one of its authors. I talked Senator Kennedy into coming on board. When Clinton signed it on the South Lawn, Kennedy was the biggest duck in the puddle. He was very proud of that particular bill. RFRA makes it difficult for the government to substantially burden the exercise of religion and applies this protective standard to everyone and to every exercise of religion. Now, these cases addressed whether the Affordable Care Act's birth control mandate violated RFRA, or the Religious Freedom Restoration Act. You were in the majority, deciding that RFRA applied to the plaintiffs in both cases and that the birth control mandate failed to meet RFRA's standard. Opponents of your nomination do not like this result, and they accuse you of being anti-woman. That, of course, isn't true at all, and any fair person would have to conclude it's not true. Your critics simply demand that, as a judge, you must follow their political priorities, that availability of birth control is more important than religious freedoms. Now, I have 2 questions about your decision. Isn't that really a policy dispute that should be addressed by Congress? And was your job in these cases to impose your or anyone else's priorities, or to interpret and apply those statutes the way Congress enacted them?
Senator, our job there was to apply the statute as best we could understand its purpose as expressed in its text. And I think every judge who faced that case, everyone, found it a hard case and did their level best. And that's all any judge can promise or guarantee. I respect all of my colleagues who addressed that case.
Well, we respect you for doing so. You wrote a concurring opinion in the Hobby Lobby case. You wrote about the Religious Freedom Restoration Act this way. Quote, "It does perhaps its most important work in protecting unpopular religious beliefs, vindicating the nation's long-standing aspiration to serve as a refuge of religious tolerance," unquote. In other words, Congress enacted RFRA to apply broadly and robustly to ensure that, among other things, the little guy would be protected as much as the big one. Is it fair to say that the court's decision in Hobby Lobby and your concurring opinion upheld this purpose, and in doing so effectively promoted religious tolerance?
Well, I might give you even a couple other examples of RFRA's application that I've been involved in that might shed some light on this. It's the same statute that applies not just to Hobby Lobby, it also applies to Little Sisters of the Poor and protects their religious exercise. And it's also been applied in a case where I appointed counsel, because I saw something potentially meritorious there. And our court held it applied to a Muslim prisoner in Oklahoma who was denied a halal meal.
Right.
It's also the same law that protects the rights of a Native American prisoner who was denied access to his prison sweat lodge. It appeared solely in retribution for a crime that he committed, and it was a heinous crime. But it protects him too. And I wrote those decisions as well, Senator, yes. I wrote the Native American prisoner case, and I participated in, and I wrote a concurrence in the Muslim prisoner case.
Well, thank you for doing so. I also want to give you a chance to answer or respond to a few things that were said during statements on Monday. One of my Democratic colleagues said it is important to know whether you are a surrogate for President Trump or for particular interest groups. Are you?
No.
Of course not. Another senator mentioned just a few of the thousands of cases in which you participated and said, quote, "I'm troubled by the results in those cases," unquote. He never took issue with how you applied the law in those cases. He said only that the results troubled him. And as I described Monday in my opening statement, I've contrasted judges who focus on the process or arriving at a result with judges who focus on what they want the result to be. Which approach do you associate with?
I associate myself with the approach I think all good judges attempt to follow the law wherever it leads.
My time is up, Mr. Chairman. Sorry.
Senator Leahy.
Well, thank you,
Oh, you're a star. Thank you.
Judge Garland, and good to have you back. Now, you know from our earlier discussions, and I had told you very frankly that, of course, I felt that if the Republicans had followed the Constitution and practiced, Chief Judge Merrick Garland would be on the Supreme Court today. I also respected you for calling Chief Judge Garland when your nomination was announced. And I understand you respect him as a jurist. Is that correct?
Very much so, Senator. Whenever I see his name attached to an opinion, it's one I read with special care. He's an outstanding judge.
Do you think he was treated fairly by this committee, yes or no?
Senators, I explained to you before, I can't get involved in politics. And there's judicial canons that prevent me from doing that. And I think it would be very imprudent of judges to start commenting on political disputes between themselves or the various branches.
The reason I asked that question, since this committee began holding hearings, public hearings to Supreme Court nominations, began in 1916. I wasn't here at that time, but it has never denied a hearing or a vote to a pending nominee ever until Chief Judge Garland. I can't express an opinion. I think it was shameful. I think it has severely damaged the reputation of this committee. I think it has severely damaged the reputation of senators who concurred with that. We were anything but the conscience of the nation in that regard, and those who proudly held their hand up to this and swore that they would uphold the Constitution of the United States did not. Now, it becomes more of a problem because it appears the president outsourced your selection to far-right, big money, special interest groups. And you may not like that terminology, but even Republican senators have praised the fact that the president had gone to this group and had a list when he's running for office of who he could select from. The list given not prepared by him, but by these special interest groups. And they have an agenda. They're confident you share their agenda. In fact, the first person who interviewed you for this nomination said they sought a nominee who understands things like we do. And, Mr. Chairman, I would ask that an article from the Wall Street Journal entitled "Trump's Supreme Court Whisperer" be included in the record.
Without objection, so ordered.
And another one in which the New York Times and Gorsuch, conservative activists sees test case reshaping the judiciary. Those be included in the record.
Without objection, so ordered.
Now, the two far-right interest groups that recommended you to the president, I want you to have a chance to talk about this. The Federalist Society and the Heritage Foundation applauded the Citizens United decision, which allowed unrestricted corporate money to pour into elections. You have suggested the constitutional law should be grounded solely in the original meaning of the text. You said judges should, and I quote you, strive to apply the law as it is, focusing backward, not forward. If we do that, let's go to the First Amendment. Do you believe that James Madison and the other drafters of the First Amendment understood the term speech to include corporate money being funneled into campaigns?
Senator, I can tell you that the Supreme Court of the United States has a lot of precedent in this area, as you're well aware. Quite a lot of it permitting Congress to compel disclosure, to limit contributions, and a lot of other case law in this area. There's a lot of precedent in this area.
Well, is there precedent from the drafters that speech included corporate money being put into corporations and being put into campaigns?
Senator, that was exactly what was at issue in part in Austin and then again in Citizens United. And the Supreme Court issued a variety of opinions on that subject, on that very subject, looking back to the original understanding of the First Amendment to see whether it embraced the speech at issue in those cases. And different justices came to different conclusions on that score.
But nothing in the Federalist Papers that talked about corporate money going into campaigns. Is that correct?
Well, Senator,
That's an easy yes or no.
I think there's an awful lot in the Federalist Papers and elsewhere that were relevant to and considered by both concurrences and dissents in Citizens United.
But nothing about corporate money.
I don't remember that term, no, Senator.
Trust me. Trust me, there wasn't.
I trust you.
Okay.
Entirely.
No, you don't have to.
Not that much?
I'll let it go. In Citizens United, Justice Kennedy indicated restrictions on campaign donations could only be justified by concerns about quid pro quo corruption. Now, President Trump has said, and I quote, that the reason he made campaign donations was so that when he needs something from them, they're there for me. Filling his campaign contributions by favors. Shouldn't Congress, not the courts, make the determination about the potential for corruption, especially if we're talking about quid pro quos?
Senator, I think there is lots of room for legislation in this area that the court has left. The court indicated that if, proof of corruption can be demonstrated, that a different result may obtain on expenditure limits.
Unlimited, you don't believe that putting unlimited amount of money by somebody who has a particular interest in the outcome of actions by the Congress, putting unlimited amount of money into specific campaigns, that's not enough to show the intent to buy favors or enough to show corruption?
I'm not sure I tracked the question, Senator. I'm sorry.
If you have corporate money that is basically unlimited under Citizens United, it can be funneled through various special interest groups. Does that at least raise concerns about quid pro quo corruption?
I think after Citizens United made clear that quid pro quo corruption remains a vital concern and a subject for potential legislation. And I think there is ample room for this body to legislate, even in light of Citizens United, whether it has to do with contribution limits, whether it has to do with expenditure limits, or whether it has to do with disclosure requirements.
There's different, if somebody were to out and out buy a vote or buy a favor, we'd all agree that's corruption, is it not?
I think Justice Kennedy would agree with you, yes.
Well, would you agree with me?
I'd follow the law. And that's my understanding. That would certainly follow within my understanding of the
When
law.
I was a prosecutor, we'd call that corruption.
All right. I'll trust you there too, Senator.
And I did. Now, but influence is different ways. For example, when you became a judge, you were here in Washington, you were working in Washington. I understand there were 3 extremely well-qualified Coloradan women attorneys who are on the short list being considered by the Bush White House. The Denver Post then did a profile of these women. At that point, and your name was not on that list, at that point, a billionaire conservative donor intervened. He lobbied the White House to appoint you. You were his lawyer, he liked you. He made donations to the same far-right interest groups that were on the list that recommended you to President Trump. Are these areas of concern?
Senator, with respect to my nomination, as I recall,
I'm talking about the circuit.
yeah, as I recall, all of my clients, or an awful lot of them, came out of the woodwork to say nice, supportive things about me. And Phil Anschutz was one, and I think there's probably letters in there from the fellow with the gravel pit, too.
Which one do you think the White House listened to the most, Mr. Anschutz or a gravel pit owner? I mean, let's be realistic.
Senator, I think what they probably listened to was the fact that they'd seen me in action at the Department of Justice. That's my guess, if you're asking me to guess, but that's a guess because I didn't make the decision.
I raise this because some of these same people helped to fund the group that put you on the list for President Trump. Now, President Trump, as you know, has attacked judges who dare to uphold the Constitution. He's gone after them. He's said things that I don't think any one of us would do. So you have to prove that you can be an independent judge. You've heard that from both sides here. Let me ask you a question in this regard. You are a person who believes in religious freedom. You said that before. In December 2015, the Senate Judiciary Committee adopted my sense of the Senate that they, quote, the United States must not bar individuals from entering into the United States based on their religion. This passed almost every senator, with the exception of then Senator Sessions and a couple others, voted for it. Now, does the First Amendment allow the use of a religious litmus test for entry into the United States?
Senator, that's an issue that's currently being litigated actively, as you know.
Well,
and
I'm not asking about the litigation in the Ninth Circuit or anything else. I'm asking about the fact, is a blanket religious test, is that consistent with the First Amendment?
Senator, we have a free exercise clause that protects the free exercise of religious liberties by all persons in this country. If you're asking me how I apply it to a specific case, I can't talk about that for understandable reasons.
Well, could the president...
The understandable reasons, just so you know, I'm frank and candid with you as I can be. Senator, when you asked me to apply it to a set of facts that look an awful lot like a pending case in many circuits now.
I'll try hypothetical. Would the president have the authority to ban all Jews from the United States or all people that come from Israel?
Senator,
would that be an easy question?
We have a constitution, and it does guarantee free exercise. It also guarantees equal protection of the laws and a whole lot else besides. And the Supreme Court in Zavidas has held that due process rights extend even to undocumented persons in this country. Okay? I will apply the law. I will apply the law faithfully and fearlessly and without regard to persons.
How about
I don't care.
Regard to religion?
Anyone, any law is going to get a fair and square deal with me. My job as a judge is to treat litigants who appear in front of me as I wished to be treated when I was a lawyer with my client, large or small. I didn't want them discriminated against because they were a large company or a small individual with an unpopular belief. And that's the kind of judge I've tried to be, Senator. And I think that's my record.
Well, Judge, let me ask you this. Do you agree with me that there should not be a religious test in the United States?
I need to know more specifics.
Well, let me give you an example. Should there be a religious test to serve in the military?
Oh, Senator, that would be inappropriate, yes. That's against the law. That's against the law.
Or well, of course, we go right back to the question, do we ban people based solely on their religion? Solely on their religion.
Senator, we have the religious...
Not whether they form a threat or something, but you ban somebody solely on their religion.
Senator, we have not just the First Amendment free exercise clause in this country. Very important protection. We have not just the equal protection guarantee of the 14th Amendment, which prohibits discrimination on the basis of race, gender, ethnicity. We also have the Religious Freedom Restoration Act, as Senator Hatch mentioned, which was a bipartisan bill passed by this body with support of Senator Kennedy and Senator Schumer when he was in the House. And that imposes an even higher standard on the government than the First Amendment when it comes to religious discrimination. It says that if there's any sincerely held religious belief, earnestly held religious belief, the government must meet strict scrutiny before it may regulate on that basis. Strict scrutiny being the highest standard known in American law.
Well, the reason I ask these questions, there is a legitimate concern. I hear stories from my grandparents when signs used to say no Irish need apply, right, or no Catholic need apply. I'm sure Senator Feinstein could speak about those of her religion. President Trump promised a Muslim ban. He still has on his website to this day, he's called for a total and complete shutdown of Muslims entering the United States. And a Republican congressman recently said the best thing the president could do for his Muslim ban is to make sure he has Gorsuch on the Supreme Court before the appeals get to that point.
Senator, a lot of people say a lot of silly things.
Oh, that's not silly.
My grandfather,
That's more than silly. That's this congressman wants you on the court so they can uphold a Muslim ban.
Senator, he has no idea how I'd rule in that case. And Senator, I'm not going to say anything here that would give anybody any idea how I'd rule in any case like that that could come before the Supreme Court or my court or the 10th Circuit. It would be grossly improper of a judge to do that. It would be a violation of the separation of powers and judicial independence if someone sitting at this table, in order to get confirmed, had to make promises or commitments about how they'd rule in a case that's currently pending and likely to make its way to the Supreme Court.
Well, is the president's national security determinations, are those reviewable by the court?
Senator, no man is above the law.
Okay. Because they've asserted that their national security determinations are unreviewable by the courts. I've heard other presidents say that in the past. I disagree when they say that. Do you disagree?
Senator, as a judge, I apply the law, and the law here, I think, is Youngstown. I looked at Justice Jackson, okay? And Justice Jackson wrote a brilliant opinion in Youngstown. Now, it's really important to know who he was. He was the fiercest.
I wrote a paper on that.
I know you did.
I know it.
I know you did. Well, I know we talked about it. And, you know, here was the fiercest advocate of executive power as FDR's Attorney General. Fierce advocate of executive power. And when he became a judge, he said the robe changes a man, or it should. And you go from being an advocate to being a neutral adjudicator. And the Youngstown system of analysis, when it comes to presidential power and foreign affairs, has three categories. One, the president acting with the concurrence of Congress. That's when the president is acting at his greatest strength, because there are shared responsibilities in our Constitution. He has commander-in-chief power. This body has power of the purse and the power to declare war assigned to it in Article 1. When the Congress and the president are in disagreement, that's the other end of the spectrum. The president there is acting at the lowest ebb of his authority. And when Congress is silent, that's the gray area in between. That's how a court, as opposed to a lawyer or advocate, approaches the problem.
Well, then let's go to that then. President Trump has declared that torture works. And he said, I quote him, bring a hell of a lot worse than waterboarding, close quote. A 2002 memo authored by Jay Bybee from the Office of Legal Counsel claimed that any effort by Congress to regulate the interrogation of battlefield combatants would violate the Constitution's sole vesting of the commander-in-chief in the president. Now, considering the fact that Congress has passed a law on this, what controls?
Well, we have a convention against torture and implementing legislation which ban torture. We have the Detainee Treatment Act, which we talked about earlier, which bans cruel, inhuman, and degrading treatment. We also happen to have an Eighth Amendment.
Well, let me ask you this. Does a president have the right to authorize torture if it violates the laws that have been passed by Congress or the other ones you cited?
Senator, no man is above the law.
Okay. Well, then let me ask you another question. President Bush's warrantless surveillance program, when you were working there, result in the illegal collection of thousands of Americans' communications. Now, many of us felt that was a direct violation of our surveillance laws. Justice Department Attorney John Yoo justified the program. He said the statutes passed by Congress cannot infringe the President's inherent power under the Constitution to conduct national security searches. So, do you believe that President Bush's warrantless surveillance program is justified because the President had, quote, inherent power to override our surveillance laws to conduct national security searches?
Senator, as a judge, before I even tried to decide a question like that, I'd want briefs and argument, and I'd want to go through the whole judicial process. I wouldn't begin to try and attempt to offer an off-the-cuff opinion.
Let me
like
ask a different way. If Congress passed a specific law on surveillance, and if a president said, I'm going to violate that law because I'm president, does he have that power?
No man is above the law, Senator.
Okay. Senator Lee, who was here a minute ago, I don't know if he, Senator Lee and I led efforts to pass the USA Freedom Act to end the NSA bulk collection of Americans' phone records. Had a clear decree from Congress that dragnet collection of Americans' phone records is not permitted. And is it still your answer that the President does not have a power to supersede that law?
Senator, I can't issue advisory opinions at this table in cases or controversies and how they would come out. I can't do it. Wouldn't be responsible.
Is that law?
But every law that this body passes, I take seriously. I respect this body. And nobody is above the law in this country, and that includes the President of the United States.
Well, when you were there, and I don't know whether these are among the things that Senator Feinstein gave you, but when Jay Bybee wrote, any effort by Congress to regulate the interrogation of battlefield combatants would violate the Constitution's sole vesting of the Commander-in-Chief in the President. And you appear to have advocated for a similar view when you attempted to give President Bush the flexibility not to be bound by Senator McCain's legislation.
Senator, my recollection is that Mr. Bybee was long gone from the department before I ever showed up, and that by the time I got there, the department and the President were willing to work with Congress to try and establish a regime that would govern operations at Guantanamo. That's my recollection. And my role was a lawyer and predominantly overseeing litigation filed by others against the government. I had a role as a lawyer, a significant one, but I was not a policymaker, Senator.
Were you involved in Hamden versus Rumsfeld?
Did you put that together?
Senator Hamden, I recall, was a decision that passed in the first instance on the Detainee Treatment Act. So to the extent I was involved in providing advice as a lawyer about the Detainee Treatment Act, I'm sure yes.
Okay. You've read the Shelby County decision. If you were on the court, which side would you have voted with?
Senator, I admire the various ways You really, you'd be a formidable companion in the courtroom.
Well, listen, I'm not, yeah, but Senator Feinstein said, don't let it go to your head, Pat.
Oh, he
And
should.
I'm not. I'm just I'm a lawyer from a small town.
Yeah, all right. I've heard that story. Whenever a lawyer says I'm just a lawyer from a small town, watch out. He's about last time you got to watch your wallet because it's gone quickly. In my experience, and I might have played that line once or twice myself.
No, but I asked these questions because there were both Justice Alito, when he was before us, and Justice Roberts, and Judge Alito and Judge Roberts answered some precedent questions. And are you saying there are no precedent questions you could answer?
Well, no, Senator, I'm happy to say Shelby is a precedent in the United States Supreme Court. It's a recent one. It's a controversial one. I understand that. What its precedential reach will prove to be remains to be seen. Because, for example, as I read it, the decision left room for Congress to legislate in this area if it wishes, to make new findings and to express a new possible regime for Section 4 and Section 5 coverage. And that possibility is live and could yield further litigation, undoubtedly would.
You've been critical of class actions, and Justice Scalia in Ledbetter case and the Walmart Dukes case been more difficult, I believe, for Americans to have day in court. Would you have joined Justice Scalia's decision in Walmart?
Well,
I just, whatever answer you want.
Senator, I would tell you that my record on class actions, I think, will reflect, if you look, and I know you have, that I represented class actions. I represented people fighting class actions. I've ruled against class actions, and I've ruled for class actions. And in each case, it depends upon the facts and the law presented to me. The most recent class action case, significant one that I can think of, involved residents who lived near Rocky Flats, a uranium processing plant, made nuclear weapons outside of Denver. And those folks filed a class action for damage to their property. And it took 25 years for that case, bouncing up and down and back and forth across the legal system before I finally issued a decision saying, stop, enough, they win. They had a trial, a jury found for them, and they win. Finish the lawsuit. And I believe it has been finished, and I believe they've been finally paid, though, of course, it's been so long. Many of them, it's their children who are getting the money.
Before Senator Graham, I thought I'd give some directions. We have this vote at noon. It's just one roll call vote. And Senator Graham should finish about 12:11 or 12:12. And then we'll adjourn, depending on when your last word is, answered his question, 30 minutes later. So somewhere's around 12:40, 12:45, I'll gavel the committee back into session. And you need to be reminded that you shouldn't be offended as members go to vote. And you'll have your 30 minutes, and I hope that's enough because I want to keep this moving. You can be back here around 12:45 or thereabouts. I'll wait until you get the orders. Does that detract from anything?
We're okay.
Okay. Senator Graham. And Senator Graham, if I go ahead of time, you will adjourn the committee, recess the committee.
Yes, sir.
Until that time.
Yes, sir. Thank you. Well, Judge, I want to read a statement here that I associate myself with. I certainly don't want you to have to lay out a test here in the abstract, which might determine what your vote or your test would be in a case you have yet to see that may well come before the Supreme Court. Does that sound like a reasonable standard?
Yes, Senator.
That's what Senator Leahy said on July the 21st, 1993. I think it was good then. I think it's good now. You're not a political person. I am, so I want to take a bit of a moment here to talk about the fairness of what's going on in terms of you and just Judge Garland. Judge Garland was a fine man. I'm sure I would have voted for him. At the time his nomination came about, we were in the middle of selecting a new president. We're in the last year of President Obama's term. To my Democratic colleagues, I want to remind you of some things that people on your side have said. On June 25th, 1992, it was in an election year, there was a suggestion that maybe one of the judges on the Supreme Court would step down before the election in November. This is what the chairman of this committee, Joe Biden, said about that possibility then. It would be our pragmatic conclusion that once the political season is underway, and it is, action on a Supreme Court nomination must be put off until after the election campaign is over. If someone steps down, I would highly recommend the president not name someone, not send a name up. If Bush did not send someone up, I would ask the Senate to seriously consider. If Bush did send someone up, I would ask the Senate to seriously consider not having a hearing on that nominee. That was Joe Biden, the possibility of a vacancy coming about by somebody stepping down, not dying, once the campaign season was afoot. Justice Alito passed away in February. There had already been 3 primaries. The campaign season, in my view, was afoot. This is what Senator Reid said on May 19th, 2005. The duties of the United States Senator are set forth in the Constitution of the United States. Nowhere in that document does it say the Senate has a duty to give presidential nominee a vote. This is Senator Schumer. And the last July 27, 2007. We should reverse the presumption of confirmation. We should not confirm any Bush nominee to the Supreme Court except in extraordinary circumstances. That was the last year of President Bush's last term. To my Democratic colleagues, on November the 21st, 2013, you decided when you were in charge of this body by 52 to 48 vote to change the rules of the United States Senate with the nomination of executive branch appointments and all judges below that of the Supreme Court. I'm not going to ask you whether you think that was fair or not, because that's not your job. I will say to the public, I thought it was incredibly unfair. I thought it was a power grab by our Democratic colleagues that will change the nature of the judiciary for the rest of our lives. Because what you have done is you've made it that you can confirm a judge now within one party if you have over 50 votes, not having the requirement to reach across the aisle to pick up a vote or two, which is a moderating influence. That is lost forever for all judges below the Supreme Court. I was in the Gang of 14 that was formed to deal with the wholesale filibuster of all Bush nominations. New to the body, I felt it would be bad to change 100 and something, almost 200 years, I guess, plus, precedent of how we deal with nominations coming from a president. But there was a wholesale filibuster of everything Bush. And there were 14 of us, I think I'm one of 2 or 3 left, that believed that it was wrong to filibuster Supreme Court judges and judges in general because you don't like the outcome of the election. And we came up with a standard that you should only filibuster in extraordinary circumstances, which I think is consistent with what Hamilton had in mind in terms of the role of the Senate, that you expect a Republican nominee or a Republican president to pick someone different than a Democrat president, because that's what the campaigns are all about. Qualified judges, and I believe that Sotomayor and Kagan were well within the reasonable mainstream of judges who would be to the left of center in the judicial philosophy world. That's why I voted for them. But now things are different. I believe that that vote, November 21st, 2013, forever changed the way the Senate works when it comes to executive appointments, judicial nominations, and will do long-term damage to the judiciary as a whole. because the most ideological will be rewarded. We don't have that requirement yet for the Supreme Court, and I hope we never will. Time will tell. I'm not optimistic. At the time of that vote, the Senate had confirmed 19 of the President Obama's judicial nominations. That same time in President Bush's second term, there had been 4 confirmed. I thought it was a manufactured crisis. I thought it was politically motivated. And when it comes to cries of being unfair, they fall on deaf ears. As to Justice Garland, fine man, I fully expected Trump to lose. He won. I think he deserves the right of every president to pick qualified people. And that's just not me saying that. This is what the Federalist Papers number 76 said about the requirement of advice and consent. This is what Mr. Hamilton wrote a very long time ago, in 1788. The Senate could not be tempted by the preference they might feel to another to reject the one proposed, because they could not assure themselves that the person they might wish would be brought forward by a second or by any subsequent nomination. They could not even be certain that a future nomination would present a candidate in any degree more acceptable to them. To what purpose, then, require the cooperation of the Senate? It would be an excellent check upon a spirit of favoritism in the president. It would tend greatly to prevent the appointment of unfit characters from state prejudice, from family connection, from personal attachment, or from a view to popularity. That was the check and balance, advise and consent rules of the game that were established in 1788. When you look at the history of the Senate's role in confirming justices to the Supreme Court, it has changed dramatically. Many of the judges of the Supreme Court were confirmed without a hearing, some without even a recorded vote. I'm not here to say that my party is without fault in the area of judges. We're not. I'm here to say that on 2013, in November 2013, the game changed in a way that I think Mr. Hamilton would be very disappointed in. And it's not that I don't understand. I very much do. When my time came for Sotomayor and Kagan to appear before this committee, I knew what awaited me if I applied the Hamilton standard. Partisan people abound on both sides of the aisle. The ferocity by which people wanted me to vote no was real, apparent, and I could feel it. I believed that if Strom Thurmond could vote for Ginsburg and that 98 senators could vote for Scalia, that there was a point in time where it was expected that you would vote for somebody you would not have chosen. You would use the qualifications of that person. So we find ourselves here today confronting a nomination of one of the most qualified people I think President Trump could have chosen from the conservative world. You are not an unfit person. I don't think there's any reason to suggest that you're his favorite. Had you ever met President Trump personally?
Not until my interview.
In that interview, did he ever ask you to overrule Roe v. Wade?
No, Senator.
What would he have done if he'd asked?
Senator, I would have walked out the door. It's not what judges do.
Okay.
They don't do it at that end of Pennsylvania Avenue, and they shouldn't do it at this end either, respectfully.
This is what the Speaker, the Democratic leader in the House said about you. Neil Gorsuch is a very hostile appointment and a very bad decision, well outside the mainstream of American legal thought. If you breathe air, drink water, eat food, take medicine, or in any other way interact with the courts, this is a very bad decision. I want to ask you to respond to what I think is complete, absolute political garbage. And statements like that were also directed against Justice Sotomayor and Kagan. I remember Sotomayor being called a racist because she gave a speech that was edgy. I remember Elena Kagan being called unpatriotic because she was involved in a decision at Harvard to kick the ROTC unit off the campus. And the reason I didn't buy one was a racist and the other was unpatriotic is because I took the time to look at the way they lived their lives, and I listened to what people had to say who had interacted with them all their lives. To my Democratic colleagues, if you take the time to listen to people who have interacted with Judge Gorsuch throughout his entire career, you will find pretty quickly that he's a fine, decent man who has tried to be a good father, a good husband, a good lawyer, and a good judge. And if you don't want to take the time, it says more about you than him. All I can say is it is impossible to conclude that what Nancy Pelosi said about you is anything other than political talk because there are no facts to justify that. The ABA gave you the most highly qualified rating they could give anybody. I just want you to know that I believe you have led a life you should be proud of, that you've tried your best to be a good father, a good husband, a good lawyer, and a good judge. Now, let's talk about our interaction a long time ago.
Thank you, Senator, for those very kind words.
Well, it's something you've earned, not something that you need to thank me for. The bottom line is, are we at war in your view as a nation?
Senator, all I know is that there are a lot of young men and women out there in harm's way so that we may sit here and have this conversation.
It would be news to them we're not at war.
I'm sure that's right.
Yeah, it'd be news to the families who've lost a loved one in this fight. So I think we're at war. Would you agree with me it's not a traditional war?
Certainly not, Senator.
There is no capital to conquer, no Air Force to shoot down, and no Navy to sink. There is no taking of Berlin and Japan. Do you agree with me it'd be hard to determine when the war is actually over?
Senator, that was a question that the court struggled with in the Hamdi case, as you know.
And we had a lot of conversations about how to proceed forward when you were in the Bush administration. Is that correct?
We did.
And you were in the camp of the Youngstown Steel camp, that if Congress is involved, the president is stronger, not weaker. Is that right?
That's right, Senator.
But there are some authorities that the president as commander-in-chief have that cannot be taken away by the Congress. They're inherent to the job. Is that true also?
There's certainly people who believe that, Senator.
Well, I am one of them. But having said that, because you can't have 535 commander-in-chiefs, Senator McCain and myself were trying to pass legislation that basically codified the practices of the Bush administration post-waterboarding. Is that a fair summary of the conflict?
Yes, Senator, I believe it is.
There were people in the Bush administration who did not want to go down the road that waterboarding was torture. That was not the view of Senator McCain or myself. At the end of the day, the Detainee Treatment Act codified how we treat enemy combatants in a time of war in terms of what practices we can employ in terms of interrogation standards. Is that correct?
Yes.
And it also tried to come up with a system of judicial review. I was in the camp that were at war, and in past wars, you don't give enemy prisoners lawyers. I don't remember any German or Japanese prisoner having a lawyer when they were captured. So traditionally, is it the commander-in-chief's job to determine who the enemy force is?
There's certainly legal authority suggesting that, Senator.
And this court's job to determine if the procedures in question pass muster?
That's correct, Senator. Of course, this body plays a role, too.
I believe it was the Department of Defense, the commander-in-chief's job to determine the enemy force because that's their expertise. And Congress could regulate the naval and land forces, and we had a say about how they could do that. And the courts have a say as to whether or not the procedures used by the President of Congress pass constitutional muster. Is that the general layout of this situation?
That's the separation of powers at work.
And there was a cross-current here. There was an email that you weren't part of. You were not included on the email, but it says, Neil and I have just been told separately, this is not what the White House wants. We have been given authorization to engage on the Graham Amendment, and not just authorization. They want us to engage, to eliminate if possible, but if not, to fix. DOD, not DOJ, has the lead, which may be what led to DOJ-LA's confusion. But the key point for us is that we have green light to engage on Graham. And what I was trying to do was preserve the Combat Status Review Tribunal concept, the ARB, Administrative Review Board concept, and allow the courts to judge the work product at the D.C. Circuit Court of Appeals, to have judicial review, but let the CSRT go first. Do you remember that debate?
I do.
Okay. And it was settled in the Congress where the Combat Status Review Tribunal would have the first shot at determining whether somebody's an enemy combatant, and the D.C. Circuit Court of Appeals could review their work product to see if it was capricious or arbitrary, if it made sense. The Supreme Court in Boumediene struck that down, saying it was not an adequate substitute for habeas. Is that correct?
That's absolutely correct, Senator.
And your role in all this was try to find out a way to engage Congress on the Detainee Treatment Act because it was your view that Congress being involved would strengthen the President's hand.
As a lawyer,
Yes.
I was not a policymaker, but I did advise.
As a lawyer.
As did many others. There were many other very fine lawyers, too, Senator, who advised the administration that engaging Congress would be a good idea because we had read our Youngstown and our Justice Jackson.
Any lawyer, I think, who understands this area of the law would suggest the President's stronger when he has congressional support. The signing statement. Is it fair to say there was a conflict between the Vice President's office and other parts of the Bush administration about what this signing statement should say or look like?
That's my recollection, and that's about all I can recall.
I remember it very well because Vice President Cheney's signing statement was going to be, we have an inherent authority to do whatever we think we need to do. And there were a lot of other people saying, no, you don't have the authority just to set aside a law. You have to have a reason to object to it. So I just want the public to understand that when it comes to this man, I've seen him in action in very complicated emotional matters where he had one group of people who could give a damn about the terrorist and another group of people that wanted to criminalize what I thought was a real-world fight. And we tried to find that middle ground. And in a 5-4 decision, the Supreme Court struck down my proposal, and we fixed it later with a huge bipartisan vote so that every enemy combatant today has a habeas proceeding where the government has to prove by preponderance of the evidence you're in fact an enemy combatant. Then if they reach that conclusion, you can be held under the law of war as long as you're a threat to our nation. Is that a fair summary of where we're at?
That's my understanding, Senator. Along the way, your legislation did prevail in the D.C. Circuit and in the Supreme Court. Of course, it was a close call. It was 5-4, as I recall.
And that just proves that 5 people can be wrong. So, while I disagree, I certainly respect the court's decision.
You're not going to get me to commit on that one either,
worry.
Senator.
I'm not even going to try. The bottom line here is there will be more legislation coming regarding the role of the government in gathering information. But from sort of a civics point of view, which Senator Sass is going to take you through, there's a difference between the law of war and domestic criminal law. Do you agree with that?
Yes, Senator.
That a common criminal, the goal of the law is to prosecute a crime that one individual or group committed against another individual or groups. That's correct?
That's right.
The law of war is about winning the war.
Well, Senator, there are
How you fight the war.
There are, as you know, rules about that too.
Right.
Laws about that.
Yeah, and we're fighting an enemy who has no rules, that would do anything, and I've always been in the camp that I don't want to be like them. I think that's their weakness, and the strongest thing we could do is stand up for a process that stood the test of time, which is intelligence gathering in a humane way, because they would cut our heads off. Doesn't make us weak because we won't cut their heads off. It actually makes us stronger over the arc of time, so that's my commercial about that. So there will be more litigation, and there are no bad guys or girls when it comes to challenging precedent. Do you agree with that? People have the right to do that.
To challenge precedent?
Yes.
Every person is allowed to come to court to bring whatever claim they have. That's how our system
That's how
works.
Brown versus Board of Education came about.
Exactly right, Senator.
Okay, let's talk about Roe v. Wade. What is the holding of Roe v. Wade in 30 seconds?
Well, the holding of Roe versus Wade in 30 seconds, Senator, is that a woman has a right to an abortion. It developed a trimester scheme in Roe that specified when the state interest and when the women's interests tend to prevail.
Okay, so let me just break it down. The court said that there's a right to privacy, that the government can't interfere with that right in the first trimester. Beyond the first trimester, the government has more interest as the baby develops. Is that fair to say?
That was the scheme set
And I
forth.
think medical viability was the test that the court used.
Well, that's the test that the court came around and applied in Casey in 1992.
Okay.
And so viability became more of the touchstone rather than a rigid.
Is it fair to say that medical viability in 1992 may be different than it is in 2022 medically?
Senator, I'm not a scientist or a doctor.
I would suggest that medical viability may change as science progresses. So you may have people coming in and saying, in light of scientific medical changes, let's look at when medical viability occurs. That's one example of litigation that may come before you. I have legislation that says at 20 weeks, the unborn child is able to feel excruciating pain, and the theory of the legislation is that the state has a compelling interest to protect an unborn child from excruciating pain, which is caused by an abortion. I'm not asking you to agree with my legislation. I am saying that I am developing, we're one of 7 nations that allow wholesale, on-demand, unlimited abortion at 20 weeks, the 5th month of pregnancy. I'd like to get out of that club, but we're going to have a debate in this body, in the House, about whether or not we want to change the law to give an unborn child protection against excruciating pain at 20 weeks, because you can, the standard medically is that if you operate an unborn child at 20 weeks, the medical protocols are such that you have to provide anesthesia because you don't want to hurt the child in the process of trying to save the child. So medical practice is such that when you operate an unborn child at 20 weeks, which you can do, you have to provide anesthesia. And my theory is, well, let's just look at it the other way. Should you allow an abortion on demand of a child that can feel excruciating pain? Is that what we want to be as a nation? Does that run afoul of Roe v. Wade? I'm going to make the argument that there's a compelling state interest at that stage of the pregnancy to protect the child against death that is going to be excruciatingly painful. You don't have to say a word. I'm just letting everybody know that if this legislation passes, it will be challenged before you. And you'll have to look at a new theory of how the state could protect the unborn. And here's what I think. You'll read the briefs, look at the facts, and make a decision. Am I fair to conclude that?
Senator, I can promise you no more than that, and I guarantee you no less than that in every single case that comes before
Well, this is a
me, no matter
real-world
what the subject
situation.
matter.
that may develop over time because 70-something% of the American people side with me on the idea that at 20 weeks we should not be in the club of 7 nations that allow abortion on demand, because that's in the 5th month, and that doesn't make us a better nation. There'll be people on the other side saying, no, that's an erosion of Roe, and it will go to the court, maybe, if it ever passes here. And the only reason I mention this is that everybody who wants to challenge whatever in court deserves a person like you. A person like you, no matter what pressures are applied to you, will say over and over again, I want to hear what both sides have to say. I want to read their legal arguments, look at the facts, and I will decide. That, to me, is reassuring. And that's exactly the same answer I got from Sotomayor and Kagan. No more, no less. And we can talk forever about what you may or may not do. If you do anything different than that, I think you'd be unworthy of the job. Now, about what's going on in the country with President Trump. Whether you like him or you don't, he is president. But you have said several times that he is not above the law as president. Is that correct?
Yes, Senator.
You told Senator Leahy if there was a law passed that a Muslim could not serve in the military, you believe, based on current law, that would be an illegal act.
Senator, yes, I see that having all sorts of constitutional problems under current law.
So if we have laws on the book that prevent waterboarding, do you agree with me that the Detainee Treatment Act prevents waterboarding?
Yes, Senator, that's my recollection of it. Firmly.
So in case President Trump is watching, which it may very well be, one, you did a good job picking Judge Gorsuch. Number two, here's the bad part. If you start waterboarding people, you may get impeached. Is that a fair summary?
Senator, the impeachment power belongs to this body.
Okay, that's even better. Would he be subject to prosecution?
Senator, I'm not going to speculate.
But he's not above the law.
No man is above the law.
Okay.
No man.
Thank you. I think you're a man of the law, and I really want to congratulate the president to pick you. Quite frankly, I was worried about who he'd pick. Maybe somebody on TV. But President Trump could not have done better in choosing you. And I hope people on the other side will understand that you may not like him. I certainly didn't agree with President Obama, but I understood why he picked Sotomayor and Kagan. And I hope you can understand why President Trump picked Neil Gorsuch. I hope you'll be happy with that, because I am.
Thank you, Senator.
We will recess till 12:45.
The Senate Judiciary Committee taking a relatively quick half-hour break. There's a vote in the Senate, so members heading there and giving Judge Gorsuch and his family a chance for a lunch break here as the hearing's expected to go until well after 7 o'clock tonight. They got underway at 9:30 Eastern with senators taking a half an hour for questions. Day number 1 of questioning of Judge Gorsuch. Tomorrow, 20-minute rounds of questions. We expect when they come back that it'll be Senator Dick Durbin's turn. Again, they're expected back at 12:45, and our live coverage will continue here on C-SPAN 3. A very busy day on Capitol Hill, especially on the other side of Capitol Hill as well, the House side, with President Trump meeting with the House Republican Conference earlier today, to talk about the upcoming vote this week on the Republican health care plan. The Hill headline this morning with Tom Price, the president, arriving this morning. Their headline: Trump warns Republicans ahead of health care votes, saying that he issues a stern warning today, telling Republicans they could lose their seats and the House majority in 2018 if they fail to repeal and replace Obamacare. Our Capitol Hill producer, Craig Kaplan, catching up with the Minority Whip, Steny Hoyer, telling reporters that no House Democrat will vote for the American Health Care Act, the GOP health care law repeal replace bill. And Robert Costa of the Washington Post actually catching up with the Judiciary Committee chairman, Chuck Grassley, and his comments on the upcoming vote in the House this week. Quote, "They're a few votes short," he said. Again, the Senate Judiciary Committee coming back in a half an hour or so. We will have live coverage here, and we encourage your comments and your participation on Twitter at C-SPAN. Comments here from Bill, who tweets about today's hearing so far, saying that Judge Gorsuch has integrity and follows the law, not his personal or political opinions. Diane thinks, though, how many times with senators ask Gorsuch's opinions on cases and he says can't say, hoping he slips up and says what he thinks. Another view saying that Judge Gorsuch would not be nominated if the Federalist Society and Republicans did not believe he would overturn Roe. Roberts and Alito the same. And from Yvette, she says his job is to decide on issues by personal preference. His job is not to decide on issues by personal preference. His job is to decide and uphold the law and Constitution. So more questioning. Again, we expect Senator Durbin at 12:45. But earlier he was asked about court precedent and the 1973 Roe v. Wade decision by the chairman, the ranking member of the committee, Dianne Feinstein. Here's what he had to say.
In my opening remarks, I indicated that if anything had super precedent, Roe did in terms of the numbers, and I've put that in the record. Here's why it becomes of concern. The president said that he would appoint someone who would overturn Roe. You pointed out to me that you viewed precedent in a serious way in that it added stability to the law. Could you elaborate on the point that you made in my office on that?
I'd be delighted to, Senator. Part of the value of precedent, it has lots of value. It has value in and of itself because it's our history. And our history has value intrinsically. But it also has an instrumental value in this sense. It adds to the determinacy of law. We have lots of tools that allow us to narrow the realm of admissible dispute between parties so that people can anticipate and organize their affairs. It's part of the reason why the rule of law in this country works so well. We have statutes, we have rules, we have a fact-finding process and a judicial system that's the envy of the world. And precedent is a key part of that because, as the chairman pointed out when he quoted a piece of mine, once a case is settled, that adds to the determinacy of the law. What was once a hotly contested issue is no longer a hotly contested issue. We move forward. And Senator, the value of that is the United States Supreme Court takes something like 70 or 80 cases a year. That is a tiny fraction of all the disputes in our federal legal system, right?
Right.
My law clerks tell me it's something like 0.001%. And they're unanimous in those cases which have divided circuit judges. That's why the Supreme Court largely takes the case, because it's divided us. It's one of the rare cases where we disagree. They're unanimous 40% of the time.
One other question.
Sure.
Do you view Roe as having super precedent?
Well, Senator, a super precedent is
In numbers, 44.
It has been reaffirmed many times. I can say
Yes.
that. Yes.
Yes, dozens.
5 senators have asked questions of Judge Gorsuch. Total of 20 on the committee, 11 Republicans, 9 Democrats. We expect when they come back that Senator Dick Durbin will be next up. And we expect the committee to gavel back in at 12:45. Again, there's a vote in the House, in the Senate going on, and just a short lunch break for what's expected to be a very long day. This hearing today, day number 2 of the confirmation hearing. And a reminder, too, that we'll re-air the entire hearing tonight over on C-SPAN 2, beginning at 8 o'clock Eastern. While we wait for the committee to gavel back in, however, we'll take you back to the beginning of today's hearing. And the first to ask questions was, of course, the chairman, Chuck Grassley.
Welcome back, Judge Gorsuch. Glad to have you back, and I'm sure you're glad to be here. Good morning, everybody. I'd like to welcome everyone, and especially our nominee, as I just did. This is day 2 of the Supreme Court nominees hearing. We have a long day in front of us, so we'll immediately turn to members' questions. It's my intention to get through all members' first round of questions today, so it's important that we all stick to our time limits so that we can stay on that schedule. I realize that 10 hours is a long time for you to sit there and answer questions for 20 of us. So I'm going to defer to you when you might need a break. In the meantime, I would anticipate a break about 30 minutes for lunchtime, and I hope for the members of the committee. I have not made up my mind on this yet, but we do have a vote scheduled at noon, and it might, I'm sorry. Okay, we have 2 votes at noon. So it might be appropriate to use that period of time for our lunch break. I'll make a decision on that later on. So with that understanding with you and to accommodate you, because you're the person that has to sit there and answer questions, and so whatever your needs are, you let us know. I started yesterday morning, Judge and audience, with Justice Scalia's comments that our government of laws and not men is the pride of our constitutional democracy. Our democracy requires judges to let the people's elected representatives do the lawmaking. You, Judge, said that Justice Scalia's great accomplishment was to, quote you, remind us of the differences between judges and legislators, end of quote. Legislators, in other words, consult their own moral convictions to shape law as we best think it to be. But you said that judges can't do those things, rightly so from my point of view. Our Constitution is also a charter of liberty. Justice Scalia said that our Constitution guarantees our liberties primarily through its structure. That happens to be the separation of powers. You've said, Judge, that said much the same thing, and I quote you, what would happen to disfavored groups and individuals, end of quote, if we allowed judges to act like legislators? Quote, the judge would need only want his own vote to revise the law willy-nilly in accordance with preferences, end of quote. The separation of powers in our system requires an independent judiciary made of judges respectful of the other 2 branches, but not beholden to them. Judges must be equally independent of the president who nominates them and us senators who confirm the same judiciary members. Let's start with independence from the executive. No one, not even the president, is above the law. One of the most remarkable things about your nomination is the broad bipartisan support that you've received. You've earned great praise from individuals who aren't exactly supporters of the president, but who strongly supported your nomination. Yesterday, we heard from one of them, Neil Gorsuch. President Obama's former Solicitor General said that you, quote, will not compromise principle to favor the president. In 2006, former Colorado Senator Salazar, a Democrat, said that you have, quote, the sense of fairness and impartiality that is a keystone of being a judge, end of quote. And legal commentator Jeffrey Rosen, similar, praised you for your independence. So let's start with my first question. I'd like to have you describe in any way you want to what judicial independence means, and specifically tell us whether you'd have any trouble ruling against a president who appointed you.
That's a softball, Mr. Chairman.
Turn your microphone.
I'm sorry. So that's a softball, Mr. Chairman.
Okay.
I have no difficulty ruling against or for any party other than based on what the law and the facts in the particular case require. And I'm heartened by the support I have received from people who recognize that there's no such thing as a Republican judge or a Democratic judge. We just have judges in this country. When I think of what judicial independence means, I think of Byron White. That's who I think of. I think of his fierce, rugged independence. He said, I have a job. People asked him what his judicial philosophy was. I give the same answer. I decide cases. It's a pretty good philosophy for a judge. I listen to the arguments made. I read the briefs that are put to me. I listen to my colleagues carefully. And I listen to the lawyers in the well. And this experience has reminded me what it's like to be a lawyer in the well. It's a lot easier to ask the questions, I find, as a judge than it is to have all the answers as the lawyer in the well. So I take the process, the judicial process, very seriously. And I go through it step by step, and keeping an open mind through the entire process as best I humanly can. And I leave all the other stuff at home. And I make a decision based on the facts and the law. Those are some of the things judicial independence means to me. It means to me the judicial oath that I took to administer justice without respect to persons, to do equal right to the poor and the rich, and to discharge impartially the duties of my office. It's a beautiful oath. It's a statutory oath written by this body. That's what judicial independence means to me. Happy to talk about the separation of powers, too, if you'd like, Mr. Chairman, which you referenced in there, or I'm happy to answer another question, entirely up to you.
Well, your record made clear that you aren't afraid to fulfill your role independently, and you just emphasized that. You vacated orders of administrative agencies acting outside their authority, and you ruled on cases where Congress has overstepped its bounds. So I think you can maybe speak about the separation of powers, but at the same time, maybe you could give me a couple of your cases that demonstrate your commitment to that independence of the executive branch of government.
Sure. On the first point, I have decided, as I noted yesterday, over 2,700 cases. And my law clerks tell me that 97% of them have been unanimous. 99% I've been in the majority. They tell me as well that according to the Congressional Research Service, my opinions have attracted the fewest number of dissents from my colleagues of anyone I've served with that they studied over the last 10 years. Now, the Congressional Research Service speculates whether that's because I'm persuasive or I believe in collegiality. I don't see why it has to be a choice. My law clerks also tell me that in the few cases where I have dissented, that I'm as likely almost to dissent from a Democrat-appointed colleague as a Republican-appointed colleague. And that's, again, because we don't have Democrat or Republican judges. According to the Wall Street Journal, I'm told that of the 8 cases that they have identified that I've sat on that have been reviewed by the United States Supreme Court, our court was affirmed in 7 of them. Now, I think Louise might argue for the 8th.
Okay.
Because in that case, the Supreme Court didn't like a procedural precedent of our court that, as a panel, we were bound to follow. So they remanded it back. We decided on the merits, as the court instructed. Cert denied. 8 out of 8. On the separation of powers, it is, Mr. Chairman, the genius of the Constitution. Madison thought that the separation of powers was perhaps the most important liberty-guaranteeing device in the whole Constitution. And this is a point of civics that I do think maybe is lost today, how valuable the separation of powers is. That you have, in Article 1, the people's representatives make the law. That's your job. And I don't think it's an accident that the framers put Article 1 first. Your job comes first. You make the law. Article 2, the president's job is to faithfully execute your laws. And our job, Article 3, down at the bottom, is to make sure that the cases and controversies of the people are fairly decided. And if those roles were confused and power amalgamated, founders worried that that would be the very definition of tyranny. And you can see why. Judges would make pretty rotten legislators. We're life tenured, right? You can't get rid of us. It only takes a couple of us to make a decision, or 9, or 12, depending on the court. That'd be a pretty poor way to run a democracy. And at the same time, with respect, legislators might not make great judges because they're answerable to the people. And when you come to court with a case or a controversy about a past facts, you want a neutral, rigidly neutral, fair, scrupulously fair decision maker. You want somebody who's going to put politics aside. So the separation of powers, I don't think has lost any of its genius over 200 years. In fact, it's proven it.
Thank you. I've heard my colleagues and people not in the Senate say that now more than ever, we need a justice who will be independent of the president who nominated him or her. So I'd like to ask about your nomination and your independence. A lot has been made about the list of judges then candidate Trump proposed as possible nominees. To me, it was the most transparent that we've had in history, and we didn't have Secretary Clinton give out such a list. Of course, you weren't on the first group that came out, and otherwise added later. So I'm curious, when did you first learn that you were on candidate Trump's extended list?
Well, Mr. Chairman, you're right. There were 2 lists, as I recall, over the summer. And I wasn't on the first list. And I remember having breakfast one day with a friend who may be here. Brian, there you are. You remember this. We were having breakfast one day, and he said, "Neil, you're not on the list." And I said, I'm fine. You're right, I'm not on the list. He said, "You should be on the list." And I said, "I love my life in Colorado. I wouldn't change a thing. I'm a happy man. I have a loving wife, a beautiful home and children, a great job with wonderful colleagues. I'm a happy person." We're walking away from breakfast, and I get an email from Brian saying there's a new list, and you're on it. That was the first I heard of it.
And I assumed you thanked him.
I don't know about that. I don't know if, I don't think you didn't know. I don't think we were all surprised.
I'm kidding.
And at any rate, we are where we are.
Okay. Tell me about the process that led to your nomination. Did anyone ask you to make any promises or assurances at all about your view on certain legal issues or the way that you'd rule in certain cases?
Senator, I think you'd be reassured by the process that unfolded. I tried to live under a shell during the campaign season, watch baseball and football, go about my business. But I did hear lots of talk of litmus tests from all around. It was in the air. And I don't believe in litmus tests for judges. I've written about that years ago. I wasn't about to become party to such a thing. And I am here to report that you should be reassured, because no one in the process, from the time I was contacted, with an expression of interest for a potential interview, to the time I was nominated, no one in that process, Mr. Chairman, asked me for any commitments, any kind of promises about how I'd rule in any kind of case.
And that's the way it should be. So we've just discussed your independence from the president, but there's also independence from the legislative branch. It's odd that some of the same folks who will claim that you're not independent from the president will turn around and try to extract from you promises and commitments before they pass judgment on your nomination. The irony, of course, is that extracting commitments during the confirmation process is exactly what would undermine your independence as a judge. One way that they'll do this is asking you about precedent. So let's talk about that. For starters, I've got a book here that you co-wrote, an 800-page book on precedent. Your 12 co-authors included judges from across the ideological spectrum, such as Bill Pryor, who was also on President Trump's Supreme Court list, and Diane Wood, who was reportedly on President Obama's list. You've also touched on the value of precedent in speeches that you've given or in your opinions. For instance, in the speech you gave honoring Justice Scalia last year, you said this, quote, "Even when a hard case does arrive, once it's decided, it takes on the force of precedent, becomes an easy case in the future, and contributes further to the determinacy of our law," end of quote, especially if more recent opinions have called into question the rationale of the original case. But you've also suggested that there may be circumstances where it's appropriate to revisit precedent. Specifically, you wrote that it may be appropriate to reconsider a decision where it has become a, quote, precedential island surrounded by a sea of contrary law, end of quote. So there may be times where it is appropriate to reconsider certain decisions, especially if more recent opinions have called into question the rationale of the original decision. I think all of us would agree, for instance, that Brown versus Board of Education, which finally overruled a repugnant, separate but equal standard in Plessy, is the textbook example of this. So with these things in mind, I'd like to explore the approach that you take to Supreme Court precedents. Could you tell us what you believe is the value of precedent in our legal system?
Absolutely, Senator. And if I might, Mr. Chairman, go back just a moment to promises. I have offered no promises on how I'd rule in any case to anyone, and I don't think it's appropriate for a judge to do so, no matter who's doing the asking. And I don't because everybody wants a fair judge to come to their case with an open mind and to decide on the facts and the law. One of the facts and one of the features of law that you have to decide it on is on the basis of precedent, as you point out. And for a judge, precedent is a very important thing. We don't go reinvent the wheel every day. And that's the equivalent point of the law of precedent. And we have an entire law about precedent, the law of judicial precedent. Precedent about precedent, if you will. And that's what that 800-page book's about. It expresses a mainstream consensus view of 12 judges from around the country appointed by, as you point out, presidents of both parties, great minds. Justice Breyer was kind enough to write a foreword to it. It makes an excellent doorstop. And in it, we talk about the factors that go into analyzing precedent, any consideration of precedent. There are a bunch of them. You've alluded to some of them. The age of the precedent, very important factor. The reliance interests that have built up around the precedent. Has it been reaffirmed over the years? What about the doctrine around it? Has it built up, shored up, or has it become an island, as you point out? Those are all relevant considerations. Its workability is a consideration, too. Can people figure out how to abide it? Or is it just too confusing for the lower courts and their administration? Those are all factors that a good judge will take into consideration when examining any precedent. You start with a heavy, heavy presumption in favor of precedent in our system. Alexander Hamilton said that's one important feature, I think it was Hamilton, said one important feature of judges. If we're going to give them life tenure and allow them that extraordinary privilege, they should be bound down by strict rules and precedents. Francis Bacon called precedent the anchor of the law. So you start with that heavy presumption in favor of precedent. You consider those factors in that light. And yes, in a very few cases, you may overrule precedent. It's not an inexorable command, the Supreme Court has said. That's the law of precedent, as I understand it, and I believe is expressed in that book with my very highly respected colleagues.
As a lower court judge, you're bound by not only Supreme Court precedent, but as you've demonstrated, the precedent of your own court. But as a Supreme Court justice, part of your job will be to decide when existing Supreme Court precedent need not be reconsidered. How will you decide when you revisit existing precedent?
Mr. Chairman, I don't think the considerations change. It's the same analysis that I would have as a Supreme Court justice, if I'm fortunate enough to be confirmed, that I have when I'm considering circuit precedent as a circuit judge. It's the exact same process. The exact same rules apply.
Okay. This is the 14th Supreme Court hearing that I participated in, so I have a pretty good idea of some of the questions that you're going to get today. You're going to be asked to make promises and commitments about how you'll rule on particular issues. Now, they won't necessarily ask you that directly. For instance, how will you rule on this issue or that issue? Instead, they'll probably ask you about old cases, whether they were correctly decided. Of course, that's another way of asking the very same question. They know that you can't answer, but they're going to ask you anyway. I've heard justices nominated by presidents of both parties decline to answer questions like these. That's because, as the nominee put it, quote, a judge sworn to decide impartially can offer no forecasts, no hints, for that would show not only disregard for the specifics of this particular case, it would display disdain for the entire judicial process, end of quote. Now, you probably know that's what Justice Ginsburg said at her hearing, and it's what we call the Ginsburg standard. The underlying reason for this is, of course, is that making promises or even giving hints undermines the very independence that we just talked about. I'd like to ask you if you agree with what I just said.
I do, Mr. Chairman.
So let me ask you about a couple of Supreme Court cases. In Heller, the Supreme Court held that the Second Amendment protects an individual right to bear arms. If I ask you to tell me whether Heller was rightly decided. Could you answer that question for me?
Senator, I'd respectfully respond that it is a precedent of the United States Supreme Court. And as a good judge, you don't approach that question anew as if it had never been decided. That would be a wrong way to approach it. My personal views, I'd also tell you, Mr. Chairman, belong over here. I leave those at home. Mr. Kochel yesterday said that what he wants is a fair judge. And that's what I wanted as a lawyer. I just wanted a judge to come in and decide on the facts and the law of my client's case and leave what he had for breakfast at the breakfast table. And part of
testimony and questions from earlier today in the House and the Senate Judiciary Committee. We'll take you back live now to the hearing room as the hearing will resume shortly.
On and on. Senator Durbin.
Thanks, Mr. Chairman, and thanks, Judge. Just to be clear, going back to Senator Graham's line of questioning, you helped draft the provision stripping the courts of jurisdiction, which was struck down by the Supreme Court in Hamdan, and you weren't involved in the drafting of the McCain section of the bill on the detainee treatment amendment.
Senator, that wouldn't fit quite with my recollection.
Please.
My recollection is that Senator McCain and Senator Graham wrote the legislation with input from the Department of Defense and the Department of Justice and a whole lot of others besides. And I was one voice among a great many. And that in terms of when it was struck down, Hamdan held that the Detainee Treatment Act didn't apply retroactively. It only applied prospectively. And then several years later, gosh, I want to say it was 2008 maybe, the court came back around in Boumediene.
So what I'm driving at, though, is the McCain section relative to cruel, inhuman, and degrading treatment. And I assume, or I hope, you've had a chance to take a glance at the emails that Senator Feinstein gave you. You said in your email you wanted a signing statement to the effect that the view is that McCain is best read as essentially codifying existing interrogation policies. So what interrogation policies did you think the McCain Amendment was essentially codifying?
Senator, I haven't had a chance to look at that. I'm sorry. I scarfed down a sandwich over the break, and I will be happy to read it. But I'm not sure what I can answer you here sitting off the top of my head. It was 12 years ago, and I'm doing the best I can with my recollection.
I'm trying to get this leap from your memory of this email, which I understand there were 100,000 pages of email.
Exactly. Senator, I think the Department of Justice has produced something like 200,000 pages of stuff.
I will concede that point, but your lack of memory at the moment, and contrast that with your clear statement that you believe that the McCain bill, which I supported, outlawed waterboarding.
Sitting here, that would be my understanding, Senator.
The problem with what I've just described is when you were talking about a signing statement, waterboarding was still happening, and you were saying in your email, I want to essentially codify existing interrogation policy. There's an inconsistency there, which we're going to have to wait to the second round to resolve.
Okay.
Okay. Let me read something to you and ask you for a reaction. Is a statement that was made about 8 days ago by a congressman named Steve King of Iowa. And here's what he said. You cannot rebuild your civilization with somebody else's babies. You've got to keep your birth rate up, and that you need to teach your children your values. In doing so, you can grow your population, you can strengthen your culture, you can strengthen your way of life. The reaction to that statement was overwhelming. Civil rights leader Congressman John Lewis called it bigoted and racist. Republican House Speaker Paul Ryan said he clearly disagreed with King's comments, went on to say the Speaker clearly disagrees and believes America's long history of inclusiveness is one of its great strengths. What would your reaction to that statement be?
Senator, I can talk about my record. And I can tell you that as a federal judge, when a defendant comes to court with an allegation that the sentencing judge made improper comments based on his ethnicity, me and my colleagues and I have removed that judge from the case. I can tell you that when an immigration lawyer fails to provide competent counsel time and time again, I've sent him to the bar for discipline. Okay. I can tell you that when it comes to access to justice, I've written on this topic. I've worked on this topic for the last 6 years together with many wonderful people on the Rules Committee trying to make our civil litigation system cheaper and faster because it takes too long for people to exercise their Seventh Amendment liberties. And I can tell you together with my colleagues, when we found that the level of representation of inmates on death row was unacceptable in our circuit, a whole bunch of us, I can't take too much credit, tried to do something about it. I can tell you that when prisoners come to court, pro se handwritten complaints, and I see something that might be meritorious in them, I appoint counsel. That's my record, Senator.
Can you describe your relationship with Professor John Finnis?
Sure. He was my dissertation supervisor.
When did you first meet him?
Well, whenever I went to Oxford, so it would have been 1992. Well, it could have been 2 or 3, somewhere in there.
And what was his relationship with you or you with him?
He was my dissertation supervisor, and I would describe that as a relationship between teacher and student, and he was a very generous teacher, particularly generous with his red ink on my papers. I remember sitting next to the fire in his Oxford office. It's like something out of Harry Potter. And he always had a coal fireplace burning, and sometimes whether I was being raked over the coals. He did not let an argument that I was working on go unchallenged from any direction.
So that was over 20 years ago that you first met him?
Whatever it is, yes.
Do you still have a friendship or relationship with him?
Last time I saw him, when I know I saw him when he retired, and there was a party held in his honor, and I remember seeing him then, and that was a couple of years ago.
Did he know you were from Colorado?
I don't know. It must have, at some point, come out in our conversations. Mm-hmm. I don't know.
And do you recall saying some words of gratitude for his help in writing your book?
He did not write my book, Senator. He did not help write my book. I wrote my book. I certainly expressed gratitude to my dissertation supervisor in a book that's basically my dissertation.
I think you were quoted as saying in 2006, you thanked Finnis for his, quote, kind support through draft after draft.
And there were a lot of drafts, Senator. I mean, golly, that was a very tough degree. That was the most rigorous academic experience of my life, and I had to pass not just him, but an internal examiner and an external examiner, and that was hard. That was hard.
In 2011, when Notre Dame ran a symposium to celebrate his work, you recalled your study under him, and you said, quote, it was a time when legal giants roamed among Oxford's spires.
Oh, yeah. Yeah.
You called him one of the great scholars.
Well, and Oxford has a stable, and it's part of the reason why it was such a privilege. I mean, out here as a kid from Colorado, and I got a scholarship to go to Oxford. I'd never been to England, to Europe before. And at Oxford at that time, they had John Finnis, Joe Raz, Ronald Dworkin. H.L.A. Hart was even still alive then.
So let me, if I can, read a couple statements from Professor Finnis. In 2009, Professor Finnis wrote, about England's population. He said England's population had, quote, largely given up bearing children at a rate consistent with their community's medium-term survival. He warned they were on a path to, quote, their own replacement as a people by other peoples more or less regardless of the incomer's compatibility of psychology, culture, religion, or political ideas and ambitions, or the worth or viciousness of those ideas and ambitions. He went on to say, quote, European states in the early 21st century move into a trajectory of demographic and cultural decay, population transfer and replacement by a kind of reversed colonization. Had you ever read that before?
Nope.
Had you heard it before?
Nope, not to my recollection.
Could you distinguish what he said with what Congressman Steve King said?
Senator, I'm not here to answer for Mr. King or for Professor Finnis.
But I'm asking your reaction to these things. Do you feel that what Professor Finnis wrote about purity of culture and such is something that we should condemn or congratulate?
Senator, before I expressed any view on that, I'd want to read it. And I'd want to read it from beginning to end, not an excerpt. And Senator, I've had a lot of professors. I've been blessed with some wonderful professors. And I didn't agree with everything they said, and I wouldn't expect them to agree with everything I've said.
Well, let me ask you this specific one. It was 1993, and you were at Oxford, and this is when you believe you first met this professor. Professor Finnis was tapped by the then Colorado Solicitor General, Timothy Tymkovich, to help defend a 1992 state constitutional amendment that broadly restricted the state from protecting gay, lesbian, and bisexual people from discrimination. During the course of the deposition which he gave in support of that effort, Finnis argued that antipathy toward LGBT people, specifically toward gay sex, was rooted not just in religious tradition, but Western law and society at large. He referred to homosexuality as bestiality in the course of this as well. Were you aware of that?
Senator, I know he testified in the Romer case. I can't say sitting here I recall the specifics of his testimony or that he gave a deposition.
I guess the reason I'm raising this is a man who apparently had an impact on your life, certainly your academic life, and I'm trying to figure out where we can parse his views from your views, what impact he had on you as a student, what impact he has on you today with his views.
Well, and I guess, Senator, I think the best evidence is what I've written. I've written over, well, gosh, written or joined over 6 million words as a federal appellate judge. I've written a couple of books. I've been a lawyer and a judge for 25 or 30 years. That's my record. And I guess I'd ask you respectfully to look at my credentials and my record. And some of the examples I've given you are from my record about the capital habeas work, about access to justice. I've spoken about overcriminalization publicly. Those are things I've done, Senator.
And what about LGBTQ individuals?
Well, Senator, there are, what about them?
Well, the point I made is...
They're people.
Oh,
and,
of course.
You know,
but what you said earlier was that you have a record of speaking out, standing up for those minorities who you believe are not being treated fairly. Can you point to statements or cases you've ruled on relative to that class?
Senator, I've tried to treat each case and each person as a person, not of this kind of person, not of that kind of person, a person. Equal justice under law. It is a radical promise in the history of mankind.
Does that refer to sexual orientation as well?
Senator, the Supreme Court of the United States has held that single-sex marriage is protected by the Constitution.
Judge, would you agree that if an employer were to ask female job applicants about their family plans, but not male applicants, that would be evidence of sex discrimination prohibited by Title VII of the Civil Rights Act?
Senator, I'd agree with you. It's highly inappropriate.
You don't believe it's prohibited?
Senator, it sounds like a potential hypothetical case that might be a case for controversy I might have to decide, and I wouldn't want to prejudge it sitting here at the confirmation table. I can tell you it would be inappropriate.
Inappropriate. Do you believe that there are ever situations where the costs to an employer of maternity leave can justify an employer asking only female applicants and not male applicants about family plans?
Senator, those are not my words, and I would never have said them.
I didn't say that. I asked you if you agreed with this statement.
And I'm telling you I don't.
Thank you. In Wang versus Kansas State, the case involved a cancer-stricken professor. You wrote an opinion that noted that EEOC guidance commands deference, quote, only to the extent its reasoning actually proves persuasive. EEOC's enforcement guidance on pregnancy discrimination provides as follows. Because Title VII prohibits discrimination based on pregnancy, employers should not make inquiries into whether an applicant or employee intends to become pregnant. The EEOC will generally regard such an inquiry as evidence of pregnancy, discrimination, or the employer subsequently makes an unfavorable job decision affecting a pregnant worker. Do you find this instruction to be persuasive?
Senator, there's a lot of words there, and if you're asking me to parse them out and give you a legal opinion, and I fear that you may be, I'd respectfully say I'd have to study it in the course of a judicial case.
Well, let me bring it right down to the operative words, whether employees should or should not make inquiries into whether an applicant or employee intends to become pregnant.
Senator, it sounds like you're asking me about a case or a controversy, and with all respect, when we come to cases and controversies, a good judge will listen. Socrates said the first virtue of a good judge is to listen courteously and decide impartially.
I think you know why I'm asking these questions.
No, this one I don't.
The reason I'm asking is because about your views on pregnancy women in the workplace is because two of your former students from legal ethics and professionalism class last spring wrote to this committee to say how troubled they were by your comments in an April 19th class. It was a gender-targeted discussion regarding the hardship to employers of having female employees who may use maternity benefits. One of these students signed her name publicly to her letter, which is a pretty brave thing to do. That student didn't just make this issue up after you were nominated. Last night, the University of Colorado Law School confirmed that she had voiced her concerns with administrators shortly after your April 19th class, and also confirmed that the administrators told her they would raise this matter with you, though they never actually did so. When we receive information like this, which raises questions about your views and conduct on important issues, I want to get to the bottom of it. I mentioned that to you yesterday in my opening statement, that I would be bringing this up. So I just want to ask you to confirm. Did you ask your students in class that day to raise their hands if they knew of a woman who had taken maternity benefits from a company and then left the company after having a baby?
No, Senator, and I'd be delighted to actually clear this up.
Please.
Because the first I heard of this was the night before my confirmation hearing. I've been teaching legal ethics at the University of Colorado for 7 or 8 years. It's been a great honor and pleasure. I teach from a standard textbook that every professor, well, I don't know if every professor, a number of professors at CU and elsewhere use. It's an excellent textbook, Professors Lerman and Schrag. One of the chapters in the book confronts lawyers with some harsh realities that they're about to face when they enter the practice of law. As you know, and I know, we have an unhappy and unhealthy profession in a lot of ways. Lawyers commit suicide at rates far higher than the population. Alcoholism, divorce, depression are also at extremely high rates. Young lawyers also face the problem of having enormous debts when they leave law school. And that's a huge inhibition for them to be able to do public service, like you and I are so privileged to be able to do. We talk about those things. There is one problem in the book, and I'd be happy to share with you the book and the teacher's manual so you can see for yourself, Senator, which asks the question, and it's directed to young women, because sadly this is a reality they sometimes face. The problem is this: suppose an older partner woman at the firm that you're interviewing at asks you if you intend to become pregnant soon. What are your choices as a young person? You can say yes, tell the truth. The hypothetical is that it's true, and not get the job, and not be able to pay your debts. You can lie, maybe get the job. You can say no. That's a choice too. It's a hard choice. Or you can push back in some way, shape, or form. And we talk about the pros and the cons in a Socratic dialogue so that they can think through for themselves how they might answer that very difficult question. And Senator, I do ask for a show of hands, not about the question you asked, but about the following question. And I ask it of everybody. How many of you have had questions like this asked of you in the employment environment? An inappropriate question about your family planning. And I am shocked every year, Senator, how many young women raise their hand. It's disturbing to me. I knew this stuff happened when my mom was a young practicing lawyer, graduating law school in the 1960s. At age 20, she had to wait for a year to take the bar. I knew it happened with Justice O'Connor. Couldn't get a job as a lawyer when she graduated Stanford Law School and had to work as a secretary. I am shocked it still happens every year that I get women, not men, raising their hand to that question. Thank you for the opportunity to clarify that, Senator.
And I wanted to give you that opportunity. I told you yesterday we'd get to the bottom of this, and I'd give you your chance to tell your side of the story. You made a point yesterday of talking about your 4 heroes, and one of them was Justice Jackson. And I went back to look at some of his cases. I just know of him. I don't know much about him. And I found his dissent in Korematsu. And this was a case which I thought was fascinating because his dissent was not that long, but it had an impact. It was profound. The question, of course, was the military orders in the United States on the treatment of Japanese Americans. Fred Korematsu was caught up in it and was basically told he had no choice. He had to go off to the internment camp, and that whole military directive was challenged in this case. And it was interesting that it was upheld in an opinion by Justice Black, but among the dissenters was Robert Jackson. In his dissent, he said some things that I thought were pretty interesting, and I'd like to ask your thoughts on them. He gave a constitutional condemnation of what he considered the military's racist exclusion orders, but what he articulated in the second half of the opinion is what I'd like to ask you about. He really raised a question about the role of the courts, even the Supreme Court, in time of war, in time of fear, when it came to military orders, and whether the courts and the Constitution were up to it. That was really an amazing challenge to us as a nation of laws. So what do you think about the role of the court challenging the military or the commander-in-chief in time of war? And as Senator Graham reminded us, many people believe we are at war, and I believe you confirm that as well. Are we up to it in terms of constitutional protection and the role of the court?
We better be. Senator, a wise old judge, kind of like Judge Johnson, you're going to hear from. He's going to come talk to you from Colorado, and a hero of mine. Known me since I was taught. He taught me that the test of the rule of law is whether the government can lose in its own courts and accept the judgment of those courts. That doesn't happen everywhere else around the world. We take it for granted in this country. It's a remarkable blessing from our forefathers. And it is a daunting prospect as a judge to have to carry that baton. And to do it on the Supreme Court of the United States is humbling, that prospect to me. I pledge to you that I will do everything I can to uphold the Constitution and the laws as a good judge should at all times.
Let me ask you about another case that's been referred to. Yesterday, many of us left Al Madden sitting in that truck. It was about 3 in the morning on I-88 west of Chicago. I've driven it many times. It was in January. The temperature in the cab was 14 degrees below zero. He had no heater in his cab. His dispatcher had told him, sit tight. You either drag that trailer with the frozen brakes behind you out onto that highway, or you wait. And so he waited for hours, and finally, feeling numb and life-threatening, he unhitched the trailer and took his tractor to a place for some gas and to warm up, and then returned to it when they fixed it. 7 different judges took a look at those facts and came down on Al Madden's side, except for one, you. Why?
Senator, this is one of those that you take home at night. The law said that the man is protected and can't be fired if he refuses to operate an unsafe vehicle. The facts of the case, at least as I understood them, was that Mr. Madden chose to operate his vehicle, to drive away, and therefore wasn't protected by the law. He would be protected if he refused to operate, but he chose to operate.
But
now, Senator,
you know the distinction, though, because his dispatcher had told him, don't leave unless you drag that trailer.
right.
And he said, I can't do it. It's, you know, the brakes are frozen. And they went out there at 14 below and unhitched that trailer, he thought, because he was in danger. And when you wrote your dissent in this, you said it was an unpleasant option for him to wait for the repairman to arrive.
I said more than that, Senator.
I know you did. And you went on to say that you thought that the statute, which we thought protected him, you said, especially ends in the ephemeral and generic phrase, health and safety. You went on to write, after all, what under the sun, at least at some level of generality, doesn't relate to health and safety? We had a pretty clear legislative intent for a driver who feels he's in danger of his life, perhaps, and you dismiss it. The only one of 7 judges, and say, no, you're fired, buddy. And you know he was blackballed from trucking because of that. Never got a chance to drive a truck again.
Senator, all I can tell you is my job is to apply the law you write. The law as written said that he would be protected if he refused to operate. And I think by any plain understanding, he operated the vehicle. And if Congress wishes to revise the law, I wrote this. I said it was an unkind decision. I said it may have been a wrong decision, a bad decision. But my job isn't to write the law, Senator. It's to apply the law. And if Congress passes a law saying a trucker in those circumstances gets to choose how to operate his vehicle, I will be the first one in line to enforce it. I've been stuck on the highway in Wyoming in a snowstorm. I know it's involved. I don't make light of it. I take it seriously. But, Senator, this gets back to what my job is and what it isn't. And if we're going to pick and choose cases out of 2,700, I can point you to so many in which I have found for the plaintiff in an employment action or affirmed a finding of an agency of some sort for a worker or otherwise. You know, I'd point you to, for example, WD Sports or Casey, Energy West, Crane, Simpson versus CU. It's just a few that come to mind that I've scratched down here on a piece of paper.
Judge, we up here are held accountable for our votes. And I've been in Congress for a while, and I've cast a lot of them. Some of them I'm not very proud of. I wish I could do it all over again. I made mistakes. But your accountability is for your decisions, as our accountability is for our votes. And if we're picking and choosing, it's to try to get to the heart of who you are and what you will be if you're given a chance to serve on the Supreme Court. I'd like to go, if I can, for just a moment, to this famous case, which you and I discussed at length, Hobby Lobby. I still struggled all the way through this, and it was a lengthy decision, with trying to make a corporation into a person. Boy, did the court spend a lot of time twisting and turning and trying to find some way to take RFRA and say that Congress really meant corporations like Hobby Lobby when they said person. It was dictionary law and so many different aspects of this. What I was troubled by, and I asked you then, I'll ask you again. When we are setting out, as that court did, to protect the religious liberties and freedom of the Green family, the corporate owners, and their religious belief about what's right and wrong when it comes to family planning, and the court says that's what will decide it, what the Green family decides when it comes to health insurance, you made a decision that thousands of their employees would not have protection of their religious beliefs and their religious choices when it came to family planning. You closed the door to those options in their health insurance. And by taking your position to the next step, to all those who work for closed-end corporations in America, 60 million people had their health insurance and their family planning and their religious belief denigrated, downsized to the corporate religious belief, whatever that is. Did you stop and think when you were making this decision about the impact it would have on the thousands and thousands, if not millions, of employees if you left it up to the owner of the company to say, as you told me, there's some kind of family planning I like and some I don't like?
Senator, I take every case that comes before me very seriously. I take the responsibility entrusted in me in my current position very grave. I think if you ask the lawyers and judges of the 10th Circuit, am I a serious and careful judge? I think you'll hear that I am. I'm delighted to have an opportunity to talk to you about that decision. As you know, in RFRA, the Religious Freedom Restoration Act, Congress was dissatisfied with the level of protection afforded by the Supreme Court under the First Amendment to religious exercise. The court, in a case called Smith versus Maryland, written by Justice Scalia, said any neutral law of general applicability is fine. That doesn't offend the First Amendment. So laws banning the use of peyote, Native Americans, tough luck, even though it's essential to their religious exercise, for example. All right. This Congress decided that that was insufficient protection for religion. And in a bill sponsored by Senator Hatch, Senator Kennedy, Senator Schumer when he was in the House, wrote a very, very strict law. And it says that any sincerely held religious belief cannot be abridged by the government without a compelling reason, and even then, it has to be narrowly tailored. Strict scrutiny, the highest legal standard known in American law. Okay. I've applied that same law, RFRA and RLUIPA, their companion statutes, to Muslim prisoners in Oklahoma who seek halal meals, to Native Americans who wish to use an existing sweat lodge in Wyoming, and to Little Sisters of the Poor. Hobby Lobby came to court and said, we deserve protections too. We're a small family-held company, small number of people who own it, I mean. They exhibit their religious affiliations openly in their business. They pipe in Christian music. They refuse to sell alcohol or things that hold alcohol. They close on Sundays, though it costs them a lot. And they came to court and said, we're entitled to protection too under that law. It's a tough case. We looked at the law, and it says any person with a sincerely held religious belief is basically protected except for strict scrutiny. What does person mean in that statute? Congress didn't define the term. So what does a judge do? A judge goes to the Dictionary Act, as you alluded to, Senator. The Dictionary Act is an act prescribed by Congress that defines terms when they aren't otherwise defined. That's what a good judge does. Doesn't make it up. Goes to the Dictionary Act. And the Dictionary Act, Congress has defined person to include corporation. So you can't rule out the possibility that some companies can exercise religion. And of course, we know churches are often incorporated. And we know nonprofits, like Little Sisters or hospitals, can practice religion. In fact, the government in that case conceded that nonprofit corporations can exercise religion. Conceded that. So that's the case. Then we come to the strict scrutiny side. Right?
I don't want to cut you off.
Oh, I'm sorry.
I'm going to get in big trouble with
Oh, I don't want to get you in trouble.
Iowa here.
I think I would want you to continue your answering his question.
I'm sorry, Mr.
No,
Chairman. I
please,
apologize.
no, I want you to continue.
Okay, all right. And so then you've got the religion, the first half of the test met, right? So then you go to the second half. Does the government have a compelling interest in the ACA in providing contraceptive care? The Supreme Court of the United States said, we assume yes. We take that as given. And then the question becomes, is it narrowly tailored to require the Green family to provide it? And the answer there the Supreme Court reached and precedent binding on us now, and we reached an anticipation, is know that it wasn't as strictly tailored as it could be because the government had provided different accommodations to churches and to other religious entities. The Greens didn't want to have to write down and sign something saying that they were permitting the use of devices they thought violated their religious beliefs. And the government had accommodated that with respect to other religious entities and couldn't provide an explanation why it couldn't do the same thing here. That's the definition of strict scrutiny. Now, Congress can change the law. It can go back to Smith versus Maryland if it wants to, eliminate RFRA altogether. It could say that only natural persons have rights under RFRA. It could lower the test on strict scrutiny to a lower degree of review if it wished. It has all of those options available, Senator. And if we got it wrong, I'm sorry. But we did our level best, and we were affirmed by the United States Supreme Court. And it's a dialogue, like any statutory dialogue, between Congress and the courts.
Thank you, Judge. Thank you, Mr. Chairman.
Senator from Texas.
Thank you, Mr. Chairman. Before I start, yesterday in my statement I mentioned an op-ed in the New York Times written by Neil Gorsuch. My apologies to him if I butchered his name. With a name like Cornyn, I'm used to it, but I apologize.
I get a lot worse.
Entitled,
I got a lot worse the other day.
The title of the op-ed is Why Liberals Should Back Neil Gorsuch. I'd like to ask consent that this be included in the record along with other supportive letters.
Without objection, all documents will be included.
So, Judge, I have a pretty basic question for you. Does a good judge decide who should win and then work backward to try to justify the outcome?
That's the easiest question of the day, Senator. Thank you. No. And I have to correct myself. Senator Durbin, it's not Smith versus Maryland. That's third-party doctrine. It's Employment Division versus Smith that we're talking about. I apologize to you for that.
Well, I'm glad to hear you answer my question the way you did. I expected that you would. But that seems to be implied in some of the questioning that you're getting. You look at who the litigants are and who you would like to win, the little guy, as we've heard, and I'll get to that again in a minute, and then go back and try to justify the outcome. But I agree with you. That's not what good judges do. I want to return briefly to, I know, something you've talked to Senator Feinstein and Senator Durbin about, again, just to give you every opportunity to make sure this is crystal clear. I remember back when George W. Bush was President of the United States, there was a practice of signing statements that went along with his signing legislation into law that was criticized by some of our friends on the other side of the aisle as somehow undermining Congress's intent or the President's own signature enacting a bill into law. And so Senator Feinstein raised the question of back when you worked with Senator McCain, Senator Graham on the Detainee Treatment Act, the signing statement that the President ultimately issued that went along with his signing that legislation into law. Did I characterize that correctly?
I think so, Senator, to the best of my recollection.
Okay, so the question is this, Judge. There were some in the administration who wanted a single statement, basically that the President was signing the law, but, you know, if you could find an argument that the President didn't have to pay attention to the law, or perhaps had authorities that weren't otherwise laid out in the statute, that the President could disregard what Congress had passed and what the President had signed into law. On the other hand, there were those like you in an email who laid out the case for a more expansive signing statement. You made the point that on the foreign public relations front, allowing us to speak about this development positively rather than grudgingly would be helpful. You said that while we all appreciate the appropriate limitations of the usefulness of legislative history, it would be helpful as this provision is litigated, which it inevitably would be, to have a statement of policy from the executive branch on why this law was enacted. And third, that you said it would help inoculate against the potential of having the administration criticized in the future for not making sufficient changes, when in fact all the bill did was to codify existing law with regard to interrogation practices. Senator McCain made that comment. So you, at least, I guess, I hate to put it in these terms, you lost that argument in a sense because the vice president's lawyer prevailed in that argument, and they had a single statement in the signing statement basically making reference to, well, it's here, I'll just read it. It said, the executive branch shall construe Title 10 of the Act in a manner consistent with the constitutional authority of the president to supervise the unitary executive branch and as commander-in-chief and consistent with the constitutional limitations on judicial power. So that's the statement in the signing statement that you sought to make more expansive and accommodate the three concerns that you raised. Isn't that correct?
Senator, your understanding of events is a lot fresher than mine, but I sitting here, I can't disagree with you, anything you've said.
Well, and I understand this was, what, 12 years ago?
Something like that.
And you were asked questions initially by Senator Feinstein without the benefit of actually being able to refresh your memory from reading the emails. But I think we've covered that enough, I hope, and laid that to rest. I want to talk a little bit about the little guy. You know, in these confirmation hearings, sometimes very complicated and complex issues are dealt with in a rather simplistic and misleading sort of way. But first of all, I want to talk to you a little bit about an article that you wrote in the Judicature magazine called Access to Affordable Justice. And I know, as somebody who's actually practiced law in the trenches, as you said you have, and you did, you were concerned and write in this article about your concerns for access to justice for the little guys and little gals, I guess. And you point out that litigation has become so expensive and so time-consuming that essentially it was out of reach. Justice in our courts of law to resolve legitimate disputes was out of reach for people of modest means. Could you expand on those concerns that you raised in that article?
I really appreciate this opportunity and venue to be talking about these things, because these I care about and I can talk about as a judge. I wrote that article in conjunction with some input from a lot of wonderful people, so I can't take total credit for it. And I thank them, and you can see who I thank. My point there was threefold, starting with the fact that too few people can get to court with the legitimate grievances today. That's a fact. Too few people can get lawyers to help them with their problem. I teach young folks law who leave law school unable to afford their own services. Think about that. Think about that. And hundreds of thousands of dollars in debt. How do they go be Main Street lawyers? How do they help people who need legal services? And I pointed to three potential sources of problems where we lawyers maybe should look internally rather than blame others for the problem. There's plenty of blame to go around. I'm not a big blame guy. But I am a look inside guy. And what do I see in our profession? There are three things I pointed to in that article. First, our own ethical rules. It's a very unusual profession where we're allowed to regulate ourselves. It's quite an extraordinary privilege. Usually it's the legislature, right? But lawyers basically regulate themselves. And do all of our ethical rules necessarily help our clients? Or do some of them help us more than they help our clients? And I point to some that, for instance, regarding the unauthorized practice of law. Why is it you have to be a lawyer to help parents with disabled children in administrative proceedings to seek relief under IDEA? Was an example I pointed to. Why is it that every time certain companies that provide online legal services for basic things get sued every time they move into a new state? Why is it I can go to Walmart and get my hair, teeth, eyes taken care of, but I can't get a landlord-tenant contract drawn up. Those are all results of our ethical rules. And I'm not sure whether they're worth the price that we pay for them. It's estimated, I've heard, I can't verify it, that our ethical rules result in a $10 billion a year surplus to lawyers from clients every year. That was one. Number two was our own rules of procedure, which yield cases like the one we talked about that took 25 years to resolve. That's wrong. That's wrong. Should be able to resolve cases in less time than it takes for my law clerks to be born, raised, and get through law school. And the third thing I pointed to was our legal educational system, where we have 3 years of postgraduate education for everybody who wants to have anything to do with lawyering. The best lawyer in the country in this history came from your state, Senator Durbin, and he didn't ever go to law school. And he always said the best way to become a lawyer, read the books. Still true. And other countries around the world don't have 3 years of postgraduate legal education. Now, this is where Justice Scalia and I, this is a disagreement. He thought 3 years was necessary for everybody. I'm not convinced. In England, where I studied, you could become a lawyer through 3 years of an undergraduate degree, or 1 year as a postgraduate degree, all followed by a lot of on-the-job practical training. And I wonder whether all that debt is worth it, or whether it induces people to pick jobs that they have to pick to pay their debt, rather than to serve the people they'd like to serve. Those are the problems I talk about in that article.
Judge, you make this statement that the rules sometimes yield more nearly the opposite of their intended result. Expensive and painfully slow litigation that itself is a form of injustice. Can you think of many things more unjust for people of modest means in America than being denied access to the courts because our system is so expensive and so time-consuming they just simply can't afford it?
I think it's a problem when 80% of the American College of Trial Lawyers, the best lawyers in the country, arguably, they certainly think they are. Sorry. When the 80% of them say that good claims are priced out of court, and 70% of them say that cases are settled based on the litigation costs rather than the merits of the litigation. That's a problem run both ways. And these are lawyers who operate on both sides of the V.
So basically, you either have to be able to pay a lawyer's hourly rate, or you have to agree to some contingent fee arrangement. And lawyers aren't going to take a contingent fee case unless there is at least some reasonable prospect for their being compensated out of any settlement and judgment, ordinarily.
Ordinarily, some do. What we're seeing today, though, Senator, is an explosion of pro se, that is, filings by the person without a lawyer. And that's what I was trying to address there. I do think access to justice, in large part, means access to a lawyer. Lawyers make a difference. I believe that firmly. My grandpa showed that to me, what a difference a lawyer can make in a life.
Judge, let me ask you about another case involving the little guy. This was an immigration case that you'll recall was a conflict between two provisions of immigration law, Gutierrez-Bruzella versus Lynch. I hope I pronounced that approximately correctly. Do you recall the case?
I do, and we talked a little bit about it with Senator Feinstein. And
well, and
I'm
happy to hear it again because I believe it was Senator Feinstein, maybe I'm mistaken there, or maybe one of our other colleagues, I apologize if I misstated that talked about this deference to administrative agencies as being necessary and a fundamental doctrine. But can you explain how that ended up hurting the little guy in that case?
So, Senator, in that case, there were two statutes that this undocumented immigrant faced. He was trying to remain in the country. One statute said that he had the right to apply for immediate discretionary relief from the Attorney General. No promises about the outcome, but he could at least apply to the Attorney General. The other statute seemed to suggest that he had to wait 10 years out of the country before he could seek relief. Now, I'm not criticizing Congress's handiwork here, okay? But those two statutes appeared a little in conflict. So the case came to our court in the first instance, and our court held that the first statute trumped, that the man had a right to apply for immediate discretionary relief and didn't have to wait 10 years out of the country. And then some number of years later, I can't remember whether it was 3 or 4, I want to say, don't hold me to that, the Board of Immigration Appeals, in its infinite wisdom, comes back and says, we're wrong. Court of Appeals got it wrong. The 10-year statute trumps. Okay. Says, though, that we're not just wrong, but we're wrong retroactively. So it's as if our decision never existed. And this man, who had relied on our holding to apply for immediate discretionary relief, was denied the opportunity to do so and told now he had to go start his 10-year waiting period. Now, instead of 10 years, it's now equivalent of, what, 13 or 14 years. And to me, that just seemed like he had the rug pulled out from underneath him. And I think a person in this country should be able to rely on the law as it is. And it's a matter of due process and fair notice. When he's told that that's the law, he should be able to rely on it. And I also think it's a separation of powers question. When, with all respect, a bureaucracy can overrule neutral, dispassionate judges on the meaning of a law based on their political whims at the moment. That's a separation of powers issue, I think. And maybe an equal protection issue, too, because a political branch can single out people for disfavor. Judges are sworn to treat every person equally in that Vermont marble.
And in this case, the little guy was actually relying upon a judgment of a court of law.
Yes, he
and was effectively, or at least the attempt was, to overrule that court decision by an administrative regulation or interpretation. Is that correct?
Yes.
And if you had applied the Chevron test, we've talked about that a little bit, said that if it's ambiguous, the statute's ambiguous, and the agency's interpretation is a legal one, then you're obligated to enforce the agency decision rather than the judgment of the court of law.
Senator, we did apply the Chevron case faithfully because we had to. And I also wrote separately to ask questions because I'm a circuit judge. And, I never dreamt I'd be sitting here, I can tell you that, when I wrote this opinion. And part of my job as a circuit judge is to tee up questions from my bosses. And it struck me, here's a question. Is this result consistent with the Administrative Procedures Act, which says in Section 706 that we're supposed to defer to agencies when it comes to questions of fact, to the scientists, to the biologists. But when it comes to questions of law, APA Section 706 entrusts courts to decide what the law is. And is this consistent with our values of equal protection, due process, and separation of powers? Those are questions I raised, Senator, to tee up for my bosses.
So you actually applied the Chevron test in your judgment,
Senator,
but wrote a separate opinion raising these questions perhaps for review by the Supreme Court.
I follow precedent.
Sounds like it, even when you disagree with the outcome.
Well, no, we got to an outcome we could live with there too, Senator, and applied Chevron. But I did raise it in the separate concurrence to raise these questions. And, I don't know how I'd rule if I were a Supreme Court justice on the question. I got to be honest with you, Senator Cornyn, because I'd want to do what a good judge does. Keep an open mind, read the briefs, and I could change my mind. I think here of my old boss, Dave Centel, who when I clerked for him, he wrote a panel opinion going one way at the beginning of the year, and by the end of the year, he wrote an en banc opinion for the full court, reversing his own panel opinion. Now, some people say that's a man who doesn't have a spine, something like that. I say that's a judge with an open mind.
Well, speaking for myself, the idea that agencies unelected bureaucrats have the latitude to interpretate their own legal authorities, if the Congress is ambiguous and their interpretation is deemed reasonable, is a troubling concept. Because if there's one part of the federal government that is completely out of control of the regular voters in this country, it is the bureaucrats who don't stand for election, like members of Congress do. And so I hope it's something that we legislatively can look at as a way to help rein in the regulatory state, which, in my humble opinion, has gotten out of control. Let me talk to you about the Establishment Clause, if I may. I firmly believe the Supreme Court has lost its way in limiting religious expression in this country. That's my opinion. And part of my conviction stems from an experience I had 20 years ago when I had a chance to argue before the United States Supreme Court. I had that chance 2 occasions when I was Attorney General of Texas. This case was called the Santa Fe Independent School District versus Doe. The school district in southeast Texas around Galveston had a practice before football games of inviting a student to offer a prayer or a poem or maybe just an inspirational thought before the football game. They got sued by the ACLU, and that case ended up going to the United States Supreme Court, where the court held by a vote of 6-3 that student-led prayer was unconstitutional. That led the late Chief Justice Rehnquist to make the statement that rather than neutrality toward religious expression, that the court now exhibits, quote, hostility to all things religious in public life. We don't seem to have many limits on expressions of sex, violence, or crime in the public square, but we do seem to have compunctions about religious expression in the public square. And I wonder if you could just talk to us a little bit about your views, not prejudging cases, but the sorts of considerations that you believe the founders, for example, had in mind. And of course, as I'm asking you the question, I'm already thinking through my head here. I'm not asking you to prejudge any future case, so let me give you the latitude to answer the question any way you deem fit. But I have to tell you, I'm very troubled by what Chief Justice Rehnquist called hostility to religious expression in the public square and what that's done to change our country, not in a good way.
Senator, I appreciate your thoughts, and it's a very difficult area doctrinally, because you have 2 commands in the First Amendment that are relevant here. You have the Free Exercise Clause on the one hand, and you have the Establishment Clause on the other. So you're guaranteed free exercise of religion, and you're also guaranteed no establishment of religion. Those 2 commands are in tension, because to the extent we accommodate free expression, at some point, the accommodation can be so great that someone's going to stand up and say, you've established, or you've passed a law respecting the establishment of religion, right? It's a spectrum, and it's a tension. And in so many areas of law, judges have to mediate 2 competing and important values that our society holds dear. The court has struggled in Establishment Clause jurisprudence to provide a consistent and comprehensive test. I think that's a fair statement. The current dominant test is called a Lemon test, and it asks whether the intent is to establish a religion, promote a religion, whether the effect is to help advance a religion, and whether there's too much entanglement between state and religion. It's proved a difficult test. Of according to 6 justices at least, have expressed dissatisfaction with this test, but never at the same time. So lemon endures. And academics have thoughts about various options and alternatives, I know, and the justices themselves have expressed various and sundry ideas. I can tell you as a lower court judge just trying to faithfully do what the Supreme Court wants us to do, it's a bit of a challenge in this area. We struggle along.
Well, just as one citizen to another, let me tell you, I think it's a morass. And unfortunately, the result is, like Chief Justice Rehnquist said, hostility to religious expression in the public square, and I think our country is poorer for it. My final topic, at least for this round, let me ask you a little bit about originalism and textualism. Our mutual friend, Brian Garner, mentioned to me that textualism isn't the same thing as being a strict constructionist. I know we use that phrase, at least colloquially, some. But if a judge isn't going to be bound by the text of the Constitution or the text of a statute, what is a judge going to be bounded by?
Well, Senator, I hope it isn't what he had for breakfast. And, you know, when I was a lawyer, all I wanted was a judge who put all of his personal things aside, her personal views, and come to the law and the facts in each case fairly. And I do think when we're talking about interpreting law, there's no better place to start than the text. And maybe here I have to blame Sister Mary Rose Margaret. She taught me how to read, and she taught me how to diagram a sentence. And it was under pain of the hot seat paddle, which hung above her desk for all to see. I used to say she could teach a monkey how to read. I think she did. Me. And I think that's where we want to start for a couple of reasons with the text of the law. First, we go back to the due process considerations, the fair notice considerations we spoke of earlier. Before I put a person in prison, before I deny someone of their liberty or property, I want to be very sure that I can look them square in the eye and say, you should have known. You were on notice that the law prohibited that which you're doing. I don't want to have Tim say, how am I supposed to tell? I need an army of lawyers to figure that out. Some people can afford armies of lawyers. Most Americans can't. It's a matter of fair notice and due process. And the other part, again, is separation of powers considerations. If I start importing my feelings, if I treat statutes or laws as Rorschach inkblot tests, I've usurped your role. I've taken away the right of self-government by the people, for the people. Took a jog to the Lincoln Memorial the other morning before the start of all this. Second inaugural address. Right. There it is. Believe in government for the people, by the people. Well, maybe that's the, gosh, is that the, it's the Gettysburg Address, isn't it? I read them both. Thank you, Senator. It's the Gettysburg Address. It's the Gettysburg Address.
Well, Judge, let me ask you, I'm sorry to interrupt you.
No, I'm sorry. It's just a matter of separation of powers. It's not my job to do your job.
Well, what sort of escapes me is if people who argue that somehow judges aren't bound by the text of a statute, it is the text of a statute that Congress votes on. So how in the world, if it's something else other than the text that ought to direct the outcome, how can anybody have that kind of fair notice that we depend upon so people can align their affairs consistent with the law?
Right. And it isn't a matter of strict construction. Strict construction, in my mind, sounds like I'm putting the finger on the scale toward a particular interpretation, maybe even a pro-government interpretation. I don't see it that way at all. A judge should try and reach a fair interpretation, what a reasonable person could have understood the law to mean at the time of his actions. That's a pretty good starting place for fair notice and for separation of powers, I think, Senator.
Thank you. Thank you, Judge.
Thank you.
Thank you, Chairman. Let me ask unanimous consent to put into the record a letter from over 100 groups dated March 14th, 2017 regarding what they describe as Judge Gorsuch's troubling money and politics record, and a letter from Demos dated March 9th, 2017 urging opposition to Judge Gorsuch's confirmation, and a New York Times article captioned, "Neil Gorsuch has web of ties to secretive billionaire."
Without objection, all three documents will be included.
Thank you. Before we get into that, Judge, let me, since we were talking about separation of powers, could you just reflect on whether the constraint that an appellate court is obliged to take the findings of fact as lower courts have found them and can't indulge in its own fact-finding or fact-making, does that have a separation of powers element to it in terms of constraining the free-range wanderings of a court that could make up its own facts and then go in that direction?
I haven't thought about that, Senator, to be honest with you. I know.
How about the question presented? Should the Supreme Court, in the question presented, try to keep the question narrow to the case presented so that it's not using an expansive question presented to enable itself to wander throughout the legal landscape beyond the constraints of the case?
Senator, it's generally, as you know, on the facts, the practice of an appellate court not to review or overturn the facts of a trial court except in the presence of clear error.
Very rare, yeah.
And that's a very important standard.
Yep.
It may have, I haven't thought about it in separation of powers, but it's a very important principle that I take seriously. I was a trial lawyer for a long time.
And in terms of the constraint to narrow the question, does that have separation of powers overtones as well?
And I give you kind of a similar answer on that, Senator. I don't know about that, but I would say it's an important general practice. Sometimes there are exceptions that a court can and should go beyond a question presented, but it's pretty rare. Usually we stick within, well, we don't have, the questions presented are whatever the parties present to us on an intermediate court. They get to choose. We don't get to choose.
That's part of what separation of powers is about in terms of constraining the judicial branch to actual cases and controversies, correct?
Well, we generally refrain from examining arguments that haven't been adequately developed or made for risk of improvident mistakes.
Now, let me turn to another topic. Let's talk for a minute about money. And in particular, let's talk about dark money. Are you familiar with that term?
In the loosest sense.
How would you describe it in the loosest sense, just to make sure you and I are on the same wavelength?
Senator, as I understand it, you may be referring to money that's not spent by a candidate or a party in connection with...
And where you actually don't know who the true source of the money is.
Okay.
Is that a fair enough definition for us to
Sure.
agree on? Okay. Could you let us know first what you know about the campaign that is being run to support your confirmation? There's been a lot of talk about how this is outside of politics and we're above politics, but there's a group that is planning to spend $10 million on TV ads in which their own press release describes as a comprehensive campaign of paid advertising, earned media, research, grassroots activity, and a coalition enterprise, all adding up to the most robust operation in the history of confirmation battles. That sounds pretty political to me, and I'm wondering what you know about that.
I've heard a lot about it, Senator, from you, from others. I've heard a lot about it.
Do you know, what do you know about it?
I know that there is a lot of money being spent in this by, as I understand it, both sides. I think.
Well, I wouldn't leap to that conclusion at this point.
Okay. I know what I've read. I know what I've heard from friends and family and acquaintances. I know what you're saying, what you've just indicated, that there appears to be a lot of money being spent.
Do you know who's spending the money?
Senator, I could speculate based on what I've read and what I've heard, but I don't know individuals who are contributing. I don't know that.
Do you know if your friend Mr. Anschutz is contributing?
I don't know.
Do you think that it should matter who is contributing? Do you think that there's a public interest in the public knowing who is contributing?
Well, Senator, I think we've got a long tradition from in Buckley versus Vallejo, indicating that this body has robust authority to regulate disclosure.
Yeah, but my question is, do you think there's a public interest
Senator,
in disclosure of political funds in a democracy? That's, I don't think, a prejudgment. That's just a values proposition, and one of the considerations that you ought to be able to answer without much hesitation.
And Senator, what I'm prepared to say is I recognize that as a matter of First Amendment interests, the Supreme Court has validated the proposition that disclosure serves important functions in a democracy. At the same time, the Supreme Court's also acknowledged that those disclosure functions can sometimes themselves have unintended consequences, as with the NAACP case, which I know you're familiar with, where you can use disclosure as a weapon to try and silence people. And we have a long history in this.
Hardly the case with respect to the dark money operation that is funding this campaign in your favor, is it?
Senator, I'm not prejudging any case. What I am suggesting to you is that there are interests here in this area of First Amendment disclosure. That's what we're talking about, in my mind, generally, okay, that are competing. On the one hand, in order for informed voters and citizens to be able to make decisions, the Supreme Court in Buckley has validated the interest that this body has in regulating disclosure.
And in theory, so did the court in Citizens United.
And in theory, in Citizens United. At the same time, the courts also recognized in NAACP, for example, that disclosure can be used as a weapon to silence voices. And we have a long history of anonymous speech serving valuable functions in this country.
So here's a live example right now. We have this $10 million that is being spent on behalf of your confirmation. Do you think, for instance, that we on this panel ought to know who is behind that? And, well, answer that, and then I'll go on to a related question.
Senator, that's a policy question for this body.
Well, it's also a question of disclosure. You could ask right now that as a matter of courtesy, as a matter of respect to the process, that anybody who is funding this should declare themselves so that we can evaluate who is behind this effort.
Senator,
right? That wouldn't be a policy determination. That would be your values determination.
It would be a politics question. And I'm not, with all respect, Senator, going to get involved in politics. And if this body wishes to pass legislation, that's a political question for this body. And there's ample room for this body to pass disclosure laws for dark money or anything else it wishes to, and it can be tested in the courts. So, Senator, with all respect, the ball's in your court.
Do you really think that a Supreme Court that decided Citizens United doesn't get involved in politics?
Senator, I think every justice on the Supreme Court of the United States is a remarkable person trying their level best to apply the law faithfully.
And they got deeply involved in politics, did they not? They changed the entire political environment, the entire political ecosystem with one decision. You must recognize that.
Senator, it's a precedent of the United States Supreme Court. There were thoughtful opinions by justices on both sides.
I didn't say that they weren't thoughtful. I was responding to your question that your response that they don't get involved in politics. What could be more involved in politics than to open this ocean of dark money that's flooded into our politics?
Senator, what I mean to suggest is that I believe every justice on that court is trying to apply the First Amendment and the laws of this country faithfully. You may disagree with them. Many people do. I understand that. It's hard. Judges make half the people unhappy 100% of the time. That's our job description. And people do criticize judges. I understand your criticism. But I do not question their motives, Senator.
This is a little different. I think you see more like 90% of the public unhappy with Citizens United because they see the problem that it caused in our democracy. And in that case, it wasn't just a question of two parties and you're going to make one of them angry because you decided for the other. This is the Supreme Court operating in its role as the legal constitutional guide to the operation of American democracy. And if they get that wrong, that is a much, much bigger deal, whether their motivations were pure or impure. When or whether they got that wrong is a bigger question than just which party won. Wouldn't you agree?
Senator, if a court errs as a matter of law, there are various remedies. There is a legislative remedy because there's always another law to be passed and another case to test. Every case comes on its own facts with its own record and can be analyzed anew. And then there's the law of precedent, which we've discussed. I wrote this 800-page book on. Makes a great doorstop, gift for Christmas. I cut a really bad deal on royalties.
And another way is for the court to clean up after itself if it's been wrong.
Yeah, that's what I'm suggesting. There is a way to do that, right? Precedent is not an inexorable command. And so the court can reverse itself. It happens.
If a question were to come up regarding recusal on the court, how would we know that the partiality question in a recusal matter had been adequately addressed if we did not know who was spending all of this money to get you confirmed? Hypothetically, it could be one individual. Hypothetically, it could be your friend, Mr. Anschutz. We don't know because it's dark money. But if you were to ever find that out, or even if you were to have suspicions, I think in any challenge as to whether recusal was appropriate or not, were that to happen, say, in a lower court, these would be facts that would be noteworthy and that we'd be entitled to have an answer to. So it's kind of odd to be sitting here in a United States Supreme Court nomination hearing with a $10 million spend taking place for you out there in the political world and absolutely no idea who's behind it. Is that any cause of concern to you?
Senator, I'm not sure what the question for me is.
Is it any cause of concern to you that your nomination is the focus of a $10 million political spending effort and we don't know who's behind it?
Senator, there's a lot about the confirmation process today that I regret. A lot.
Yeah?
A lot. When Byron White sat here, it was 90 minutes. He was through this body in 2 weeks, and he smoked cigarettes while he gave his testimony. There's a great deal about this process I regret. I regret putting my family through this.
But to my question.
Senator, the fact of the matter is, it is what it is, and it's this body that makes the laws. And if you wish to have more disclosure, pass a law and a judge will enforce it, Senator.
There are going to be, that's just not, that just doesn't do, Judge Gorsuch. There are going to be questions that you will be asked to decide on the United States Supreme Court that are going to be dependent on the values you bring to this. I don't think you can avoid talking about those values here. You're an expert on antitrust law, correct? You're very good at that.
I wouldn't count myself an expert, Senator.
And when you
I've
write
read-
about antitrust law, you understand that there are values to which the law should be directed if it's going to be successful. You've written about the values of competition, that the antitrust law should operate in such a way as to maximize and support competition, and that the antitrust law should be read in such a way as to maximize and support innovation. Those are proper values for a judge applying antitrust law to pursue, are they not?
Senator, a judge applying antitrust law looks to precedent predominantly for guidance as to what
A lower
rule of
judge
decision.
does.
Yes. And so
Supreme
does
Courts, usually it's a new question, otherwise it wouldn't be there for you.
Senator, respectfully, I disagree. Supreme Court justice is bound by precedent, too.
No, but the question likely presented in the case is one that is new. Otherwise, it wouldn't be in the Supreme Court. They would not have taken it for review, and it would have been settled at the circuit or at the district judge level, no?
Senator, the precise question may be new, but the notion that precedent wouldn't bring to bear instructions and information on how it should be decided would be mistaken as well.
I guess what I'm saying is that the part of the decision that is guided by precedent is not the part that I'm asking about. The part that I'm asking about is the values determination, and I'm trying to determine if you think that openness with respect to the money that flows around in our democracy in such large numbers right now is a value that is worth pursuing. Is it a touchstone? Is it a lodestar? Or is it just a burden on people's communication?
Okay, I'd refer you again to Buckley versus Vallejo and NAACP.
I'm asking actually you.
And I'm giving you my answer, Senator, as best I can.
Okay.
Which is the First Amendment, which I'm sworn to uphold as a judge, contains two competing messages here. On the one hand, it has regularly recognized the rights of this body to legislate in this area if it wishes to do so. If it hasn't done so, with respect, that's not my fault, okay? It's on legislators to legislate. And Buckley recognizes their authority. On the other hand, it has recognized there may be limits when it chills expression, as it did in the NAACP case. And we have to be worried about that because there is room in our democracy.
So if we have to be worried about the chilling of expression, which is a value proposition that you have just enunciated, should we not, am I not also entitled to ask the question about whether we should be worried about the influence of dark money essentially corrupting our politics?
Instead of what I'm
taking a lot of time to get what I would think would be a fairly simple answer.
Well, I'm sorry, but I don't think this is simple stuff at all, Senator. I think this is hard stuff. And I think you've got First Amendment concerns and precedents, all right, in the area would have to be considered. We'd have to see what law Congress enacted. I'd then want to go through the full judicial process, Senator. I'd want to read the briefs. I'd want to keep an open mind.
I understand, but you just asserted right here that the value of not chilling speech was something that we should consider, right?
I said the Supreme Court of the United States and NAACP recognized that the First Amendment protections we all as people in this country enjoy,
which is a value that we should consider,
can be chilled.
And
sometimes.
Not chilling is a value that we should consider.
It's a First Amendment right we're talking about, Senator.
And where does an anonymity, let's say $1 billion in anonymous funding into our elections, where does that fit in your into the values that you bring to this?
In the first instance, Senator, it's for this body to legislate.
Yeah.
And then it would come to court, and a record would be made.
Of course, Citizens United did actually overrule a law that we had written, so that's hardly the be-all and the end-all.
Well, it's a dialogue. It's the separation of powers dialogue that we have in all areas. Congress passes a law, a lawsuit's brought, a record's made, a fact finder makes facts, judges determine the law, a ruling is issued, Congress responds, and the cycle continues. And Senator, that's our history. in this area and so many others. Our founders were brilliant. They didn't give me all the power. I don't wear a crown, I wear a robe. They didn't give you all the power.
When it
They
comes
divided
to the determination to state what the law is, particularly in constitutional matters, they actually did give the Supreme Court the power. And that's why it's important to us to ask these questions now before you go on to the Supreme Court and we have no accountability left. And so the values that you bring to that in those areas where you're not just implementing Congress's will, but are bringing your own values to the constitutional document that we treasure, that is why I think these questions are important. Let me ask something slightly different. You said you knew Judge Garland.
I do. I wouldn't claim him as my closest personal friend, but someone whom I admire greatly. And
would you describe, how would you describe any differences that you may have in judicial philosophy with Chief Judge Garland?
I would leave that for others to characterize. I don't like it when people characterize me, and I would not prefer to characterize him. He can characterize himself.
What's interesting is that this group sees a huge difference between you that I don't understand. The dark money group that is spending money on your election spent at least $7 million against him getting a hearing and a confirmation here, and indeed produced that result by spending that money. And then now we have $10 million going the other way. That's a $17 million delta. And for the life of me, I'm trying to figure out what they see in you that makes that $17 million delta worth their spending. Do you have any answer to that?
You'd have to ask them.
I can't because I don't know who they are. It's just a front group. There is it's been, I think, fairly and fully documented that there's a small group of billionaires who are working very hard to influence and even to control our democracy. Kochs, Mercers, DeVoses, and yes, Anschutzes. They often network together. They attend planning conferences. They pool their resources. As a candidate, President Trump made fun of the begathon, to use his word, that the Koch brothers run every year to bring candidates to their conference. They set up an array of benign-sounding front groups to both organize and conceal their manipulation of our politics. And Supreme Court justices socialize with this small group. And then they go and they render decisions that give that small group immense political advantage, particularly the ability to hide the political expenditure of their money. And then they go back and socialize some more with that group. And they even speak at the begathon political retreats. Does that look right to you? How, as a judge, do you think, as a justice of the Supreme Court, should you comport yourself in terms of keeping a distance from interests that are before the court?
Senator, I have no information about anything you've just described. I don't know about that.
And wow, because guess what? You're going to be asked to make decisions on the Supreme Court that, if you don't know that, you're going to have a very hard time figuring out how to make the right call. It's a real concern. You know, this is the first Supreme Court in the history of the United States that has nobody on it who's ever run for political office. Ever. And yet it makes these wild leaps like Citizens United that completely deform democracy. And then I don't know if they don't know what they're doing. I don't know what the motivation is. I don't know. I sure don't know. But I do think it's a concern to be asked to make decisions like that without a real grounding in what's going on around you. Let me ask a little bit just about, to narrow it down more to the judicial branch, what do you think the court's approach should be to the sort of machinery of corporate influence that surrounds the Supreme Court? There are corporate front groups that have been described, I think, very well as the think tank as disguised political weapon that surround the court and constantly pelt it with amicus briefs on behalf of big corporate and industrial interests. At this point, they're in the 5-4 decisions I listed yesterday, their record is 16-0 at the Supreme Court in terms of helping the corporate interests. So it looks like they're doing really, really well, these frequent flyer corporate front amici. When they turn up at the Supreme Court, should they disclose more about whose interests they represent? Would it be good for the reputation of the Supreme Court and for our democracy if people knew who actually funded them when they turn up?
Senator, to your earlier question, I think I can talk about my record. I'm not a philosopher king, but I can talk about my record. And my record is that in the last 10 years, I don't think there's been a single motion to recuse me. I've tried to be very careful in which cases I hear.
This is
and I take that very seriously. It's part of my obligation as a judge. I can't claim I'm perfect, but I've tried awful hard, and I haven't had a motion filed against me because I do take seriously the impartiality and the appearance of impartiality. And Senator, all I can say to you is that I commit to maintaining my impartiality as best I can and to recuse where the law suggests I should.
So back to my question about these amicus briefs and not knowing who's behind the front groups who turn up and pelt the court with the briefs.
Senator, there's a corporate disclosure statement rule, as I recall.
Yeah, but it's not much of a one, because here's what it says. It says that the filers shall identify every person other than the amicus curiae, its members, or its counsel, who made a monetary contribution to fund the preparation or submission of the brief. As you know, the preparation and submission of a brief is not particularly expensive, and the monetary contribution is not ordinarily reported as being the funders of the organization. So if an as I understand it, if an organization gives $100 million to a front group and says, go in there and don't put my name on any of this stuff, but this is what I want you to do, as long as the front group then pays for the brief itself, there's no filing that reports who the interest is behind it. And I worry that we have an operation going surrounding the court, that the court itself is actually blind to the true roots of. And should the court not understand what the interests are behind these front groups?
I think that's a very interesting suggestion, and one I will take to heart, Senator. Obviously, this Congress has a role in rulemaking process as well, and there's a rulemaking committee and a Rules Enabling Act process for the lower courts, and the Supreme Court has its own rulemaking process, and I appreciate that information for both functions.
And as a Supreme Court justice, you'll also have a role in policing the judiciary as the top court. One of the things that's cropped up is special interest training camps, basically, at lush resorts for lower court judges. As much as 40% of the federal judiciary has gone to these special interest funded training sessions, described by one writer as a cross between Maoist cultural re-education camps and Club Med. There's been a wide array of condemnation of this practice from editorialists of all stripes. And is that something, as a matter of kind of protecting the integrity of the courts, to which the Supreme Court should attend itself?
Well, Senator, I know as a sitting judge, I disclose every trip I take that isn't official business that anybody else pays for.
And to your credit, you went to none of these, as far as I can tell.
Thank you, Senator. I appreciate that acknowledgement. I do go to a lot of moot courts and things like that, and and everything I've done is disclosed. So it is all there. You have all the information.
Yeah. I'll just note that some of the editorializing about this, it creates an egregious ethical conflict of interest bordering on wholly improper out-of-court communication with special interest lobbyists or representatives of people who have filed lawsuits. Another said it looks like an interest group has put part of the federal judiciary in its saddle. A third said the conflict is clear and the judge's participation is mind-boggling. And by the way, all of those came from newspapers below the Mason-Dixon line. That's not just Yankee elitist talking. So my time has expired, but I look forward to further rounds, and I appreciate your time with me.
Thank you.
Who am I to tell you how you should answer questions? But if I were sitting where you were and values were brought up, it seems to me it's the Congress that deals with values as representatives of our people, and you look at the law. And when it comes to briefs, I would assume that you don't care who paid for them. You're only interested in what the brief says. Senator Lee.
Thank you, Mr. Chairman, and thank you, Judge. What you're seeing here is the confluence that occurs by operation of the Constitution between law and politics. And you as a textualist understand as well as anyone where the word politics comes from. You break the word down into its two Greek roots. You've got poly, which means many, and ticks, which are blood-sucking parasites. It works out. I'd also like to echo something said by our chairman a moment ago. When we're focused on the identity of the parties, on the identity of those speaking to the court, the identity of those people might matter more if your focus is on their identity. If, on the other hand, your focus is on the law and what the law requires, the focus is likely to be different. Judge Gorsuch, are you a lawmaker?
No, Senator.
Have you ever held position as a state legislator?
No, Senator.
Have you ever held a position as a member of Congress?
Goodness, no.
Have you ever held any public office in a policy-making arena outside the federal judiciary?
I've served on my kids' school board.
Have you?
But that's about as close to policy as I care to get.
You had any role in setting federal, in establishing and making laws governing federal campaign finance?
No, Senator. That's this body's province.
Okay. It seems to me, Judge, that it would be unfair for anyone to state or to imply that you then are responsible somehow for the expressive conduct of third parties who are not you. It would be unfair for me to attribute to you something that someone else is saying. And it would seem to me to be especially unfair to say to you, as a sitting federal judge and nominee for Supreme Court of the United States, to say to you that you have to tell someone else something that they shouldn't say, because otherwise that might cause problems for you when you didn't make the set of laws to begin with. By the way, were you involved in the Citizens United case?
Senator, I was not involved in the Citizens United case, and I appreciate the opportunity to clarify that fact. I'd also like to clarify that nobody speaks for me. Nobody. I speak for me. I'm a judge. I don't have spokesman. I speak for myself.
Thank you for clarifying that for us. Judge, yesterday you referred to the fact that you had some of your law clerks here with you yesterday. I suspect some of them are here today as well. Tell us a little bit about the relationship that exists between a judge and the judge's law clerks. It's more than just a job, isn't it? More than just a job or an adventure. It's sort of part of the legal education experience that many lawyers are able to go through. Is that right?
As your father knew well. It is one of the great joys of this job, and one of the great surprises, right? You practice law for 20 years. You're used to working with pretty senior people, And then all of a sudden, you show up, as I did my first day. There's a pile of briefs waiting in a tiny office that hasn't been decorated. There's a chair. Have at it. And you get to hire 4 brand new young folks straight out of law school who don't know a darn thing. Have at it. Have fun.
Did you acknowledge that when you were a law clerk?
Well, the part of the reason why I'm a judge is because of my experience as a law clerk, a shared experience with the same fellow your dad clerked for, and Byron White, and we used to race writing opinions. And this is the humility of maybe the smartest lawyer I knew. I'm talking about Rhodes Scholar, first in his class from Yale type stuff. And he'd say, first one done with the draft wins. Well, what does it mean to win? Drafting an opinion. That wasn't real clear to me, but he was a pretty competitive guy. And what it meant was whoever got the first draft done, the other one went in the bin and we worked off the draft of the guy who won. I never won. And he could only type with these big paws, these big hands, thick, pulling up sugar beets. And so he'd hunt and peck and he could still beat me. It's a very close relationship. It's an intimate working relationship. And it becomes one of the great joys of your life. You see these young people. Now, I've been out to pasture for 10 years. I thought I was done. That was my life. I love my life. I love my home state. I hope I'm making them proud. And you see these young people come and go, and you get to see what they go on to do. They go on to do such wonderful things. I've had young people go on to clerk for the Supreme Court, about a dozen of them, for justices, all kinds of justices. Justice Scalia and Thomas, Justice Kennedy, Kagan, Sotomayor. And that's a deep and inspiring thing. And you watch them go on beyond that. Some of them are teaching. Kids at Harvard, Vanderbilt, Notre Dame. Some people, young lady who's doing fishery policy in South Africa, doing all sorts of really wonderful things. And it just gives you hope and heart in the future. As I tell my students, somebody has to run the zoo. You want it to be the best and the brightest. And it's so heartening to see these young people, some of whom are first in their family to go to college, immigrants to this country, rise to the very top.
Winston Churchill was known to have said, we shape our buildings and then our buildings shape us. There seems to be a corollary here with law clerks. You shape your law clerks, they end up probably having an influence on you as well. At a minimum, I would think that you develop the kind of relationship with them to where they know you. They know your jurisprudential style. They know your quirks. They know most likely what you like to have for lunch. But you would say there develops a pretty close relationship between a law clerk and the judge during a clerkship. Would you agree with that?
I always think that a family that skis together stays together. We ski together.
Yes. And it's much more true of skiing than snowboarding, I think. Just snowboarding is a lot more painful. And
that's a value judgment I'm happy to make.
Yeah. One of the reasons I ask about this is because I've got some letters that I'd like to introduce for the record. There's a piece written by 3 lawyers who clerked both for Justice Scalia. I tried really hard to think of a great term for this, the Scalia-Gorsuch combo or something like that, but I couldn't come up with anything interesting. But that's a good duo for whom these lawyers have clerked. And they've written a great piece talking about you. It's entitled A Principled and Courageous Choice. I'd like to submit that for the record.
Without objection, it will be included.
They write, Judge Gorsuch's opinions reflect the principle Justice Scalia spent his career defending, that in a democracy, the people's elected representatives, not judges, get to decide what the laws should be, what laws we should have. They go on to say that they believe that you, Judge Gorsuch, will be, quote, as principled, as courageous, and as committed to the Constitution and our country, close quote, as Justice Scalia was. So they go on to urge that we confirm you to the Supreme Court. I'd also like to enter into the record another letter that's written by someone else who clerked for you, Judge Gorsuch, and who also clerked for Justice Kagan on the Supreme Court. He writes, quote, "Gorsuch will make an exceptional Supreme Court justice. He possesses a rare combination of intelligence, humility, and integrity, not to mention a fierce commitment to the rule of law. In fact, he's remarkably similar on these metrics to Supreme Court Justice Elena Kagan." He also goes on to write, quote, "This zeal for the rule of law gives me every confidence that Gorsuch, like Kagan, will stand firm against any effort by the Trump administration to abuse executive power," close quote. He writes that liberals should welcome a nominee like Gorsuch. I'd like to enter this one into the record also, Mr. Chairman.
Without objection, so ordered.
Thank you, Mr. Chairman. Let's move on. One of my colleagues earlier today asked some questions about remarks that you assisted in preparing, remarks that were prepared for delivery by then Attorney General Alberto Gonzales in connection with a Senate Judiciary Committee oversight hearing concerning the terrorist surveillance program. This is a hearing that occurred on February 6, 2006. One of my colleagues referred to this this morning. Are you familiar with what I'm describing?
Very vaguely.
Okay. My understanding is that at the time you were serving as the Principal Deputy Associate Attorney General. Would that be correct to say you were in that position?
Quite a mouthful.
Yes, quite a mouthful. That is why it's commonly known as the PAYDAG, but most people might not immediately recognize the term PAYDAG, as I'm sure they would in your household. So the issue in that hearing, as I understand it, was whether or not this TSP program was unlawful. And you were involved, as I understand it, not on the basis of your expertise in this area, but on the basis of your writing ability, based on the fact that people recognized your ability to write, a talent that has now become apparent to many of us as we've reviewed your judicial writings. You were brought in as a scrivener of sorts, someone who would give voice, so to speak, to what the Attorney General might say, and not based on your expertise of this TSP program. Is that consistent with your recollection of these events?
It is, Senator.
Okay. It's also my understanding that not only were you not thoroughly familiar with this TSP program, but you legally could not have been. It was impossible for you to be familiar with that program for the simple reason that you didn't even have the clearance necessary to know the details of the program, and therefore couldn't speak to those details.
Sitting here, that's my recollection.
Okay. So as a result of that, any work that you did on those prepared remarks would have been done based on your limited understanding, based on a limited set of facts that you were given in preparing it, and then anything you would have done from that moment forward, you would have said, look, I don't know the facts of this, I can't know the facts of this, you all are going to have to fill in the details. I've done the best I can based on assumptions I've drawn and the limited facts I've been given about this program.
Yes, that's my recollection, too.
Thank you. Some of my colleagues have suggested that your rulings reflect a particular bias, a bias in favor of the big guy and against the little guy. It's not always apparent in every case whether there is, in fact, a big or a little party. I suppose in some cases it's open to dispute. In other cases, it might be very apparent that one outpowers the other in terms of economic heft and access to good lawyers and so forth. But I've reviewed your work, and I'd like to say that, yes, in some instances it is easy to identify a party that might thusly be described as little. And I can't discern any bias in your work that favors one type of party over another. In fact, there are a whole lot of cases where you've ruled in favor of the little guy. among those cases was one discussed just a few minutes ago in your conversation with my colleague, Senator Cornyn, in Gutierrez Brizuela versus Lynch. That was a ruling that was most decidedly in favor of a little guy. In fact, it doesn't get much more little guy than a David going against the Goliath that is the federal government. A David who is someone in a very precarious position relative to the federal government against the entity with more money and more lawyers than any enterprise that's ever existed on planet Earth. Other cases in which I know you have ruled in favor of the little guy include, but are by no means limited to, Fisher versus City of Las Cruces, AM v. Holmes, Orr versus City of Albuquerque, Williams versus WD Sports, and Walton versus Powell. Now, these cases do not all fit into a common framework. In fact, they involve a pretty wide range of issues, including cases involving qualified immunity against police officers, cases arising under the Family Medical Leave Act, sex discrimination cases, and cases involving politically motivated firings. So these are just a few examples. But just to be clear, in going into this, as a judge, do you have any bias that you can detect? How do you approach a case? Do you look at a case and say, this person is well represented and powerful, this one is less well represented and not powerful? Does that influence how you approach the law in any case?
Senator, you try to treat each person as a person. We're all just people at the end of the day. And that equal justice promise, the equal protection under law, is the most radical guarantee I'm aware of in the history of human law. The recognition that no one is better than anyone else. And Senator, all I can tell you, here's some facts. These are facts of my record. 97% of the time, out of 2,700 cases, we've ruled unanimously. 99% of the time, I'm in the majority. According to the Congressional Research Service, as I understand it, of the judges studied in the 10th Circuit, my opinions attract the fewest dissents. They're not sure whether it's because I seek consensus or because I'm persuasive. I don't care which it is. My law clerks tell me as well that I'm as likely to dissent from a Democrat as a Republican-appointed colleague. Not that that matters.
Yeah, but by the way, what if this weren't the case? What if you were dissenting in a lot more cases? What if you were a lot more likely to dissent from one type of judge versus another? Would that...
Senator, I know the men and women of the 10th Circuit. I know the judges with whom I serve. I question the motives of none, ever. We disagree sometimes, but when we disagree, it's about the law, not politics. And I think sometimes, really, in this country, we're kind of like David Foster Wallace's fish. He wrote about a fish swimming in an aquarium. And it spends so much time in water and is so surrounded by it that the fish doesn't even realize it's in water. And I feel like sometimes when we nitpick and we complain about the quality of justice in this country, which leaves a lot to be desired, there is much room for improvement. I'm not here to say it's perfect or anywhere close to it. We are a work in progress. But the rule of law in this country is so profoundly good compared to anywhere else in the world that we can complain and know that we're protected because of the rule of law. I think we're a little bit like David Foster Wallace's fish. We're surrounded by the rule of law. It's in the fabric of our lives. So much so we kind of take it for granted. You know, just to go on, you know, my work on access to justice in the Rules Committee and outside the Rules Committee, speaking on it. My work talking about overcriminalization, capital habeas. I've removed judges and lawyers when I've had to, or sought their removal. I believe in our Seventh Amendment jury trial right. I've ruled for the least amongst us when it comes to immigrants. We've talked about a couple of examples. And criminal defendants. I can give you a whole long line of cases I can cite where I've ruled for Fourth Amendment claimants and other criminal defendants. Ford, McCarr, Farr, Gamez Perez, Sabina Umana, Spaulding, Carlos, Ackerman, Kruger. That's just criminal. I've just jotted down here. Environmental cases, Rocky Flats, magnesium, and the renewable energy case. Civil rights, you mentioned Orr, WD Sports, Casey, Energy West, Crane, CU versus Simpson. Those are just some that come to mind.
So does this tell us that you are in fact objective, or does it just tell us that you're really, really good at covering up the fact that you're not objective? I mean, it seems to me that if you were biased and determined to rule only for the big guy, only for large, wealthy corporations, it'd be an awful lot of work to go to in order to rule for the little guy as often as you have.
Senator, I'm not buying into any of that, with respect. With respect, I view my job to be fair. It's what General Cottrell said to you all yesterday. What he wants is a fair judge. That rang true to me when I heard it. I didn't know he was going to say that. That's exactly what I thought when I was a lawyer. I just wanted to go into court and have the judge hear my client. Hear them. Really hear them as a person on the facts and the law, and leave everything else alone, at home, where it belongs. Now that's hard. I'm not here to tell you it's easy, and I'm not here to tell you I'm perfect, okay? I'm a human being. I'm not an algorithm. But I try really hard, and it's almost like an athlete. It's something judges practice. And hopefully we get better at it with time.
And when you say fair, you're not talking about fairness necessarily in some abstract, ethereal sense, in some Solomonic way in which you're just being wise in your own mind. You are being fair in a manner that is consistent with and dictated by your judicial oath. And your oath to uphold and protect and defend and operate within, subject to the constraints of the United States Constitution, a Constitution that puts the power to prescribe laws with prospective general applicability in the political branches of government, in the legislative branch and in the executive branch, insofar as the executive is involved in the lawmaking process, and then insofar as the executive is involved in the execution of those laws. The judicial branch, on the other hand, is there to give effect and meaning to those words, not just based on what is fair in some abstract sense, but also what is fair in the sense that you've got to decide who the decision maker is, who makes the law, and how to give effect to those words. One of the many cases that comes up from time to time is one called Trans Am Trucking versus Administrative Review Board. You wrote in that case, it might be fair to ask whether Trans Am's decision, meaning the decision to fire the driver in question, was a wise or a kind one. But then you say, it's not our job to answer questions like that. So you don't have to respond to this, but let me tell you how I interpret the language that was at issue in that case. As someone who has served as a law clerk in the federal judiciary and as someone who has litigated cases, if I were involved in that case, a case in which the judge wrote those words, I might think to myself, regardless of whether I like the law and regardless of whether I like the decision made by the employer in that case, this is a judge who's bound by the law and is acknowledging as much in his opinion. So I'd like to ask about the law in that case, in the Trans Am trucking case. The applicable statute said that you cannot fire someone for, quote, refusing to operate a vehicle. Is that consistent with your recollection?
Sitting here, that's my recollection.
In that case, the trucker was fired because he operated his vehicle, the vehicle that he was assigned to, against company orders. Is that a fair summary based on what you remember from that case?
Yes, Senator.
So one could argue, and I think one could argue conclusively, and I think it was argued and decided in that case, that this was a fairly clear application of the law. Because if what the law said that the person couldn't be fired for refusing to operate a vehicle, and that statute were being invoked not in a context where the person was fired for refusing to operate a vehicle, but where the person in fact operated a vehicle. Those are two different things, aren't they?
I thought so, Senator. That was my judgment in that case.
Dickens wrote the law as an ass. And sometimes you might encounter cases where that's true. And sometimes you can look at those who make the laws and say, Exhibit A, Your Honor, as to why this law is an ass. But it's not your job to rewrite the law. It's not your job to write it in the first place, and it's not your job to rewrite it after the fact, is it?
I don't believe so, Senator.
You had another case under the same statute that was involved in the Trans Am case. It's a 2007 case called Copart Inc. versus Administrative Review Board. In that case, a trucker had been fired for refusing to drive a truck that he considered unsafe. You wrote an opinion ruling in favor of the trucker and awarding him attorney's fees. Is that right?
Senator, your recollection's better than mine on the attorney's fees issue.
Courts don't always award attorney's fees, but as I recall, the court did in that case. So I don't really understand the argument that some are making or the implication some are trying to raise that you were somehow unfair in the Trans Am case. Because after all, in the Trans Am case, you applied the law. It didn't apply in the way the terminated employee wanted it to apply in that case, but you applied it fairly in the other case. I also wanted to bring your attention to another case that's been mentioned by some of my colleagues, and that's the Wong case. This is a case where a professor with cancer wanted to extend her leave. The university said no, and the professor sued. The panel ultimately concluded that the law required her to show that she could continue to perform her job if the university provided an accommodation, and all the parties in that case agreed that she could not, that she couldn't continue to perform it. That, as I recall, was a unanimous opinion. Is that correct?
So that was another very hard case to go home after. The individual there was sick, very sick, and had been given, I think, 6 months off, I think already, if I remember correctly. And I can't remember whether it was University of Kansas or Kansas State. And then she was asking for another 6 months off. And the university said no. And she sued under the Rehabilitation Act, which prescribes that reasonable accommodations must be provided to workers to perform their essential job functions. But to prevail, they have to show they can perform their essential job functions. And it was undisputed in that case, she just couldn't, through no fault of her own. And the district court said that's just not a claim under the Rehabilitation Act. Maybe for a breach of contract, maybe something else, but not under federal statutory law. That's my recollection sitting here. And my panel, 3 judges, unanimously agreed that that was a correct application of the law in those facts. No one's here to say that love the law in every case and the results it yields. I am here to say that I promise to apply the law faithfully. And I can guarantee you no more and promise you no less than that, Senator, in every case.
If I'm remembering that case correctly, Judge Lucero was on that panel with you. Is that right?
I don't recall.
I will check to make sure. I think he was, and Judge Lucero was not nominated by a Republican president.
Judge Lucero is one of my dear friends and colleagues, and he was appointed by President Clinton. That's true. He's an excellent judge.
So if you were wrong in this case, then so was he. You did write in that case also something that I thought showed a fair amount of reflection on the plight of the plaintiff in that case, writing, quote, "By all accounts, the plaintiff was a good teacher, suffering a wretched year," close quote, indicating that you are aware of her plight. This is hardly the kind of statement made by a judge who is unsympathetic. This is, in context, the kind of statement made by a judge who understands the deeply human context of every case and also understands the deeply sacred nature of the oath you took to uphold and protect and defend the Constitution of the United States and to operate within the constraints of the Constitution. For that, I thank you and I respect you.
Thank you, Senator.
Thank you, Senator Lee. I want to make an announcement that we would take a 10-minute break after Senator Klobuchar. Judge, so you know the plan, we're going to take that 10-minute break, and I hope it won't be 11 or 12 minutes. Senator Klobuchar.
All right. Thank you very much, Mr. Chairman. Thank you, Judge. As I said yesterday, your nomination comes before us during an unprecedented time in our nation's history. In recent months, foundational elements of our democracy have been challenged and questioned and even undermined, and for that reason, I just can't look at your nomination in the comfort of a legal cocoon, and I believe we should evaluate your record and philosophy against the backdrop of the real world today. So starting with something easy with the real world, Senator Grassley and I are leading a bill on cameras in the courtroom. I'm not going to ask you specifically about that bill for federal courts, but a number of your fellow people who were sitting at that table years past, including Justice Sotomayor, has said that they were open to it and were positive about bringing cameras into the Supreme Court. And just to give you a sense of why this is so interesting, only a few people can get in there, yet the decisions affect everyone in America. Even just last month, 1.5 million Americans tuned into CNN's broadcast when the Ninth Circuit heard arguments challenging the president's refugee and travel ban. So what is your opinion on having cameras in the Supreme Court?
Senator, that's a very important question. I appreciate the opportunity to discuss it with you. I come to it with an open mind. It's not a question that I confess I've given a great deal of thought to. I've experienced more cameras in the last few weeks than I have in my whole lifetime, by a long, long way. And I got to admit, the lights in my eyes are a bit blinding sometimes. So I'd have to get used to that.
But would you favor it or not?
Senator, I would treat it like I would any other case or controversy. That's what I could commit to you, that I would want to hear the arguments. I know there are justices on both sides of this issue, right?
Yeah, I think Justice Souter said over his dead body that they have cameras, but I was hoping that things have changed. I was hoping that things have changed since then, and that we see just more and more interest in these decisions, and I hope that you will remain open to it and will favor it. My second question, which also pertains to transparency, is a discussion you had with Senator Whitehouse about the federal rules for federal judges in terms of disclosing trips and things like that, and you had said that you hadn't taken those trips, but if you had, you would have disclosed them, and I appreciate that. Do you think that there should be that same kind of federal ethics standards for Supreme Court justices?
Well, Senator, what I said is I've disclosed every trip that's reportable.
Okay, I'm sorry. Yes.
And,
but the specific question is on Supreme Court justices.
Yeah. I know that the rules are different. I don't know how different they are. I haven't studied that, Senator.
Would you favor them having the same set of rules that apply to you right now?
Senator, what I can say, I'd say two things. First, I have no problem living under the rules I've lived under. I'm quite comfortable with them. And I've had no problem reporting every year to the best of my abilities, everything I can. So I can tell you that. It doesn't bother me what I've had to do. I consider it part of the price of service, and it's a reasonable and fair one. I'd also say I don't know what the arguments are. I haven't studied them. And I'd want to commit to you that I give it very fair consideration. And I'd want to hear what my colleagues have to say.
Okay.
You know,
It's pretty straightforward to me because it applies to the other federal judges. I don't think this is a matter of precedent or what's happened. You are going to be, in the words of Hamilton, if you get confirmed, in the room where it happens. And so all we're trying to do is to make this as transparent as possible of what people's interests are. And so I just hope you'll consider that.
Of course I will.
I think I'll move on to some of the harder stuff here.
I pledge to you I will consider both of those things
Okay,
carefully.
thank you. On the issue of precedent, I think this idea of an independent judiciary is important now more than ever. So I want to start with that. When you accepted the president's nomination, you said, a judge who likes every outcome he reaches is very likely a bad judge. And in your book, you said again that good judges often decide cases in ways antithetical to their own policy preferences when the law so requires. So I want to ask, can you give me an example of a Supreme Court case that you believe was wrongly decided under the law, but that you will continue to follow if you're confirmed because the precedent is so strong?
Senator, I think that's just another way, honestly, of trying to get at which Supreme Court precedents I agree with and I disagree with.
I don't think it is. It's about, it's something that you actually said when the president nominated you, and you said it in public. You said that this is a definition of a judge, that they, someone who, you know, respects precedent so much that they're still going to enforce the law. So I just thought there could be one example, even if it's a really old one.
Well, I think Senator Lee and I were just talking about a couple of cases where the results were not attractive to me as a person, where I followed the law to the best of my abilities, and did so, you know, with my colleagues.
Yeah, one of the reasons I'm asking this is that several past nominees have made this promise about respecting precedent before this committee, and these are people you respect, justices, and admire. At the same time, they said they'd respect precedent, and then they later became justices with a lifetime appointment, and they overturned precedent. One of those examples is Citizens United. Two past nominees who later became justices stated they'd honor precedent during their hearings, and then they joined an opinion that not only broke from precedent, but gutted a law passed by Congress, releasing this unprecedented wave of money. So do you view Citizens United as a departure from prior precedent?
Senator, Citizens United did overrule Austin. So in that respect, it is an example of a court that, in part, overruled a precedent. And that's part of the law of precedent, too, as we've talked about, that you start with a strong presumption in favor of precedent. That's the anchor of the law. It's the starting point. But there are instances when a court may appropriately overrule precedent after considering a lot of factors. And we've talked about them, and I'm happy to discuss them with you again if you'd like. But I don't want to waste your time either, so you tell me.
So you see this as something where there was precedent. That was, I mean, you go back to Buckley v. Vallejo, as you know, parts of that, as you discussed earlier with my colleague, stayed in place, but it overturned parts of that. Austin, McConnell, there was just a number of cases that it overturned. To us up here, it was a major overturning of precedent. And so that's why we're so concerned when people say, oh, we're going to respect precedent, and then they come in and do that. And actually, you've suggested that you would actually go further than Citizens United, and that was in Riddle v. Hickenlooper, a 2014 case. And while it was a narrow case about campaign finance caps on individual contributions to major political candidates, the outcome of the case isn't really one I want to talk about. That was all the judges. I think there was an agreement on the case. But you alone wrote a concurring opinion, and that's what I wanted to focus on, suggesting that making a political contribution was a fundamental right that should be afforded the highest level of constitutional protection which is strict scrutiny. If the Supreme Court adopts the standard that you suggested, the few remaining campaign finance limitations that we have in place and left on the books could fall. So do you believe that strict scrutiny is the appropriate standard for reviewing campaign finance regulations?
Senator, I welcome the opportunity to clarify Riddle versus Hickenlooper. In that case, the law in Colorado allowed individuals to contribute more money to major party candidates than to minor party candidates.
And I really do. I read the case. I understand that. But I just want to, with my limited time, focus on that concurring opinion, because that's what the actual opinion said. But then you took it a step further to talk about this possibility. You cited an opinion by Justice Thomas in your concurrence, joined by Justice Scalia, suggesting that all contribution limits should be subject to strict scrutiny. So could you clarify for us, do you think there's any basis for applying strict scrutiny to contribution limits that apply evenly across the board? Why else would you have cited that opinion?
I'm happy to try and explain again. So the facts of the case, and that's what I was deciding, were uneven contribution limits. It was permissible to give more to major party candidates than to minor party candidates. And the law, as you're, I know, well aware, Senator, under Buckley, says that contribution to candidates is a First Amendment fundamental right. It says that. And I was quoting Buckley, I'm sure, or citing Buckley to that effect. And then the question becomes, what level of scrutiny should we apply to that case? Buckley suggests that it's something less than strict scrutiny in the First Amendment context for contributions. That's the instruction that I, as lower court judge, have in the First Amendment context. But this was an equal protection challenge, okay? Saying it's not just contributions, it's the inequality of contributions that's the problem here. That this system favors major party candidates over minor party candidates. And normally, when we have a fundamental right in equal protection analysis, we apply strict scrutiny. And so I was faced with a situation where, do you take this little out of the First Amendment context and import it into the equal protection context, or do you apply the normal strict scrutiny of the equal protection context? And I pointed to two excellent opinions by wonderful district judges in the area, Judge Boasberg and Judge Feinerman.
Okay, all right. I really did read it. And so
I'm
here's,
almost done.
okay. I know, I understand that.
Okay.
But here's the deal, is that the other judges were happy to just decide it on that narrow basis, right? So then you write the concurrent opinion to bring up this other issue. And I think, again, about Justice White, who is your mentor, was your boss, and there's a law review article from the Dean of Tulane. Time and time again, Justice White avoided broad theoretical basis for a decision when a narrow fact-specific rationale would suffice. And yet you write this concurrence.
May I finish, Senator?
Yeah.
Okay, because I'm almost there.
Oh.
Okay. Good. So I write to point out this conflict in the Supreme Court's directions that I saw.
Okay.
All right? And then I said, in our case, Byron White, it doesn't matter because Colorado couldn't meet even rational basis test. Forget about whether it's strict scrutiny or something close to strict scrutiny. It couldn't meet rational basis test because Colorado couldn't articulate any good reason. Maybe there's one out there. I don't know. But I said, they've articulated nothing.
Okay, but let's continue on now with some other cases because it's a bit of a pattern. Not a concurring opinion, but in the Hobby Lobby case, he found that corporations were legal persons and could exercise their own religious beliefs. And for me, when it comes to campaign finance, this opens up the possibility that you would strike down then this idea that corporations shouldn't be giving money directly to campaigns. Do you think these creatures of statute have the same constitutional rights as living, breathing human beings?
Goodness no, Senator. Hobby Lobby had nothing to do with the First Amendment of the Constitution.
But it was about corporations.
It was, under RFRA.
So you don't think then, maybe we can end this line here, so you don't think that they would have these rights, a corporation would have these rights under the First Amendment?
I don't think Hobby Lobby speaks to the question of the First Amendment at all. What it speaks to is the question of the Religious Freedom Restoration Act, and what a person is defined under that statute by reference to the Dictionary Act, which is Congress's direction to us when we're dealing with statutes what words we're supposed to use and what definitions are. And Senator, if in RFRA, again, if this body wishes to say only natural persons enjoy RFRA rights, that's fine, and I will abide that direction. I'm not here to make policy. I'm here to follow it.
Okay, on to another policy that's pretty important. That's the Chevron case. And in your Gutierrez concurrence, and this is where you wrote the actual opinion and then wrote your own concurring opinion, which I noted is better than writing a dissent to your own opinion. But you wrote a concurrence to your opinion. And to me, this move, if, as you imply in your concurrence, or you don't even imply, you say, it could have titanic real-world implications when it comes to our rules. 13,500 cases on the books since 1984. In your book, you say you don't overturn precedent unless it is universally accepted, affirmed by courts repeatedly, and people have extensive reliance on the decision. So my question is, why in your concurring, and Senator Feinstein asked you about the facts of the case. I do not want to talk about that because she already did, and I got your answer. That was good. But in the concurring opinion, you say there's an elephant in the room with us today. Sorry, guys, he wasn't referring to the Republican Party. There is an elephant in the room with us today. We have studiously attempted to work our way around it and even left it unremarked. But the fact is, Chevron and Brand X permit executive bureaucracies to swallow huge amounts of core judicial and legislative power and concentrate federal power in a way that seems more than a little difficult to square with the Constitution of the framers' design. Quote, maybe the time has come to face the behemoth, end quote. That sounds to me like, again, you are going a step further and talking about overturning a major precedent. I want to know if that's what you mean, if you think it should be overturned, and if you've considered the ramifications of that when Justice Scalia himself was the original champion of the Chevron doctrine.
Senator, all I can do is explain to you why I was concerned about Chevron in that case. And I was concerned because, again, we had an undocumented immigrant who was following judicial precedent.
I really do understand the facts, but I want to know why you did a concurring opinion to your own opinion in order to make this broader sweep and talk about, you said the time has come to face the behemoth. You were clearly talking about overturning Chevron.
Senator, I'm trying to answer your question as best I can. And I was concerned about the due process implications that arise in cases like Mr. Gutierrez, where an individual who isn't aided by an army of lawyers or lobbyists, can they anticipate changes in law by agencies back and forth willy-nilly, even to the point of overruling judicial precedent? And that's a due process concern I raised. I raised an equal protection concern about the ease with which individuals like Mr. Gutierrez can be singled out by political branch in a way that judges are supposed to protect. I raised a separation of powers concern about whether judges should be the ones saying what the law is.
But as a Supreme Court justice, if you were to make this decision to overturn Chevron, would you consider the implications on all of the cases in the U.S. and the rules and the uncertainty that it would create?
Goodness, Senator, yes.
And would you overturn it? Is that what what this means when you talk about maybe it's time to face the behemoth?
Senator, my job as a circuit judge is when I see a problem, I tell my bosses about it, like any good employee. And my job there, as I conceived it, was to say, hey, listen, look at some of the implications, the real-world implications of what we're doing here.
Okay, but you would be the boss if you were the Supreme Court justice. And what rule do you think should replace it? Should we have de novo review? Is that better? What do you think should replace Chevron deference?
Senator, I don't prejudge it. I can tell you what did pre-exist it was Skidmore deference, which was written, an opinion written by Justice Jackson, actually. That's what pre-existed. So there was deference before. And we had the administrative state for 50 years. And agencies would issue rules and decisions. I don't know what all the consequences would be, and I would pledge to you, I wasn't thinking about being a Supreme Court justice then. I was identifying an issue for my bosses. If I'm so fortunate as to become a justice, I would try and come at it with as open a mind as a man can muster. And I would tell you, I remind you, what I bear in mind, it'd be David Sentel. When I was with him as a law clerk, issued a panel opinion at the beginning of my year with him, going one way, and then by the end of the year, wrote for the en banc court, the full court, reversing himself. Now, some people think that doesn't show a lack of sufficient steel. I think that shows an open mind and a lack of ego that a judge should bring to bear when he or she puts on the robe, and that's what I would commit to you.
Okay, let's go to another piece of this philosophy, and that's originalism. And in other words, whether words and phrases in the Constitution should be interpreted according to their original public meaning or how the founders and their contemporaries would have understood them. Regardless of whether you characterize yourself as an originalist, you've applied originalism in several decisions, including last year in Cordova v. City of Albuquerque, where in a separate concurring opinion you described the Constitution as a, quote, carefully crafted text judges are charged with applying according to its original public meaning, which are the buzzwords for originalism. Criticisms of the principles underlying originalism are not new. In fact, I believe some lines from Chief Justice John Marshall's opinion in McCulloch v. Maryland in 1819, almost 2 centuries ago, are still relevant to our discussion of the point today. He wrote that the founders must have intended our Constitution to endure for ages to come, and consequently to be adapted to the various crises of human affairs. He continued, to have prescribed the means by which government should in all future time execute its powers would have been to change entirely the character of the instrument and give it the properties of a legal code. It would have been an unwise attempt to provide by immutable rules for exigencies which, if foreseen at all, must have been seen dimly and which can be best provided for as they occur. He added, if we apply this principle of construction to any of the powers of the government, we shall find it so pernicious in its operation that we shall be compelled to discard it. Do you agree with the point that Justice Marshall made in McCulloch?
Well, Senator, I would certainly agree that the Constitution must endure and that it's a lot bigger than any of us. And it will live in that sense, hopefully, a very great deal longer than any of us, our children's children. I do think it's important to try and understand law according to its original understanding, public meaning. Words have meaning.
So you don't agree with McCulloch about adapting to the crisis of human affairs?
No, Senator.
So you do agree?
I'm trying to answer the
I just want a yes or no, that's all.
Well, I think it takes, these are complicated things that take more than a yes or no, respectfully. And what I would say is the Constitution doesn't change. The world around us changes. And we have to understand the Constitution and apply it in light of our current circumstances. That's what we're trying to do as judges. So, for example, one of my favorite cases in this area is Jones, right? Supreme Court of the United States is faced with a GPS tracking device attached by the police onto a car. Is that a search? And the court goes back and looks at the time of the founding what qualified as a search and found that that would have qualified as a trespass to chattels and a search by the government. And says if that would have been offensive 200 years ago, that sort of thing, it has to be offensive now. The Constitution is no less protective of the people's liberties now than it was 200 years ago.
So when the Constitution refers like 30-some times to his or he when describing the President of the United States, you would see that as, well, back then they actually thought a woman could be president even though women couldn't vote?
Senator, I'm not looking to take us back to quill pens and horses and buggies.
But just if you could answer that question, it's pretty important to me.
I'm trying to.
Okay.
Of course women can be president of the United States.
Okay.
I'm the father of 2 daughters.
Great.
And I hope one of
Okay.
them turns out to be president of the
Okay,
United
that's
States.
wonderful. How about like the Air Force? I agree with you, that's good. So in that case, you say, well, we can't take it at its literal words. So then the Constitution also says Congress has authority to oversee the land and naval forces, but there's no mention of the Air Force. And I assume you believe that would also include the Air Force because if they knew an Air Force existed, they would have included the Air Force back then?
Senator, I think the generals of the Air Force can rest easy.
Okay, great.
Let me give you
How
another-
about Virginia? Let's keep going here because I'm almost out of time here. In United States v. Virginia, the court held that the Virginia Military Institute violated the Equal Protection Clause of the 14th Amendment by excluding all women from VMI's military training. In his dissent, Justice Scalia stuck to his signature originalism and criticized the majority, saying the decision is not the interpretation of a constitution, but the creation of one. Is the interpretation of the Equal Protection Clause in U.S. v. Virginia consistent with the original public meeting?
And the majority in that case argued that it was.
Okay.
And the majority said that the words equal protection of the laws, whatever the secret harbored intentions of the writers, had an original public meaning that's quite radical and significant. And that was what the majority of the Supreme Court of the United States held.
So would you agree then that when you look at other things, would you be willing to apply this same approach to equal rights for minority groups, women, LGBT, including transgender people, racial minorities, the same approach you use when we argue, when you just made the statement about the he and his in the Constitution, about the not having the Air Force, about the Virginia military decision?
Senator, a good judge applies the law without respect to persons. That's part of my judicial oath.
So do you see it as your textualism, the original public meaning then, would you apply it to these other contexts as well that I just mentioned?
And Senator, what I'm trying to say to you is I don't take account of the person before me. Mm-hmm. Everyone is equal in the eyes of the law.
Okay, I'm just trying to figure out this, because I think for some things, a lot of people who subscribe to this theory, they say it, well, we can have originalism for some cases, but not for others. And I call it selective originalism. And it just seems to me when you look at some of the opinions that use originalism that you have and some don't.
Well, Senator,
but I have one.
Senator, if I might just respond to that. I'd ask you to take a look at Jones again. Kylo, search of a home using a heat-seeking device. I'd ask you to maybe take a look at Crawford, the right to confront witnesses. Maybe as well the Apprendi and Booker line written by Justice Stevens, a very originalist opinion about the right of an accused to be able to have all of the elements of an offense that increases his sentence tried by a jury of his peers. Those are all what one might characterize as originalist opinions protecting individual liberties.
You know what? We could do it on the second round. That'll be good. Just some minor things here at the end. When the Supreme Court temporarily blocks a lower court ruling, they need 5 votes. A practice known as the courtesy fifth has developed, in which a fifth justice will provide the vote needed to stay the lower court ruling, even if that justice might not have otherwise been inclined to do so. Do you think the practice of the courtesy fifth is a good thing?
Senator, I haven't studied that. It'd be presumptuous of me to offer an opinion in a court that I haven't sat upon.
Okay. Well, it may be very relevant when this refugee case comes up, so you might want to I'm going to end here with, I'm going to do a lot of work on antitrust in the next round. I know you're an expert. Senator Lee and I have been heading up that subcommittee for a long time, but I'm going to end with freedom of press in honor of my dad. He was a newspaper reporter his whole life, and I'm especially concerned in today's world where we're seeing these attacks on the media about maintaining the press's role as a watchdog. Our founders enshrined freedom of the press in the First Amendment. As Thomas Jefferson said, our first objective should be to leave open all avenues to truth, and the most effective way to do that is through the freedom of the press. In New York Times v. Sullivan, the court issued a landmark ruling in support of First Amendment protections for the press by affirming that when newspapers report on public officials, they can say what they want. Maybe we don't always like that, but they can, unless they say something untrue with actual malice. Do you believe, under New York Times v. Sullivan, that the First Amendment would permit public officials to sue the media under any standard less demanding than actual malice? And can you explain to the people here today and those watching on TV what that standard means to you?
New York Times versus Sullivan was, as you say, a landmark decision. And it changed pretty dramatically the law of defamation and libel in this country. rather than the common law of defamation and libel, applicable normally for a long time. The Supreme Court said the First Amendment has special meaning and protection when we're talking about the media, the press, in covering public officials, public actions, and indicated that a higher standard of proof was required in any defamation or libel claim. Proof of actual malice is required to state a claim. That's been the law of the land for, gosh, 50, 60 years. I could point you to a case in which I've applied it, and I think might give you what you're looking for, Senator, in terms of comfort about how I apply it. Bustos versus A&E Network. It involved a prisoner who was concerned that he had been misrepresented as a member of the Aryan Brotherhood. Claimed he wasn't a member, just a fellow traveler, and sought damages for that. Our court declined to grant that relief, saying that substantial truth is protected, even if it's not strictly true, and much more is required by the First Amendment in order to state a claim.
Okay, in Brandsburg v. Hayes, Supreme Court case, they didn't recognize the reporter's privilege, at least in the context of criminal grand jury testimony. Could you just end here by talking about the scope of the Brandsburg decision and whether there are instances where a court should recognize a reporter's privilege?
Senator, I know those cases come up from time to time, so I have to be very careful. But your description of the case is entirely accurate.
Thank you very much.
Thank you.
Okay, before we recess, I'd like to enter into the record a commentary in the Chicago Tribune called Crying Wolf over Neil Gorsuch, written by Dennis Hutchison, a lifelong registered Democrat. He specifically talks about concerns over Chevron deference. He writes, quote, "There are two sides to deference, however. My guess is that pro-Chevron advocates will soon be begging federal courts not to defer to interpretive findings of agencies," end of quote. Enter that in the record without objection. We will recess for 10 minutes, so that means we'll reconvene at 3:31.
On your screen is Mazie Hirono, senator from Hawaii, and if they go in order, she'll be the last of the Democrats to ask questions today on day number 2 of the confirmation hearing for Judge Neil Gorsuch for the Supreme Court. They're halfway through the 20 senators on the committee. There are 11 Republicans and 9 Democrats, so 6 Republicans yet to go, yet to ask questions. Next up should be Senator Ted Cruz of Texas, then Ben Sasse of Nebraska, Jeff Flake of Arizona, Mike Crapo of Idaho, Tom Tillis of North Carolina, and the last Republican would be John Kennedy of Louisiana. Still on the Democratic side, Senator Al Franken from Minnesota, Chris Coons from Delaware, Richard Blumenthal from Connecticut, and as we mentioned, Mazie Hirono from Hawaii. Senator Grassley, the chairman of the committee, saying they're taking another tight 10-minute break here, and should be back about, he said, 3:31. Our live coverage will continue as well. Lots of focus across Capitol Hill on this 4 days of hearings for Judge Gorsuch. The minority leader in the Senate, Chuck Schumer, said today that the judge is playing, quote, dodgeball with the Senate Judiciary Committee. And that there's no legally justifiable rationale for not answering questions. Here's what he had to say.
As you all know, Judge Gorsuch's hearing is still going on, so we'll have more to say on that later. But I want to say one thing based on what we've seen so far. Judge Gorsuch looks like he's playing dodgeball with the Senate Judiciary Committee.